Thank you. Right. GM receipt is sir. ಯಾರಿಗೆ ಬರ್ಸ ಇದು ಯಾಕೆ ಕೊಟ್ಟಿದ್ದು GM ಬಸ್ ಪಕ್ಕದಿರ್ಬೇಕು ಹೇಮಂತ್ ಚಂದನ್ ಗೌಡ್ರು ಇರಬೇಕು ಪಕ್ಕದಿರ್ಬೇಕು
Orders one first is to order second over. Hearing first is hearing hearing on again one go. Orders to hearing on again. Yeah. ಯಾಕಂದ್ರೆ ಪಕ್ಕದಿಂದ 2 ಕೋಟಲಲ್ಲಿ ಇದೆ ಅದಕ್ಕೆ ಜಸ್ಟ್ ಇದು ಬರ್ತೀನಿ ತೊಳಿ ನಾನು ನೋಡ್ಕೊಂಡು ಬರ್ತೀನಿ.
ಈಗ ಇನ್ನೊಂದು ತಿಂಗಳಿಗೆ ರಿಟೈರ್ಡ್ ಆಗ್ಬಿಡ್ತಾನೆ ಬಿ ಗ್ರೂಪಿಗೆ ಬಂದು ಯಾಕಂದ್ರೆ ಇನ್ಫೆಕ್ಚರ್ಸ್ ಆಗ್ಬಿಡ್ತಾನೆ ಅವನಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯಲ್ಲಿ ಗೊತ್ತಾಯ್ತು ಅದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಲಾ ವಾಟ್ ಎವರ್ ಸ್ಕ್ರೂಟಿನಿ ಅಂತ ಬರಿಬೇಕು ಅದೇನಾಗಿದ್ದು ಗೊತ್ತಾ ಸರ್ ಜಿಲ್ಲಾ ಬರಿಬೇಕಪ್ಪ ಇಲ್ದಿರಿ ಎಲ್ಲಿಗೆ ಅಂತ ಕಳಿಸ್ಕೊಡ್ತೀನಿ ಬಿ ಗ್ರೂಪ್ ಏನು ಅಂತಂದ್ರೆ ಇನ್ನೊಂದು ತಿಂಗಳಿಗೆ ರಿಟೈರ್ಡ್ ಆಗ್ಬಿಡ್ತಾರೆ ಇನ್ಫೆಕ್ಚರ್ಸ್ ಆಗ್ಬಿಡ್ತಾರೆ ನೋಟಿಸ್ ಆಗಿ ಅವ್ರಿಗೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು 4-5 ಸಲ ಬಂದಿತ್ತು ಕೋರ್ಟ್ ಮುಂದೆ 1-2-3 ಸಲ ರೀಚ್ ಆಗಲಿಲ್ಲ ಬಿ ಗ್ರೂಪಲ್ಲಿ ಬಂತು ಆಮೇಲೆ ರೀಚ್ ಆಗಲಿಲ್ಲ ಆಮೇಲೆ ಅವ್ರು ಟೈಮ್ ತಗೊಂಡ್ರು ಕೆಲಸ ಕೊಟ್ಟವ್ರೆ ಕೆಲಸ ಕೊಟ್ಬಿಟ್ಟು ಅಲ್ಲ ಆಗಿದೆ ಏನು ಹಾಕೈತೆ ಅಯ್ಯೋ ಏನಕ್ಕೆ ಹಾಕಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕ್ಬೇಕಾ ಇಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡ್ಲಾ ಮೆನ್ಷನ್ ಮಾಡೋದೇ ಒಳ್ಳೇದು ಆಯ್ತು
Sir.
ಕಮಿಷನ್ ಮಾಡ್ಬೇಕಾ ಅಯ್ಯ ಡಿಸ್ಪೋಸಲ್ ಅಯ್ಯಗೆ ಅಯ್ಯ ಆನ್ ಡಿಸ್ಪೋಸಲ್ 2016 ಅಯ್ಯ
No, good. One matter I have filed a year for production of document. I could.
Fresh matter.
All fresh matters, please hand it over.
Matter at 2:30 minutes. The urgency is minutes, I am a transferor company.
You're right?
I am a transferor company, employees of transferor company. Minutes, transfer, minutes, after amalgamation, there was a dispute. This, we approached this honorable court, minutes. There is a HR integration process and everything was given to me. Repetition was
Let
allowed
it come tomorrow.
tomorrow.
Tomorrow is Saturday, working day.
Oh, please.
One matter for B group, my lord, the urgency is, my lord, petitioner was working as a bill collector, my lord. The petitioner challenged
ಇದು
2000, he is going to retire by within 1 month.
ಇಸ್ವಿದು ಒಂದೇ
23 ಇದು
23. ಹಾ
ಏನಾಯ್ತು, ಅಲೋ ಆಯ್ತು ರಿಟ್ ಪಿಟಿಷನ್. ಆಮೇಲೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅಪೀಲ್ ಹಾಕಿದ್ದು, ಅಪೀಲ್ ಅಲೋ ಆದ್ಮೇಲೆ ದಿ ಪಂಚಾಯತ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ದಿ ರೆಸಲ್ಯೂಷನ್ ರೆಫ್ಯೂಸಿಂಗ್ ಟು ಟೇಕ್ ಹಿಮ್ ಟು ಡ್ಯೂಟಿ, my lord, ಡಿಸ್ಪೈಟ್ ದಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಆರ್ಡರ್. therefore, my lord, I appoint
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಯಾವತ್ತು ಬೇಕು?
tomorrow.
ಆಯ್ತು.
Adjournments page wise, list number 1, page number 6, serial number 19 to 24. Page number 7, serial number 25 to 31.
Lords, seal number 27, my lords. Lords, I appear for the respondent, my lords. My lords, arguing counsel as an eye infection. My lords, may I kindly grant 2 weeks' time.
Sir, with great difficulty, these matters get listed.
Lords,
And
that's
this
an eye
is a
infection.
2015 matter. I don't know how you are justified in asking for an adjournment.
Lords, a short date may be granted, my lords.
The short date is today. If it is adjourned, then it will go to some other date.
Lords, short date may be granted, my lords. Eye infection, my lords, is not.
Vittal Shetty.
Yes, my
He
lords.
was
No,
here.
I am for the respondent, my lords.
Learn counsel for the respondent seeks time. List on.
9th September,
Please, my lords.
page number 8, serial number 32 to 36,
30.
32 to 36.
Ah.
Page number 9, serial number 37 to 42. Page number 10, serial number 43 to 46. List number 2, page number 3, serial number 3 to 8. Page number 4, serial number 9. Page number 5, serial number 10 to 16. Page number 6, serial number 17 to 19. List number 1, for non-compliance office objection, first time, serial number 1. Ravindranath K.
Lord, in this case, office objection, Lord, if you hardship permits, all. So,
ಎಲ್ಲ
you're a
ಕೇಸಲ್ಲಿ ಹಿಂಗೆ ಮಾಡ್ತಾರೆ ರವೀಂದ್ರ.
ಸ್ವಾಮಿ.
ಯಾವ್ದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ, ಆರ್ಡರ್ ತಗೊಂಡೋಗ್ಬಿಡ್ತೀವಿ.
No, 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 Lord, everything is.
Court
other-
fee of rupees 500 to
that
be
is
paid.
paid, Lord, already paid.
Date of events to be in chronological order. Copy to be served to best.
That is served, that is served.
Issuing authority of annexure E and E3 to be made as party to this petition.
Lord, that is not required, my Lord, because already they are down here, because instead of Haryana, we have made it down here.
Whatever, please
No, down
come.
here, that is complaint, that is.
Bearing number from annexure E3 to be corrected at prayer and interim prayer. Proceedings copy.
Lord, this will not come in, because this objections, Lord, cannot, because they asking for, Lord, with different.
Complain ಮಾಡಿ ಅದ್ ಏನ್
This is,
ಬರ್ಕೊಡ್ಬೇಕು
this will not come. Lord.
Huh?
This objections.
I'll call it tomorrow. You comply with all the office of Barkod. Learn counsel for the petition undertakes to comply the office objections. List tomorrow if office objections are complied.
Lord, that way, Lord, all of its objection, because one, the eligible copy is also with the.
ಅದ್ ಏನೇನೋ
No,
ಇದು
no,
ನೋಡಿ.
if that will comply, my Lord. If your lordships order that way, my Lord, comply, my Lord, then post, then it will be difficult.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡೋದು, ಇಲ್ಲ ಮಾಡೋದಿಲ್ಲ.
No, my Lord, that objections, my Lord, maybe or
ಯಾವ್ದು?
annexure G. My Lord, this office objection, because first office objection, amount has been paid, my Lord. Fees has been
Visible
paid.
copy of annexure G, page 206. ಕೊಡಿ ಅದೇನು.
Page 206, my Lord.
ಸೇಮ್ ಲೈನ್ ಮನ್ ಕೇಸ್ ಏನ ಇದು?
Please, my Lord.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
Lord, almost 134 who are undergone, my Lord, the inquiry.
Office objection regarding production of the legible copy of annexure G is
Lord,
dispensed.
court fees paid and,
Office objections, all other office objections shall be complied. List this petition,
Lord, except,
Or-
sorry, my Lord. Except that 6-1.
this petition tomorrow if other office objections are.
That sixth office objection will not come in the frame, Lord. Sixth objection, because they asked some different, which is not even
Proceeding
relevant.
copy as per interim order for annexure E to E4 to be furnished.
Lord, that sixth one, Lord, proceedings copy as per them, Lord, that proceedings will never, because that already paid, means produce along with them, Lord, the impugned order.
ಆಯ್ತು, ಅದ್ ಏನಿದೆ ನೀವು ಬರ್ಕೊಡಿ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಬರ್ಕೊಡಿ.
Please.
Number 2, PC Sunita.
Weeks time.
1 week time is granted to do the needful.
For withdrawal, serial number 3, Mohan Prasad.
A memo is filed, withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn.
For orders matter, serial number 4, K. Srinivas.
And for the respondent, my lordship.
Yeah, 2013. What is this petition about?
I am for the
Yes.
respondent 2, 1 and 2, my lordship.
Ah.
Basura.
K. Srinivas. And some office objections are,
My lordship, I deliver the subjection statement to them, my lordship.
the learned
But
counsel
still
for
it
the
is being
respondents.
reflected.
Learned counsel.
I
for
will
the-
compile it, my lordship,
learned
within 1
counsel-
or 2 days.
I3. Dictation ಕೊಡುವಾಗ ಮಧ್ಯದಲ್ಲಿ ಹೇಳ್ಬೇಡಿ, please. Learned counsel for the response 1 and 2 submits that he has furnished a copy of the statement of objections to the learned counsel for the petitioner. The learned counsel for the petitioner is absent. Since the petition is filed in the year 2013 and admitted in the year 2013, list for final hearing on ಯಾವತ್ ಮಾಡ್ತೀರಿ?
Next week na kodi, madam.
Date
Next week,
ತಗೊಳ್ಳಿ.
my lordship. I am ready.
Please pick a date of your choice.
My lordship, 4th or 5th, my lordship.
List on 4th. The court is dictating ಮಧ್ಯ ನೀವು ಪಿಟಿ ಅನ್ಬೇಡಿ.
Pardon, my lordship.
Serial number 5, V. Tukaram Rao.
I appear for respondent number 1 in this matter, my lords.
Rectification of office objections raised on IA 1 of 24 and rejoinder filed by Mr. Vasant Kumar. AM. He has not filed wakalat on behalf of petitioner. Who is this? V. Tukaram Rao.
My lords, I appear for R1. I have not been served with a copy of the IA or the rejoinder.
There is no representation for the petitioner. The learned counsel for the respondent number 1 submits that copy of the application in IA 1 of 24 is not served. Full stop. As a last chance, list on so and so. In the meanwhile, copy of the application in IA 1 of 24 shall be served to the counsel for the respondent number 1. Failing which, the application in IA 1 of 24 shall stand rejected. Yes.
10 September. Serial number 6,
Obliged.
Lokesh
List
K.
on 10. K. Lokesh.
I appear for the respondent number 2, my lords. I am furnishing in compliance of the order.
Mr.
I'm-
Sirish Krishna.
Shirish Krishna, my lords.
Mr. Sirish Krishna has filed a memo. Enclosing therewith a list of candidates selected for the post of junior engineer electrical in compliance with the order dated 22/8/2024. Will this?
I'll file my necessary application for impleading these candidates, my lord. Short date may be given.
The learned counsel for the petitioner seeks time to implead the selected candidates in this writ petition. List after the same is done.
Great.
Serial number 7, Nayak NR.
For the respondent 3 and 4, my lord. Last occasion, your lordship had directed us to file the recruitment notification. Lord, your petitioners are working under the concerned manpower agency or contractors, my lord. They are not the regular, or they're not working in the
Mr. NR
KPTs.
Naik. Mr. NR Naik.
Please, my lord. The one order has been passed, my lord, by this honorable court, providing, my lord, by monetary benefits, my lord, to them, those who are working from outsource agency. So my humble request, my lord,
From-
more than 14 years he has served, first petitioner. First petitioner served more than 14 years, my lord. Now he sought for regularization.
No, that is right. If you're outsourced, if your services are procured from outsourced agencies.
Outsource agency, my lord, the whatever amount paid to him by the government, by the board itself, my lord. How the agency they are going to pay money to us? My lord, because the money, whatever disbursement made from the board and work extracted by the board.
No, where is your appointment order?
Appointment order, my lord, because they have permitted to us extracted work, my lord, as a
That is
junior
okay.
engineer.
How
my
did you
lord.
come into the respondents? How were your services availed by the respondents?
The committee has been formed and committee, the managing director himself is a party to the committee, my lord. He has to regularize to us, my lord.
Sir, I'm asking a simple question.
Please, my
How
lord.
were your services availed by the respondent? Was there any notification? Was there any interview?
By way of deputation, my lord.
Deputation?
In a clear vacant post, my lord, by the executive engineer.
No, you're not answering the question.
Please, my lord.
Was it through an outsourced agency?
Yes, my lord. Yes,
How-
definitely.
Where do we get that?
Yes, my lord, that is the that is the government I have made, my lord.
Really, where do we get it?
Yes, yes.
Got it. Your lordship permits me, my lord. We issued a tender notification for maintenance of the substation.
Hmm.
Now, the contractor, he's been arrayed as the respondent number 5. RK Electricals, my lord. The contractor has participated and he was the successful tenderer.
Who RK Electrical?
RK Electricals, respondent number 5. Under him, my lord, the present petitioners were working.
See, the way these substations are maintained,
Please,
it's a matter of common knowledge
please,
that these employees who work in the substations, they will be continued by these contractors.
please.
Somebody would have engaged them for the first time. Our contract to change adange, these people will be engaged by those contractors.
Please. And they were working as shift engineers, my lord, in the substation. There is no such post in KPTCL itself. Now they're telling they have to be regularized as junior engineers. For junior engineers, my lord, we issue a recruitment notification. Qualification is prescribed. In terms of that recruitment notification, my lord, candidates have participated, they are
To at least
selected.
you give them some weightage. They've been working for 14 years. Come up with some scheme.
No, that is why, in fact, the state government, my lord, a committee is constituted.
Hmm.
Lord, but the committee report is yet to be submitted or finalized, my lord. And even the decision which the learned senior is relying upon, my lord, that is not
There are
up,
so many substations in the entire state
please.
where contractors have been given the contract to maintain these substations. And all these substations are maintained by all these people who are on contract basis. Now, why don't you take a policy decision to recruit people to these substations after all the contracts have come to an end, giving them some weightage?
I take instructions, my lord. Statement is
So
not.
this is a perpetual problem. Prati varshana bartane irthidu. Whenever a contractor changes, these people run to the court and obtain an interim order and continue. And they seek for regularization. Otherwise, come up with some scheme.
Lord, I'll file my statement in this.
The learned counsel for the respondent seeks time to file a statement of objections. It's the petition after the statement of objections is filed.
Obliged.
Serial number 8.
Lord, your lordship has overruled all the objections, my lord, and
Huh?
granted your lordship has overruled the objections and granted the interim order stay. Lord, again, Lord, office objections says,
Stay ತಕೊಂಡ್ ಮೇಲೆ complaint ಮಾಡಕ್ಕೆ.
no, Lord, your lordship has overruled.
Para numbers to be stated correctly at verifying affidavit.
Yeah.
Annexure to be stated at prayer 3.
Lord, maybe it is subsequent after, my lord, you're passing the order.
Some order is passed in your favor.
No, this office objection has raised subsequently, maybe after passing the
Sorry.
order.
Complaint ಮಾಡಕ್ಕೆ ಏನ್ ರವೀಂದ್ರನಾಥ್? ಎರಡು ಚುಕ್ಕಿ ಆಡಕ್ಕೆ ಏನ್
That,
problem?
subsequent, because it is not aware, subsequently it has been raised. I will complain. Today it is only posted. Interim order has
Got an order of stay.
maybe extended.
Complaint ಮಾಡಿ.
My lords, in this case, my
1 week
lords,
time is granted to do the.
the Sumana Nagaran will enter appearance for respondent number 2 to 5. We will file Vakala today for Vescom,
My name
For 2 to 5.
2 to 5.
Srimati Sumana Naganand undertakes to appear for respondents 2 to 5. Office is directed to delete the name of Mr. B.L. Sanjeev and show the name of Srimati Sumana Naganand as a counsel for response 2 to 5.
My lords,
1 week time is granted to file objections.
My
1
lords, if I
week,
may
2
make-
weeks,
my lords, I require 2 weeks at least.
2 weeks time is granted.
If I
to
may
file.
make a request, my lords, similar matter at 43 and 44, there's a batch of matters.
List this,
Maybe
list this
requested
petition along with double P
43,
number
44.
43, 44, 45, interim order maybe.
43,
44,
44 and
45.
45.
all the three, my lord, Mr.
Yeah, if we
All these relate to
accept
that
notice,
lineman case.
please, my lord, we
The
accept
lineman
notice,
case, na?
Yes, same.
Uh,
the
yes.
fake marks card.
Lord,
We'll accept notice for the BESCOM in all these cases and it may be tackled.
And I think 43, 44, you already accepted notice.
My
No,
name
BL
has been-
Sanjeev is your
my
lord
name
has
has been
directed to
shown, my lord.
accept the notice from the BL Sanjeev.
Take notice in
We'll
all
take
those
notice
cases.
for all.
ಎಲ್ಲ ಕೇಸಸ್ ಹಂಗೆ ಮಾಡಿ.
Not interim order in all.
43, 44 and 45 ಅಲ್ಲಿ ಸುಮನಾ ನಾಗಾನಂದ. Interim order granted as extended to the.
There is other cases as well, my lord. I'll hand over the numbers,
Please hand over.
connected cases.
ಕೊಟ್ಬಿಡಿ. Well, ಅದೊಂದು ಲಿಸ್ಟ್ ಆದ 43, 44, 45 and all those cases. Yes, next.
Lord, sorry to interrupt. Serial number 18, please. In the serial number 18.
The interim order extended.
Oblige.
Serial number 9, Prithvish MK.
Prithvish,
First things first, I'm grateful, my lord, your
on
lordship.
service of writ petition copy to advocate.
They have served, my lord. They have served through email, I have served through WhatsApp. Acknowledgement, he has acknowledged the receipt of the email also.
Basuraj R.Y. Please, why don't you produce the copy of the email?
Very well, I'll come back to your
Copy
lordship.
ಕೊಡಿ.
Yes, I'll come back to your lordship.
Tomorrow,
My lord, I'll come back to you. Transfer, I'll come back to your lordship.
password.
Great.
Hearing tonight, serial number 10, VB Shivkumar.
I appeal for petitioners, my lords, kindly pass over. I appear for the respondent, please, your lordship. The matter was taken up before the Supreme Court where the status quo order has been ordered
Not yet.
till the settlement.
But the learned counsel.
1510 is it?
Learned counsel for the respondent has submits that she has challenged the order passed by this court on. She has challenged the order passed by this court before the Honorable Supreme Court in SLP Appeal 18321-322 of 24. And that the Honorable Supreme Court has passed an order of status quo. We'll stop in that view of the matter. IA 1 of 24 shall be considered only after disposal of SLP. Referred above, list this application for consideration after disposal of SLP number songs. Yes.
Serial number 11. SB Mukanappa.
Sir, application filed by me, the petitioner, my lord, the.
My lords, appearing for the respondent, my lords.
Yeah, LRs.
Last my lord, his wife and children's.
Notice ಹೋಗಿದ್ಯಾ?
My
His
lord,
notice issue.
I am the petitioner, my lord is died.
Petitioner, okay.
Yes,
IA 1 of 24 is filed by the applicants who are the legal heirs of the deceased petitioner. Since the cause of action has survived the death of the petitioner, the applicants are entitled to come on record and pursue this petition. Consequently, IA 1 of 24 is allowed and the applicants are permitted to come on record. Counsel for the petitioner is directed to amend the cause title. List for final hearing.
yes, ma'am.
Final hearing, my lords.
List for final hearing as per seniority. Date
Much
for-
obliged, my lords.
Any day.
What date? When do you want it to be listed?
We are ready, my lord, the next month or any date. my lord.
List on date,
5th September.
5th September as per seniority.
Serial number 12.
Much obliged, my lords.
IA 1 of 24.
The respondent, your
Well,
lordship.
this IA for early hearing.
All these retired employees.
Senior is out of station, your lordships. There is some personal inconvenience. Kindly have it.
The
after
tiredness allowances have not been paid on par with the state government pattern. So that is only the 23rd
IA
time,
one-
my lord, this has been posted before the court.
Filed for early hearing. So petition is filed in the year 2018. But is not admitted, IA 1 of 24 is rejected. List a petition for preliminary hearing in B group on date.
After a week, your lordship.
18th September.
19 September.
Grateful, your lordship.
Serial number 13, Ramanand Reddy.
Ramanand Edi. MC
Lordship in the,
Nagasri.
last occasion, the
Respondent.
respondent has misguided this court while arising, because in fact, the facts, both the execution petition and contempt petition are the part of pleadings in the writ petition. And for nearly 20 years, the petitioner is deprived. Now, 2 IAs have been filed, and there before the execution court, they have filed the application seeking to stay the execution proceedings and avoided the NBW warrant, which is, I have filed an affidavit along with the petitioner affidavit.
Execution petition
is
stay has been
pending.
granted due to pendency of this writ petition. my lord.
Wait, execution is pending.
Execution is only for the part of the amount to be claimed. The rest of the other relief are in this writ petition, where the, instead of petitioner, the respondent 4 to 6 have been appointed. And though there is an order to reinitiate the petitioner from 2002, she has not been reinitiated.
So what do you?
And now she has reached the age of superannuation. I filed application to seek the amendment of prayer, because reinitiation will not come because I have reached the age of superannuation, and 60 lakhs of arrears of salary are to be paid. For 16 years, 18 years, the respondent has avoided the arrest warrant and execution proceedings to pay the balance.
Please wait. You're trying to enforce the order passed at Annexure A.
Your Lordship, there are 2 other reliefs sought by me to reinitiate. Now, the question of reinitiate, the respondent number 1 and 2 and 4 to 6 are not parties before the execution
Let
court.
us read your prayer.
Yes, Your Lord. A part of the prayer, issue a writ of mandamus or any other writ to direct the respondent number 1 and 2 to reinitiate the petitioner into service in the 3rd respondent educational institution by replacing respondent number 4 to 6 or any other.
So now you attain the age of superannuation. So there's no question of reinstatement.
Yes, that is the reason I filed an amendment
Go
application.
to the next prayer.
Next page, issue a writ of mandamus directing the 3rd respondent to pay the arrears of salary of 60 lakhs in compliance with the order passed by the learned 6th additional city civil judge in EAT 27 of 2003, dated 11/11/2005.
EAT, the order passed in EAT, you filed an execution.
It was filed by me even before the writ petition, writ appeal, contempt petition were initiated. There was the 3rd respondent obtained a stay order in the execution petition initiated in 2006. The respondent number 3 came into appearance in the execution petition after this court issued notice and the media covered the injustice done to the petitioner. Till then, the 3rd respondent is avoiding the execution proceedings, and though she is fighting the litigation from 1996. That is the reason I'm before this honorable court. And your lordship had directed 2 remedies, either to take the relief in EAT or before this court. I choose this court for the reason.
You withdraw that execution then. You withdraw the execution.
He has obtained a stay.
Parallel proceedings. Right.
Not maintained.
Well, if you want to reserve your right to pursue this petition, you withdraw the execution. Not at the risk of executing the order after.
Your lordship, I'll be pleased to get any orders from this court on my petition, because this is a serious case. 1996, she has been deprived of her right, and I'm fighting this case. I'm fighting this case pro bono. I'm not.
Pro bono, better don't do it.
Yes, sir.
Don't come and say pro bono.
Because
if you said it pro bono, please keep it up. Don't even come and tell before the court I'm doing it free. Please don't say that.
Your lordship, this
You're
court,
doing it free, you're doing it for yourself.
your
Don't
lordship,
say that.
after this court issued a notice to the respondents and the media covered the injustice to the petitioner, the 3rd respondent appeared before the execution court, and once an NBW was issued, he has filed 2 applications. One is to recall the NBW and to stay the proceeding. And I have learned now that he has obtained a stay of the execution proceedings.
I can't advise you.
Your lordship, now there are 2 applications pending, interim applications.
EAT order one bandide nimige.
Yes.
Correct?
Yes.
Educational Appellate Tribunal has passed an order in
Yes.
your favor
Yes,
that you should be reinstated
yes,
with all consequential benefits with salary,
yes,
correct?
yes,
They are not reinstated you.
Yes.
You are entitled for salary from the date you are terminated
yes,
till the date of
Yes.
retirement. You are entitled to.
yes,
You have filed an execution petition,
yes,
correct?
yes.
Execution petition pending irvaga, you file a writ petition before this court seeking for a mandamus, directing them to comply the order passed in EAT.
The reason for that is for 18 years, the respondent has avoided all warrants, all arrests and all proceedings.
I don't
Or
know
my
how
lord,
to advise you,
the
how to take it
issue
forward.
finality in the contempt proceedings.
Execution petition na
2015.
ಹೆಂಗೆ pursue ಮಾಡಬೇಕು ಅನ್ನೋದು I can't advise you.
Your lordship,
It is for you to take steps, mister. You can't have two remedies at the same time.
I'm not, one thing, your lordship, so far as the payment of arrears, as per my knowledge goes, it is only the execution proceedings. For reinstating back to the service, even the government has agreed to appoint the petitioner, but the third respondent has avoided. The letters I have produced.
You have attained the age of superannuation. Where's the question of reinstatement?
I have to get pensionary benefits. For 20 years, your lordship, my pleadings, and I'll be happy for the court to decide on my submission to my.
Withdraw ಮಾಡ್ಕೊಂಬನ್ನಿ.
ಅಲ್ಲ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ದುಡ್ಡು ಇಲ್ಲ ಈ ಕಡೆ ಕೆಲಸನೂ ಇಲ್ಲ ಏನು ಇಲ್ಲದೆ ಇದ್ರೆ 18 ವರ್ಷ ಒಂದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಒಬ್ಬ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ಯಾನ್ ಅವಾಯ್ಡ್ ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಫಾರ್ 18 years ಅಂಡ್ ಈವನ್ 1 lakh ಕೊಡ್ಬೇಕಾದ್ರೆ 6 years ಬೇರೆ ಹೆಸರಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟು ಇದ್ ಮಾಡಿರೋದು. ದಿಸ್ ಇಸ್ ಎ ಪ್ಲೈಟ್. ವೈ I will quote two things. One thing about when I entered the law profession, the former Justice Rangnath Mishra had quoted one thing. He said about the hazards of judicial system. This is a classic case where in 18 years, the execution proceedings have been procrastinated for no reason with the power.
What were you doing? What were you doing?
I have taken all steps. I have taken steps for finally when the media took the issue, the police were able to get the arrest warrant. Now the arrest warrant has been, they have filed an application to.
ಏನ್ರಿ ಹೇಳ್ತಿದ್ರು? What is this yours?
I will produce the entire order sheet to show how the.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, either you withdraw that execution, I'll consider. I cannot consider this matter when the execution petition is pending.
Your lordship, the execution petition is only limited to the issue of payment of salary. The execution court cannot.
Please read the relief again. Relief number B that you have sought for.
Issue directing the third respondent to pay the arrears of salary of 60 lakh in compliance with the order passed by the learned. So that is only limited to the arrears of salary.
Yeah, I have not filed an execution petition for arrears of salary.
Arrears of salary execution petition was filed only for the part of salary till the year 2006. After 2006, there is no petition filed because the execution petition is filed only for the period.
I can't help it if you can't understand. The learned counsel for the petitioner. Even after being told that he cannot pursue two remedies at a time.
Your lordship, I'll take the instruction of the client and I'll make my submission.
Unwilling is unwilling to choose between the two, but insisted this court to pass an order, notwithstanding the fact that an execution petition is filed to execute the order passed in EAT number so and so. Hence, this on your please take a chance before any other court, not before me. Date for September.
Lordship, can
October.
be pleased to say only not before me. It would have been.
Not before me, Madalla. It will come after the.
Your lordship.
I don't want to quarrel with you.
Your lordship may.
Don't seem to understand.
Your lordship may kindly see the plight of the petitioner.
Correct, but you should take it forward in the execution petition.
I will advise and I'll withdraw and I'll prosecute this.
Don't do that mistake, mister. Once you withdraw it, you can't file another execution petition. Please understand.
The execution petition is only period to 2006.
You have to file the execution petition from the date you were terminated till the day you retired. Because all consequential benefits is ordered in the EAT order. So you cannot say up to 2006, I'll go to executing court. After 2006 till 2024, I'll come to the High Court. You can't do that. Please, yochne ಮಾಡಿ. Put some effort into understanding what is the context of the order passed in the EAT. Yes. List on October kodi yavagar undi.
Serial number 14, Federation, yes.
Yes, mister, why don't you deposit this money? Why are you playing truant with the court, with the petitioner?
Discuss with the respondent, my lord.
No, if that is the case, we'll direct the execution court to issue appropriate warrants to recover the money from you. Arrest warrant to issue ಮಾಡಕ್ಕೆ ಹೇಳ್ಬೋದು. If you want to do that, we'll do that. Why are you avoiding the process?
My lord, this writ petition is pending. That's why they are either the writ petition, what is the result of the writ petition? They're waiting for.
ಈ writ petition
Allah, he has obtained a stay in that till the disposal of this writ petition. He has obtained.
ನೀವು ಏನ್ ಕೇಳಬೇಕು ಅಂತ ನಿಮಗೆ ಅರ್ಥ ಆಗಲ್ಲ ನಿಮ್ಗೆ. ಬಂದಿಲ್ಲಿ ಜಗಳ ಮಾಡ್ತೀರಾ ಅಷ್ಟೇ ನೀವು. You're only quarreling with the court. Execution petition direction ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಆಯ್ತು.
ಅಷ್ಟೇ, I'll ask only that direction.
What
It would be great help for a lady.
Great help ಅಲ್ಲ. You should help them properly. You're not helping them properly. By filing unnecessary petitions, you're only keeping the matter pending.
While I had a right to get appointment from 4 to 6, but due to pendency of this.
Since it is stated by the counsel for the petitioner that an execution petition is filed to execute the order passed by the Education Appellate Tribunal in EAT 27 of 2003, it is appropriate to direct the executing court to take suitable and immediate steps to execute the order passed in EAT 27 of 2003. Withdraw ಮಾಡಿದ್ರೆ I can direct the executing court to dispose of the execution petition at the earliest. Without withdrawing this petition,
May I make one submission, Your Lordship? That petition is filed by some other advocate and it pertains only to 2006. Thereafter, I have to file another execution petition for remaining balance of amount because that petition was pending only due, arrears which was due till 2006.
ಆಯ್ತಪ್ಪ 2006 ಇಂದ ಇನ್ನೊಂದು petition ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ? See, now you have not advised your client properly.
This was an
6 to 2024.
This was an NOC obtained in the year 2018.
ಆಯ್ತು 2018 ಇಂದ ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ ನೀವು?
ಇದ್ರಲ್ಲಿ ಸಿಗತ್ತೆ ಅನ್ಕೊಂಡಿದ್ದೆ ನಾನು ಅಷ್ಟೇ.
ನಾವೇನ್ ಈ ತರ ಹೇಳ್ದ ನಾವ್ ಏನ್ ಹೇಳಕ್? What is that we can tell you?
Yes, Your Lordship, I had advised to file one more petition.
ನೀವು ಮಾಡಿರೋ ತಪ್ಪು ನೀವು ಒಪ್ಕೊಳಕ್ ರೆಡಿ ಇಲ್ಲ.
ನಾನು ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. I will say that
2018 ಇಂದ
ಅವ್ರಿಗೆ ಹೇಳ್ದೆ ಕ್ಲೈಂಟಿಗೆ ಈ ತರ ಹಾಕ್ಬೇಕು ಅಂತ. ನನಗೆ ನಂದು ಜಾಸ್ತಿ ಪ್ರೋಬೋನೋ ವರ್ಕ್ಸ್ ಜಾಸ್ತಿ ಇರೋದು, ಅದಕ್ಕೆ ನನ್ನ ಕೈಗೆ ಜೂನಿಯರ್ಸ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇತ್ತು, ನನಗೂ ಅವರು ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ, ನನಗೂ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ದ ರಿಯಲ್ ಪ್ರಾಕ್ಟಿಕಲ್.
What is the execution number?
EAT execution number.
Hence, the so-and-so court is directed to expeditiously dispose of EP number
1262 of 2006.
1262 of
2006.
pending 2006.
It is will judge.
Notwithstanding any stay granted by it in view of the pendency of this writ petition. Yes.
Serial number 14.
Not appear for petition.
The respondent, your lordship.
Is a retired employees of the
Convenience, your lordships. Kindly
retired
have it
employees of
activated.
handloom development corporations. The third, this is third time litigation, third time litigation.
Development Corporation. Yes, you have filed objections.
We'll file objection, your lordship. There is some inconvenience.
Have you
with your-
filed or you will file?
We will
They
file.
are not filed. They are not filed.
Learned counsel for the respondent seeks time to file statement of objections. List on when do you want it?
On 9th, your lordships.
9th September.
Grateful, your lordship.
Number 15. Tumres HC.
No, this is also, this is a retired employees of Karnataka Soaps and Detergent Limited. So the pensionary benefits have not been settled, which has been extended to some other
What is not granted?
retired employees. Pensionary benefits, the pension has not been settled.
That is to be fixed by the state. I believe they filed a statement of
But
objection.
you should process the papers.
We
in
have,
place.
we have processed all of the papers.
Process
No.
Madidira.
Yes.
No. The reason is, Milan, they have rejected my request on the ground that they have appointed after establishment of Karnataka Soaps and Detergent Limited. Those who have appointed prior to that, Milan, they have granted pension. So only on that ground, Milan, they have rejected. So that is under challenge.
Then who has to file objections?
The state government has to file objection.
Yes,
State has already filed
There's a
objection.
connected matter.
State has already filed.
In the connected, in your matter as well, the state has filed
It may
objection.
be fixed, Milan.
Your lordship in.
IA 1/24 is filed for early hearing as a petition is filed in the year 2022 and the petition is not admitted and as older matters are awaiting consideration. IA 1/24 is rejected. List the petition for preliminary hearing in B group on 21st September. Yes.
Obliged.
Ravi Shankar,
Ravi Shankar is.
MS Narayan.
Lord, I pray for a week's time, my lord, accommodation. ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಲಾಸ್ ಅಂತ ತಾವು ಕೇಳಿದ್ರಿ ಅದೊಂದು ಸ್ವಲ್ಪ ತರ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಇವತ್ತು.
pension has been stopped. Provisional pension has been stopped.
ಅದು ಸ್ಟಾಪ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಯಾಕೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರು ಅಂತ ಬಿಟ್ಟಿದ್ರಿ ಅಂತ. ಅದೊಂದು ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ ತರ ಕೇಳಿದ್ರಿ ತಾವು.
The learned counsel for the response 1 to 3 seeks time to file statement of objections.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಲ್ರೆಡಿ ಫೈಲ್.
To file secure additional documents.
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದೊಂದು ಮಾತ್ರ.
List on
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. ನಾಟ್
date put.
10th September.
10th obliged.
For 17. Shamke.
Prithvi Shamke.
Last set of hearing, it's not time to take instructions with regard to what is the steps taken pursuant to issuance of the notification. I've been informed only one sentence.
Regular registrar and the notification order published inviting of therefore seeks time.
One submission. I represent 3 and 4, my lord. I have served the copy also to the petitioner. I am filing objections. And this matter could be disposed of.
So I have been informed yesterday by email minutes, only one word saying that there is a committee appointed to select the suitable candidate. I have requested them to give full information. What are the stages, when it is going to be done, all those things. It may take a few more days. May I request for 10 more days time minutes? I will take it. I have already replied.
10 more days.
10 more days.
2 more days.
10 more days.
Lord, in the meanwhile, I may be
Counsel for the
permitted to file the
respondent.
objections.
Please file it in the registry.
Yes, madam. I may be
Counsel
permitted.
for the
to file.
respondent number 2 seeks time to place on record the
Steps.
information sought for. Place on record the details regarding appointment of a regular registrar. As per the order dated 23/8/2024, list on
Lord,
After 10th, some date.
13th September.
13 September.
Lord, on behalf of the respondents, my lord, I may be permitted to file the objection statement.
Mister, I told you, there is one registry, there are one filing registry.
Hello,
into there. Out of file, man.
out. Much of,
Hold it once, you want to tell me it again.
no, what has happened, my lord?
We are not
I am-
deciding the case today.
Yes,
You can file it in the registry. Why are you reiterating the same thing again and again?
I'm sorry. Let's,
Serial number 18.
Obliged.
Nagaraja Paye.
I appear for the third respondent minutes.
Hmm.
One submission, my lord, said. The order of transfer under challenge, my lord, says, he was posted, my lords, on 12/1/2023.
Petition was posted on?
12/1/2023.
Ah.
And the previous transfer guidelines, my lords, was in force. That's my concession may not be recorded. Let the order, impugned order be set aside, my lords, but let the board be at liberty to take action after 12/1/2023, 2025.
What action?
In case they want to effect the very same order after 2 years. That
observation may cut my
that liberty may be there in case they want to take
I
any.
don't remember the facts.
My lord, the petitioner, my lord, reported on my annexure A is the order of the posting 12/1/2023. By now, my lord, the impugned order, lordship will find at annexure E. The contesting respond number 4 posted in the place of the petitioner prematurely without posting. This is the precise case, my lord.
Yeah, what was your argument on the last day?
Last time,
It was a post, it was a
transfer or
deployment, not a transfer.
that they are not now, my lord, pressing that issue.
Since another 3-4 months is left, my lords,
4 months for the petitioner.
for the petitioner to complete 2 years.
4 months in 12/1.
12/1/23,
So it will be 25.
12/1/25.
That is as per the Melanie pen produced at annexure R3.
In view of the new transfer guidelines, another 4 months.
Whether transfer
But-
is inclusive of
Deployment.
deployment. But according to this definition, in fact, last time your lordships also
But
observed.
deployment, 2000.
Also, yes, also
You can take a
amounts-
call. Now you can take a call after he completes his 2-year tenure.
No, not necessarily, because if exigency arises, even premature transfer can also be made.
Provided you have to provide reasons for that.
Please, that's observation. With that, my lord, your lordship can.
Wonderful.
But my concession may not be.
I tell
I'm grateful.
the petitioner,
I'm representing for the board advocate.
the petitioner has challenged an official memorandum dated 1/8/2024 issued by the respondent number 2 insofar as it relates to his transfer. Insofar as it relates to transfer of the respondent number 3 to his place. Next paragraph. The petitioner contends that he was transferred from Hassan as Assistant Executive Engineer, bracket Technical Assistant, Chief Engineer Office, Mysore, in the department of the respondent number 2, and was thereafter posted on transfer as Assistant Executive Engineer, Subdivision, Mysore, in the respondent number 2 department on 12/1/2023.
I'm sorry, my lord. In fact, his transfer to Mysore was in 2020.
The 20.
Mysore
Hassan,
itself.
Hassan to Mysore was 2020.
20 ಇಸ್ವಿನಲ್ಲಿ 2020.
He's in Mysore
That
from
was
2020.
not stated.
2020. That first one from Hassan to Mysore was in 2020.
2020.
This is what I have recorded.
Please.
On 12/1/23. Full stop. The petitioner contends that
Premature without post.
contends that notwithstanding a communication issued by the state government dated 10/7/2024, directing the officials not to interfere with the affairs of the board in transferring the employees, the state government continue to interfere affairs of the board. Full stop. The petitioner contends that at the instance of the state government, the respondent number 2 transferred the respondent number 3 to the place of the petitioner in terms of an official memorandum dated 31/7/2024. Full stop. 2024 pursuant to an order of transfer dated 1/8/2024. The petitioner is therefore before this court challenging his transfer. One of the prime contentions urged by the petitioner is that the petitioner he had not completed the mandatory term of the minimum term of 2 years as the Assistant Executive Engineer, Subdivision Mysore in the respondent number 2. And even before the completion of such minimum tenure, he was transferred out. Tenure, comma, the respondent number 3 was posted in his place. Full stop. This is, however, contested by the respondent number 3, who contends that the petitioner was deployed in terms of the order dated 12/1/2023, and that the petitioner was within Mysore subdivision from the year 2020, and therefore the petitioner had completed his minimum tenure in Mysore subdivision and therefore was liable to be transferred out. Full stop. The learned senior counsel representing the respondents 1 and 2 also reiterated the above contentions.
Only two, I think.
Huh?
Only for the board.
Respondent number 2 reiterated the above contention and claimed that the petitioner was deployed in terms of the order dated 12/1/2023 and not transferred. And therefore, the petitioner, having completed his minimum tenure in Mysore subdivision, was liable to be transferred.
And one more ground on that day I have made, my lord, annexure E, who is the beneficiary in 2023, he is also by the minister of the government. And he cannot contend hot and cold.
He also contends that the petitioner had also brought in political influence through the minister concerned for his posting
On 12/1/2000.
on 12/1/2023 and therefore cannot accuse the respondent number 3 of bringing political pressure for his transfer to the place of the petitioner.
And one more submission, my lord, this minister is concerned for the same department, UD department. Therefore,
Well, it's
in all
covered by the
respects,
judgment.
in all respects, he can issue directions under the act also.
But they covered by judgments,
that
they
is
cannot.
not
So
interfere.
that, you are the beneficiary of that. That ground is not available to my learned friend now.
That's purple. It is not in dispute that when the petitioner was posted, transferred and posted as the Assistant Executive Engineer, Subdivision Mysore at the respondent number 2 on 12/1/2023, the transfer guidelines that was in existence, that was in force, the ones issued by the state government on dated 7/6/2013. Full stop. The word transfer found in the said guidelines was defined as follows. A transfer means the posting of a government servant from one headquarters to another headquarters or from one office to another within the same headquarters to take up duties of a new post or in consequence of a change of headquarters. Full stop. A note is appended which reads as follows. Movement of a government servant within the same office / unit from one post to another one or desk / compilation to another one under the same head office shall not be treated as transfer. Full stop. The guidelines of 2013 was superseded by the guidelines issued on 7/6/24.
25/6/24.
25/6/24.
Page 16 of my learned friend.
25/6/24, which provided for deployment of employees by the employer as per convenience.
Yes,
Full
it's
stop.
copy.
As rightly contended by learned counsel for the petitioner, when once he was transferred as and posted as the Assistant Executive Engineer Subdivision Mysore, as per the transfer guidelines dated, as per the extant transfer guidelines dated 7/6/2013, he was entitled to continue for the minimum tenure unless the respondent number 1 and 2 felt that a premature transfer for reasons justified was necessary or imminent. Full stop. In view of the above, the respondent number 3 cannot fall back upon the transfer guidelines dated 25/6/2024 to contend that his posting at the place of the petitioner was justified. Full stop. In that way of the matter, the impugned order passed by the respondent number 1 and 2, transferring the respondent number 3 to the place of the petitioner deserves to be interfered with. Consequently, this petition is allowed and the order of transfer of the respondent number 3 to the place of the petitioner dated 1/8/2024 is quashed. It is however open for the respondent number 2 to pass appropriate orders in case if it considers the transfer of the petitioner imminent and necessary for administrative purposes. Yes. Please.
But it should not be taken as a lever for disturbing my lord. Again, from.
Stop. It is also open for the respondent.
After
number
liberty
2.
quarter, they may take my lord
Will not-
advantage of disturbing.
Come to the court. It is
Allah.
it's also open to the respondent number 2 to transfer the petitioner in case if it feels it, in case it considers it necessary after the petitioner completes his minimum tenure.
After and the better one, because.
That is the
See,
reason.
1
my-
minute, 1 minute.
ಇದು ಇದೆ ಅದು ಇದೆ.
That is the
Allah.
reason.
One
ಇದು ಇದೆ.
No, transfer is an incidence in the service and administrative exigency permits, and even within 6
This
months
is-
also you can
he
be
is not-
transferred.
He is not an IAS officer.
ಯಾರಾದ್ರೂ ಆಗ್ಲಿ
Some
ಸ್ವಾಮಿ.
small officer, why do you want to throw a
ಖಂಡಿತ ಇಲ್ಲ ಮಾಡಲ್ಲ ಅಲ್ಲ ನಾನು ಹೇಳಿದ್ದು ದಟ್ ಈಸ್ ದಿ ಲೀಗಲ್ ಪೊಸಿಷನ್
Covered by full bench judgment.
give him 2 years?
ಅಲ್ಲ ಕೊಡ್ತೀವಿ ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ ತಾವ್ ಹೇಳಿದ್ಮೇಲೆ
2 years, why do
ಬಟ್
you want
ಒಂದ್
to?
ವೇಳೆ ಏನಾದ್ರೂ ಎಕ್ಸೈಜೆನ್ಸಿ ಬಂದಾಗ
Exigency ಬಂದಾಗ
ಹಾ.
ಮಾಡಿ.
ಅದೇ
ಕೊಟ್ಟಿದ್ದ ಲಿಬರ್ಟಿ ಇಸ್ ಗಿವನ್ ಟು ಯು. ಹಂಗಂತ ನೀವು ಯು ಕಾಂಟ್ ಕಿಕ್
ಇಲ್ಲ ಇಲ್ಲ ಮಾಡಕ್ ಹೋಗಲ್ಲ
ಅವ್ನ್
I understand your frustration.
ಕೊಟ್ಟಂತ ಅವ್ನ್ ಗೊತ್ತಿಲ್ಲ.
ಆ ತರ ಏನ್ ಲಿಬರ್ಟಿ ಕೊಟ್ರೆ immediately they will suspend
ಇಲ್ಲಪ್ಪ
me.
ಮಾಡಲ್ಲ ನಾನು ಹೇಳ್ತಾ
ಇದೆಲ್ಲ
ಇಲ್ಲ.
Always come to the court, sir. The doors of the court are always open. 24/7, 365, yes.
That
Oblige.
Correct.
Number 2 for orders matter, serial number 1, B.R. Srinivas Gowda.
Mr. B.R. Srinivas Gowda. Non-fighting of acknowledgement, and paid master office. B.R. Srinivas Gowda. Yes, madam, what is this petition about?
This matter, my lords, the petitioner has challenged, my lords, some remarks made in the confidential reports, which she sought for expunction, which has already been expunged. It has been placed before the committee and it's been, whichever part is possible, we have expunged, and the remaining we have not, my lords. That portion she seeks for expunction, and she's also sought for a direction that her tenure may be extended from 58 to 60. My lords, it's not automatic, depending on the kind of work they do and the performance they do, we extend, my lords, from 58 to 60. We've even refused to extend, my lords. That she is challenged.
She must have attained the age of superannuation.
Yes, 2005 itself. She's retired in the year 2005 itself.
So this, so the argument is already expired.
I think she
It is
has.
expired, yes. I think cost rate amend agide.
Yes, my lords.
It is expired.
She's attained superannuation in the year 2005 itself. 30/11/2005, she is retired at the age of 58.
So this expunction, it has to go.
If your lordships would take my statement of objections, we have extracted what was the confidential report.
Page?
Page 2, para 3.
Page 2, para 3.
Yes, please, my lords. So on serial number 3, 4,
Wait,
5,
please
7.
wait.
I'm sorry, my statement of objections is dated 8th June 2022, my lords.
page 2, para 3.
Please, please.
Yes, please.
On serial number 3, 4, 5, 7, 10, we had remarked, it was remarked as poor. She made a communication, my lords. Para 5, we have stated, the Honorable Administrative Judge, my lords, directed for deletion of the remarks at conduct and dignity. We have stated so in para number 5. So she wants the other remarks also to be removed. So that she'll be eligible for extension of tenure from 58 to 60. That is the main thing. This decision, my lords, of the Honorable Administrative Judge dated 12/7/2005 was placed before the senior most Honorable Judge of this Honorable Court, which was also accepted. Then before the Honorable Chief Justice, who ordered it to be placed before the Administrative Committee, my lords. The committee passed a resolution on 27/9/2005 because she had made certain remarks upon the Administrative Judge. So a show cause notice was issued upon the petitioner. Para 10, my lords, it was also placed before the Honorable Expunction Committee and an order was passed on 17/9/2005 itself.
Now, how much of it was expunged?
Only this serial number 7, conduct and dignity, was expunged. The rest of the things remained, my lords. Disposal of cases, industry, then supervision control. Overall view was remaining. Only serial number 7 was expunged. Page 103 of the petition, my lords, is the order of the expansion.
BR Srinivas Gowda. ಬರ್ತಾ ಇಲ್ಲ.
ಬರ್ತಿಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ 2,000 ಕಾಸ್ಟ್ ಹಾಕಿದ್ದೀರಾ ಸುಮಿತ್ ತಾವು. ಅದು ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ ಅನ್ಕೋತೀನಿ.
BR Srinivas Gowda. Whether the advocate is appearing or not.
He appeared on the last occasion and sought time, my lords. So this honorable court has.
He's been consistently asking for time.
Yes, that.
Oh, that Mr. BR Srinivas Gowda is a senior person. ಅವ್ರೆ ಹುಷಾರಿಲ್ಲ ಅಂತಿದ್ರಲ್ಲ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಪರ ಯಾರೋ ಬಂದು ಟೈಮ್ ಕೇಳಿದ್ರು, ತಾವ್ 2,000 ಕಾಸ್ಟ್ ಹಾಕಿದ್ರಿ.
There is no representation for the petitioner. There is no full stop. There is no complaints of the order dated 23/8/2024. As a last chance, list on yavat.
Any date.
List on date.
13 September.
Grateful.
For hearing on serial number 2. Yes, Sanjeev.
But in this, I appear for petitioners numbers 1 to 8 and 10 to 18. But on the last date when the matter was dismissed for non-prosecution, senior Mr. Bhagwan was admitted to hospital. He was in the hospital and I, as his son, I had to take care of him and I could not make.
But somebody should make a submission.
ಅದಕ್ಕೆ ನಾನು hospital ಅಲ್ಲಿ ಇದ್ದೆ. I was with him.
IA 1/24. New hospital, you should ask somebody to make a submission. How would we know?
Sorry for that, but because it was a serious condition. So because of that.
But you should.
I understand, my lord. I
You
apologize.
are making it seem as if it was a court which was at fault.
No, I'm not submitting that. I had.
IA 1/24 is filed to recall the order dated 23/8/24.
That is only by.
It is stated in the affidavit accompanying the application that the arguing counsel was unwell and was admitted to the hospital. Full stop. The cause shown for recalling the order dated 23/8/2024 is thus accepted. Consequently, IA 124 is recalled and the order dated so and so is recalled. The writ petition is restored to file. When can you argue?
13th, my lord.
Restored 13th.
Not one submission.
Item
Dictate ಮಾಡಿದ್ದು, that is on the application filed by petitioner number 9 by another counsel. ನಂದು application ready ಇದೆ, ಇಲ್ಲಿದೆ.
ಇನ್ನು ಹಾಕಿಲ್ಲ.
ನಾನು ಹಾಕಿಲ್ಲ.
ಆಯ್ತು. ಒಂದ್ಸತಿ ಆದ್ಮೇಲೆ ಮುಗೀತಲ್ಲ, ಇಟ್ ಇಸ್ ರಿಸ್ಟೋರ್ಡ್.
ಅಲ್ಲ, ನನ್ ರೀಸನ್ ಕೊಟ್ಟಿದೆ ಅದ್ರಲ್ಲಿ, ತಾವು ನಂದು ರೀಸನ್ ಕೊಟ್ರಿ, ಅವ್ರು ಕೊಟ್ಟಿದ್ ರೀಸನ್ ಅಲ್ಲ, ಅದಕ್ಕೆ.
ಕೊಡಿ. IA 1 of 2024 is filed by the advocate for the
Petitioner number 9.
petitioner number 9 to recall the order dated 23/8/2024. Full stop. It is stated in the application that the advocate for the petition number 9 was on his legs in another court, and by the time he reached this court, the case was called out and dismissed for non-prosecution. Though the cost shown for recalling the order dated 23/8/2024 is not justified, yet since the petition is admitted, an opportunity deserves to be granted to the petitioners to pursue this writ petition. Hence, IA 124 is allowed and the order dated 23/8/24 is recalled and the petition is restored to file. List on 13 September 2024.
This matter was connected.
As per seniority. Yav Shukrar barbeka idu.
This was connected, my lord, with item 9. My lord, on the last occasion, item 9,
13th September.
Please.
Yes, please.
my lord, on the last occasion, my lord, this was listed with item number 9 today in the list. It arises from the same type of proceeding, my lord. So your lordship, my lord, found in that case and adjourned that to today, but this matter, my lord, was dismissed for default. See, if your lordships are adjourning it, 9 may also be connected with the same, my lord.
9 is also connected.
Please.
Seal number 9.
Last time connect ಆಗೇ ಬಂದಿತ್ತು.
Correct ಆಗೇ ಬಂದಿತ್ತು.
List this petition along with WP number 56011 of 2016.
Please.
Could it be on 17th, my lord, if your lordship pleases?
No, these matters will come up only on Fridays. Yes.
List number 1 for fresh matters, serial number 19, Prashant HS.
Respond. IA 124 is allowed.
And head constable, my lord, at the CSF department.
Huh?
Head constable, my lord, CSF department, who has been, my lord, prematurely transferred. That is challenging, my lord, the annexure A, my lord, transfer order. On 3 grounds, my lord. One, my lord, that it's a premature transfer. My lord may kindly turn to page number 33, my lord.
33.
Yes.
Yes.
ಅದು ರೀಚ್ ಆದ್ರೆ ನೀನೇ ಮಾಡು, ನಾನು ನೋಡುತ್ತೇನೆ.
Number 25, tenure of posting. In unit or station for 3 years, at zone or zonal group, 3 years expandable by maximum 1 year. So any person in my lord is entitled to be posted, my lord, for a particular place, my lord, for 3 years plus 1 year, at least for 4 years. Now, my lord, my transfer, my lord, is at
For
annexure.
3 years. At least for 3 years.
At least for 3 years. My transfer, my lord, at annexure B, my lord. Page number 15. Page number 15. It was, my lord, 20th May 2022. Now, my lord, I have a baby of not 7 years old. A sick mother is also there. And one more personnel, my lord, who is similarly situated. He is interested in joining the very same post. I have served, my lord, in VSS Tumba, my lord, for about 4 years.
What is this sector, zonal group, unit station?
There are 2 zones, my lord. One is home zone, one is out of home zones. I have completed out of home zone.
This is unit station 3 years.
Yes, unit or station.
That is 3 years.
That is 3 years.
And what is this sector, zonal group?
That is for the entire, my lord, south zone, east zone, north zone. Like this, there are zones. If that is for, my lord, 3 plus 1 year.
In one zone, you are entitled to be for 3 years.
For a minimum period of 3 years.
You
A
are
7
posted
months old child is there and a sick mother. And one more person, my lord, he is readily willing to go there, my lord, annexure, my lord. D.
Annexure?
Annexure, my lord, our F, my lord.
F.
G. Page number 23, my lord. 23. He has written a letter, my lord, to the commandant, expressing, my lord, his willingness to go there.
Go there and where?
To the place where I'm presently posted, my lord. That is, my lord, Kerala. He is a localite there. He has some problems. He has written this letter, my lord, to the commandant.
And you are now posted to Madikeri,
No, my lord, to Kerala, my lord.
Kerala.
Kerala. Serial number 10, my lord. LPSC B Valimalai, my lord, Kerala.
Yes, Mr.
Please, my lord. Your lordship may kindly turn to page 26, my lord, for a moment. Tenure of posting. Page 26. Out of home sector, my lord, got it, out of home sector, tenure of posting in respect of NGOs is subject to availability of the vacancies, operation and administrative needs and new
What is
inductions.
this, page 26?
Please, my lord, page 26 of the petition, my lord.
Annexure F.
No, my lord,
Yes.
please, my lord, Annexure F, Annexure F. This is the transfer guidelines, my lord.
Yes.
If your lordship may kindly see, basic training period neither to be counted in home sector nor out of home sector. The first tenure, my lord, is 7 years unit and out of home sector. He's completed that. The second tenure is 12 years in the home sector. It is his home sector only. The south is entire his home sector.
Okay.
Please, my lord. Now, my lord, if your lordship may kindly turn to page 12, Annexure A. There were about 37,
Page 12.
page 12.
Ah.
37 members. My lord, out of 37, he is not the only one who is transferred. There are 22 members transferred from this post. The reason is this, my lord, remarks to meet the operational requirements. My lord, he is a specialized person. His operational requirements are needed in Kerala. Therefore, he's been transferred. If your lordship may kindly see, my lord. Now, my learned friend pointed out, referred annexure E page 23. My lord, the transfer cannot be on their whims and fancies, my lord. It is for the operational requirement, the transfer is made. Now, after this, my lord, after 16/8/2024, after the transfer order, my lord, he request the commandant on 19/8/2020.
Somebody else is willing to go. Somebody else is willing to go.
Lord, then your lordship may have it on Monday, my lord. I'll get instructions on that.
Yes. But the learned EST na DST na? DST.
Please, please.
Learned DST submits that the petitioner is now posted within the home sector, home zone. Home zone or home sector? Home sector. And therefore, he cannot have any qualms against his transfer. He also submits that the petitioner has specialized skills and that his presence in Kerala is necessary. And therefore, the respondent has transferred the petitioner to meet certain operational requirements. So when this court suggested to the respondent, to the learned is DST, that a person is, that a person named Mr. Hari Krishnan has expressed his willingness to be transferred to the place where the petitioner is posted. The learned DST sought time to secure instructions whether that person could be placed.
Would be meeting the requirements as of.
Whether he would meet the requirements. Full stop. Hence list on
Monday.
Till such time, if they would issue movement order, my lord.
No, my lord.
Take any action.
No, my lord. If your lordship may kindly see, my lord, for a moment. Otherwise, tomorrow, my lord. Otherwise, I have it tomorrow, my lord.
Please tomorrow.
Great.
Tomorrow. Please.
For preliminary matter, serial number 20, Acharya
Manjula Vittala. Put it then. Put it. If I vote. They challenge the charge sheet.
Please.
There's no representation for the petitioner. Let's list on it.
Second list ಅಲ್ಲಿ item 5, that is a lift operator matter. Your lordships heard that matter. Then you will ask me to inquire about the status of their wife and the daughters. I got the information. Wife is widow, she is working in a garment. Other two daughters are part-time, they are working and also they are.
We'll take it up. Give on 5 ನಿಮಿಷ time ಕೊಡಿ. We'll take it.
It's. Serial number 21, Javed, yes?
Javed.
For petitioner minutes. The petitioners are the assistant lineman minutes. After the inquiry minutes, inquiry has been conducted minutes. Inquiry report is at page number 84 minutes. Annexure E minutes, subsequently minutes. Now the respondent has issued the show cause notice minute, which is the impugned order challenge before this honorable court.
Now, what does the inquiry report say about you?
Minutes, there is no fault of the petitioner.
Does it implicate you or not?
No minutes.
The marks cards are genuine.
Not genuine minute, but it has stated that it is not fault of the petitioner minute. The operative portion, page number 133 minutes. 133 minutes.
Is whether the committee which was appointed by the inquiry officer which was appointed by this court.
Please, minutes.
Did he give a report saying that the marks cards obtained by the petitioners are genuine?
At page number 133 minutes. 33 minutes. Operative portion order.
133.
133 minutes. I hold that the disciplinary authority has failed to prove the charges made against the respondent. The assistant lineman that the mask card produced by him to the disciplinary authority is fake.
Where is the reference to you in the inquiry report?
Not, these are the inquiry reports of the petitioner, my lord.
Where is the reference to you? Nimba ಬಗ್ಗೆ ಎಲ್ಲಿದೆ? What is there to show that the marks card obtained by you is genuine or not fake?
To that extent, they have not mentioned in any report, my lords. Only that the disciplinary authority has failed to prove, my lords. Similarly, place petitioner has approached this honorable court with.
That is right. I remember that, but then you should point out that there was some finding about your marks cards. This is not a general report. Ellar ಬಗ್ಗೆ ಮಾಡಿರಬೇಕಲ್ಲ. Each and every marks card you must have looked into.
No, each and every marks card has been looked into. Please,
ನಿಮ್ದೆಲ್ಲಿದೆ?
At annexure E1, E2 minutes. Annexure E2 at 118 minutes. That is petition number 4 minutes.
Now, where is the reference to your marks card?
Each and every marks cards have been gone through and has filed the report. Reasoning, my lords.
And marks card case ಅಲ್ಲಿ ಯಾರು ಸುಮನಾ ನಾಗರ? Notice to the Srimati Sumana Nagaran is directed to accept notice for respondents 1 to 5. Full stop. Next para. It is stated by the petitioners that the inquiry officer appointed by this court to inquire into the alleged allegation against the petitioners that they had furnished fake marks cards at the time of recruitment, at the time of their recruitment as linemen, has submitted a report exonerating the petitioners. Nonetheless, the disciplinary authority has now issued a second show cause notice and second show cause notice proposing to dismiss the services of the petitioners without accepting the report of the inquiry officer. Without mentioning the reasons for refusing to accept the report of the inquiry officer. Full stop. In that view of the matter, the show cause notice impugned in this petition is stayed. Yes, list this petition along with the then serial number 43, 44 in Ithal. Serial number 43, 44, 45 and other connected petitions. Yes, next.
Let's memo for handover.
Yeah,
handover.
Yes, correct. Next.
Obligations.
List to third is ಯಾವ್ದು?
List 2 for final hearing by the serial number.
Yeah, what was the?
Lord, he was a lift operator in family court. One of the,
What is the punishment imposed?
beg your pardon,
What is the punishment imposed?
punishment is not, is compulsorily, he was dismissed from the service.
Dismissed from service?
Yes. Charge is, my lord, 40,000 rupees is received to use his lift operator office in early disposal of the matter pending before the family court in related to the complainant and his wife. The finding is, my lord, receipt of 40,000 is not proved. Further finding is some amount he received, and only because of some telephone conversation, it appears it is in respect of that allegation only.
Compulsory retirement ಅಂತ ಮಾಡ್ಬೋದು.
ಮಾಡ್ಬೋದು, ಅಷ್ಟು ಮಾಡಿದ್ರೆ ಸಾಕು, ಅಷ್ಟೇ ಆಗ್ಬೇಕಾದ್ರೆ.
ಶಿವಳ್ಳಿ. ಯಾರ ಅಡ್ವೊಕೇಟ್ ಇವಾಗ ಹೈಕೋರ್ಟ್ ಇದೆ? Who appears?
Surely some panel is there.
Surely, does he appear? Is he on, still on the panel? ಹೈಕೋರ್ಟ್ ಕೊಡಿ, ಯಾರು ಪ್ಯಾನಲ್ ಅಲ್ಲಿ ಯಾರು ಇರ್ತಾರೆ? I don't know whether Shivaldi appears. Huh? ಇನ್ನ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
ಈ ಒಂದು 12 ವರ್ಷ ಆಯ್ತು. His age was 39 in 2014. He was appointed in 1996. Impugned order was in February 2014. By that time, he has completed about 18 years of service he has completed.
ಶಿವಳ್ಳಿ. ಇಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ನೋಡೋಣ, ಶಿವಳ್ಳಿ ಬರ್ಲಿ.
ಮಧ್ಯಾಹ್ನ 2:30.
ಈ 2:30ನೇ ಆಗುತ್ತೆ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬರೋಷ್ಟೊತ್ತು.
Very.
We can send them back.
Can I send them back?
ಅಲ್ಲ ಕೇಳಿ, ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ ಕೇಳಿ ನೋಡಿ ಅವ್ರು.
ಅದೇ ಅವರು ಗಾರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಈಗ. ಅವರು ಒಂದು ದೊಡ್ಡ ಹುಡುಗಿ, she is completed BCom very recently and she has to join some part-time appointment. Another daughter is the younger, she is studying in SSLC or PUC, SSLC.
ಆಯ್ತು, ನೋಡೋಣ ಏನ್ ನಮ್ ಕೈಲಿ ಏನ್ ಮಾಡ್ಕೊ.
ಆಯ್ತು, good.
Number 1 for final hearing matters. Serial number 22. Salmani.
ಪ್ರಕಾಶ್ ಸಲ್ಮಾನ್.
The last date, my lord, your lordships had directed us to go into settlement or something. Talks are going on. My lords can accommodate for some more time, my lord. Both the parties, my lord, have approached us. They have come to our office and then, my lord, at Bangalore. Yes, that is a fact.
They've called and
The learned counsel for the respondent and the learned counsel for the petitioner submits that pursuant to the order of this court dated 22/8/2024, the efforts are on for a resolution of the dispute.
Without prejudice, my lord.
It's always without
Right.
prejudice.
Right.
ಏನ್ ಇಷ್ಟೊಂದು ಕೇವಟಗಳೆಲ್ಲ ಹಾಕ್ಬೇಡಿ ಕೋರ್ಟ್ ಇದ್ರಲ್ಲಿ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ it should not so happen that, my lord, they take.
Correct, Mr. You're not settled. If you're not settled, we have to decide the case on
That is
merits.
ಅಲ್ಲ, they should not take an advantage of it, that's all.
Settlement
Settlement take ಬಂದಿದ್ರು, ಆಮೇಲೆ it happened like this.
Correct.
That means-
Submission ಮಾಡುವಾಗಲೇ 20
Very-
ಕ್ಯಾರೆಟ್ ಹಾಕ್ತೀರಾ ಇದು if but that this.
ಅಲ್ಲ, ಇರ್ಬೇಕಾಗತ್ತೆ, ಯಾಕಂದ್ರೆ I'll have to protect my interest also, my lord, that's the only thing.
Correct. We are not
Very
going to
well,
be
very well.
prejudiced by any submission made. We have to
Aye,
decide
aye.
the case independently.
ಆಯ್ತು. Please.
ಯಾವತ್ ಬೇಕು?
Lord, they have said that they'll give some offer ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವರೇ ಹೇಳ್ಬೇಕು ಈಗ ಏನು ಅಂತ. ಅದು ಹೇಳಿ ಏನ್ ಡೇಟ್ ಆದ್ರೂ ತೊಂದ್ರೆ ಇಲ್ಲ. Say about 4 weeks, my lord.
4 weeks.
ಯಾಕಂದ್ರೆ ಆಗಂಗಿದ್ರೆ ಆಗೋಗ್ಲಿ, ನಂದೇನ್ ಅಭ್ಯಂತರ ಇಲ್ಲ.
No, we are ready.
Can't give
actually
it a
with
long
calculation.
leash. We have to put you on a tight leash. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? ಇಲ್ಲಾಂದ್ರೆ ಇದು ಸೆಟ್ಲ್ ಆಗೋದಿಲ್ಲ.
Next week any day.
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಅವರೇ ಹೇಳ್ಬೇಕಾಗಿರೋದು.
Next week, my lord.
ಅವ್ರು ಹೇಳಿ it has to be posted, I mean it has to be placed before the board. Say about 3 weeks ಆದ್ರೂ ಕೊಡಿ.
12th September.
Please.
23. Rajesh Shettigar.
Rajesh Shettigar.
Serial number 23.
Rajesh Shettigar. ಬರ್ತಾ ಇಲ್ವಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರ ನೋಡಿ. TP ಮುತ್ತಣ್ಣ ನೀವು.
Yes, I am for respondent, my lord.
Then what is the issue?
My lord, here the petitioner, he joined the Chitradurga Gramina Bank in 1985 as a field officer. And during the period from 2007 to 2009, he committed certain serious acts of financial procedural irregularities, where he had taken the money of the customers. Around 67 customers, they have given complaint, and even witnesses also they have given. So all those monies he along with one other clerk, Mr. Ramchandrappa, he had taken all the amount were misappropriated by them. Because of that, they were dismissed from the services.
Ramchandrappa is also.
And Ramchandrappa, actually, he is expired.
Hello, was any department proceedings initiated against him?
My lord, I don't have any idea about that. About the Ramchandrappa, I don't have idea, my lord.
ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು? ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಆಗಿರ್ಬೇಕಲ್ಲ. There must be.
No, my lord, this is, charge sheet is issued only on him here.
Whether any
So,
proceedings were taken out against Ramchandrappa.
No, that I have to get the insight from the bank, my lord.
ಫೋನ್ ಮಾಡಿ ತಿಳ್ಕೊಳ್ಳಿ ಪಾಸ್ವರ್ಡ್.
Well, at least short date may be given, so that
2013.
like Gramina Bank, I have to ask the Gramina Bank. That is the only reason.
Let the other side come, let us.
24. Vijay Kumar.
Non-filing of subcommittee report.
Lord, I was direction issued to the learned friend, Lord, I have the copy of the report. Lord, the last part.
Yeah, what is it?
This, on the basis of this report, Lord, the authorities have come to conclusion that we have suppressed and we have misled the board to secure the revised pay scale, Lord. My lords may kindly come to the report which is submitted on 28/1/2015. On the last occasion,
where is that report?
That enclosed along with that.
This one?
Yes, Lord.
27/1/2015. 28/1/2015.
Yes, Lord.
So what is the case about?
My lord, the petitioner are appointed in the year 1985. My lords, as on that date, my lords, as per 1979 regulations, my lord, the pay scale was fixed for textile designer was rupees 750 to 1,525 as per 1979 regulations. In the year 1983, my lord, prior to the appointment of these petitioners, my lord, the pay was revised. My lord, 750.
Now, when were you appointed?
I am appointed, the petitioners are all appointed on 14/2/1985. 14th February 1985. My lord, prior to that only, my lords, on 29th December 1983, the revision of pay has taken place. That I have produced at Annexure B, page 19. My lord, the pay scale was, my lord, 750 to 1,525 was revised to 1,050 to 1,950. Prior to our appointment. the public notification for recruitment, my lord, was called. My lord, in the notification, my lord, the wrong pay scale was fixed, 750 to 1,500 was the scale which was fixed in the notification. My lord, our contention is this, my lord, when we were appointed during the year 1985, as on that date, my lord, the scale was already revised to 1,050 to 1,950.
Yes.
That the notification itself was, my lord, wrongly mentioned the scale of pay. My lord, so subsequently, my lord, our claim has been considered. And my lords, in 2012, the pay scale was, my lord, revised and extended the benefit to the petitioners. My lord, so subsequently, in the year 2015, on the basis of the report submitted by the subcommittee, my lord, they said that the petitioners have suppressed and misled the board and secured the pay scale, revised pay scale. My lord, the observation of the subcommittee, my lord, itself is wrong. How it is, my lord, wrong is.
Let
my
us
lord,
see what is the observation of the subcommittee.
Please, my lord. Yes. My lord, married, my lord. The relevant.
First in the oath,
Please
read from beginning.
ನಿಗಮದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 3 ಮಂದಿ ಡಿಸೈನರ್ಗಳಿಗೆ ನೀಡಿರುವ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಯ ತಾರತಮ್ಯದ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ವರದಿ ನೀಡಲು ರಚಿಸಲಾಗಿರುವ ಉಪಸಮಿತಿಯ ದಿನಾಂಕ 27/1/2015 ಹಾಗೂ 28/1/2015 ಸಭೆ ಸೇರಿ ಕೈಗೊಂಡ ನಿರ್ಣಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ ವರದಿ. ಕಚೇರಿ ಆದೇಶ ಸಂಖ್ಯೆ 23/12/2014 ನಿಗಮದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 3 ಮಂದಿ ಡಿಸೈನರ್ಗಳಿಗೆ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಸಹಾಯ ಮಾಡಿ ಮುಂದಿನ ವೇತನ ಶ್ರೇಣಿಗೆ ಅಕ್ರಮವಾಗಿ ಮುಂಬಡ್ತಿ ನೀಡಲಾಗಿದೆ ಎಂಬ ವಿಷಯದ ವಾಸ್ತವಾಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವರದಿ ನೀಡಲು ವಿವಿಧ ಮುಂಬಡ್ತಿಗಳಲ್ಲಿನ ತಾರತಮ್ಯಗಳನ್ನು ಪರಿಶೀಲಿಸಲು ರಚಿಸಲಾದ ಉಪಸಮಿತಿಗೆ ಸೂಚಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಸಮಿತಿಯು ದಿನಾಂಕ 27/1/2015 ಹಾಗೂ 28/1/2015 ಎರಡೂ ಹಂತಗಳಲ್ಲಿ ಸಭೆ ನಡೆಸಿ ಸದರಿ ವಿಷಯದ ಬಗೆಗಿನ ಕಡತಗಳನ್ನು ದಾಖಲಾತಿಗಳನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿತು. ಪರಿಶೀಲನೆಯ ಸಮಯದಲ್ಲಿ ಸದರಿ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಿನಾಂಕ 29/7/1984 ಪ್ರಜಾವಾಣಿ ದಿನಪತ್ರಿಕೆಯ ಪ್ರತಿಯು ಪರಿಶೀಲನೆಗೆ ಲಭ್ಯವಿಲ್ಲವಾದ್ದರಿಂದ ಅದನ್ನು ಪತ್ರಿಕಾ ಕಚೇರಿಯಿಂದ ಸಂಗ್ರಹಿಸಿ ಸಮಿತಿಯ ಪರಿಶೀಲನೆಗೆ ಮಂಡಿಸಲು ಶ್ರೀ ಎಂ ಬಾಬುರೆಡ್ಡಿ ಸಮಿತಿಯ ಸದಸ್ಯರು ಇವರಿಗೆ ಸೂಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ಅವರು ಸದರಿ ಪತ್ರಿಕೆಯ ಪ್ರತಿಯನ್ನು ಸಂಗ್ರಹಿಸಿ ಸಲ್ಲಿಸಿದ್ದು ಸಮಿತಿಯು ಅದನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು ಪ್ರತಿಯನ್ನು ವರದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಈ ವಿಷಯದಲ್ಲಿ ಸುದೀರ್ಘ ಚರ್ಚೆ ಮತ್ತು ಪರಿಶೀಲನೆಯ ನಂತರ ಈ ಮುಂದಿನಂತೆ ನಿರ್ಣಯಗಳನ್ನು ಕೈಗೊಳ್ಳಲಾಯಿತು. ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯಂತೆ ಸದರಿ ಡಿಸೈನರ್ಗಳ ನೇಮಕಾತಿಗೆ ನಿಗದಿಪಡಿಸಲಾದ ವಿದ್ಯಾರ್ಹತೆಗೂ ನೇಮಕಾತಿ ಹೊಂದಿರುವ ಡಿಸೈನರ್ಗಳ ವಿದ್ಯಾರ್ಹತೆಗೆ ವ್ಯತ್ಯಾಸವಿರುವುದನ್ನು ಸಮಿತಿಯು ಗಮನಿಸಿತು. ಸೇವೆಯಲ್ಲಿನ ಡಿಸೈನರ್ಗಳು ಹೊಂದಿರುವ ವಿದ್ಯಾರ್ಹತೆಯ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸುವ ವಿದ್ಯಾರ್ಥಿಗೆ ಸಮಾನವಾದ ವಿದ್ಯಾರ್ಹತೆಯ ಎಂಬ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸುವುದು ಅಗತ್ಯವಿದ್ದಲ್ಲಿ ಅದರಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಶಿಫಾರಸು ಮಾಡಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಪ್ರಜಾವಾಣಿ ದಿನಪತ್ರಿಕೆ ದಿನಾಂಕ 29/7/1984 ಪ್ರಕಟಣೆಯಲ್ಲಿ ದಿಸ್ ಇಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿ ರಿವಿಷನ್ ಆಫ್ ಪೇ ಸ್ಕೇಲ್. ದ ನೋಟಿಫಿಕೇಶನ್ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಇನ್ 84. ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯಲ್ಲಿ 2 ಡಿಸೈನರ್ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಲಾಗಿದ್ದು ಸದರಿ 2 ಹುದ್ದೆಗಳಲ್ಲಿ 1 ಹುದ್ದೆಯನ್ನು BSc ವರ್ಗಕ್ಕೆ ಹಾಗೂ 1 ಹುದ್ದೆಯನ್ನು TCM ವರ್ಗಕ್ಕೆ ಮೀಸಲಿರಿಸಿದೆ.
BSG, ವಾಟ್ ಇಸ್ BSG?
BSG ವರ್ಗ ಹಾಗೂ 1 ಹುದ್ದೆಯನ್ನು BCM ವರ್ಗಕ್ಕೆ.
BSG ಅಂದ್ರೇನು?
That will I'll verify. I'm not abbreviations I am unaware of. ವರ್ಗಕ್ಕೆ ಮೀಸಲಿದೆ. ಆದರೆ ನಿಗಮದಲ್ಲಿ 2 ಹುದ್ದೆಗಳ ಬದಲಾಗಿ 3 ಅಭ್ಯರ್ಥಿಗಳನ್ನು ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದು ಅವರ ಸೇವಾ ಪುಸ್ತಕಗಳಲ್ಲಿರುವಂತೆ ಜಾತಿವಾರ ವಿವರ ಇಂತಿದೆ. So all the 3 petitioners are the petitioners in this present petitions, my lord. ಈ ಅಂಶಗಳ ಬಗ್ಗೆ ವಿವರವಾದ ಪರಿಶೀಲನೆ ಅಗತ್ಯವಿದ್ದಲ್ಲಿ ಅದರಂತೆ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದೆಂದು ಸಮಿತಿಯು ಶಿಫಾರಸು ಮಾಡಿ ನಿರ್ಣಯಿಸಿತು. ನಿಗಮದಲ್ಲಿ 1983ರಲ್ಲಿ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಗಳನ್ನು ದಿನಾಂಕ 1/4/82 ಅನ್ವಯವಾಗುವಂತೆ ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. They themselves have admitted that the revised pay scale has been.
Can understand Kannada.
I'm sorry. ಹಾಲಿ ಸೇವೆಯಲ್ಲಿರುವ ಡಿಸೈನರ್ಗಳು 84ರಲ್ಲಿ ಹೊರಡಿಸಲಾದ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ವಯ ನೇಮಕಾತಿ ಹೊಂದಿದ್ದು ಸದರಿ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ 33ನೇ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ ₹500ರಿಂದ 1120 ಶ್ರೇಣಿಗೆ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿ 750ರಿಂದ 1500 ವೇತನ ಶ್ರೇಣಿ ನೇಮಕಾತಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿದೆ. ಅದರ ಅನ್ವಯ ಸದರಿ ವೇತನ ಶ್ರೇಣಿ ಅಂದರೆ ₹750ರಿಂದ 1500ರಲ್ಲಿ ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಲಾಗಿದೆ. ಆದರೆ 1979ರಲ್ಲಿ ಹೊರಡಿಸಲಾಗಿದ್ದ ಇದೇ ಮಾದರಿಯ ಪ್ರಕಟಣೆಯಲ್ಲಿ ₹750ರಿಂದ 1525 ವೇತನ ಶ್ರೇಣಿಗೆ ಡಿಸೈನರ್ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಿರುವುದನ್ನು ಉಲ್ಲೇಖಿಸಿ ಅದರ ಆಧಾರದ ಮೇಲೆ ತಮಗೆ ನೀಡಿರುವ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ಪರಿಷ್ಕರಿಸಬೇಕೆಂದು ಮನವಿ ಸಲ್ಲಿಸಿ ಅದರ ಮಂಜೂರಾತಿ ಪಡೆಯುವಲ್ಲಿ ಈ 3 ಮಂದಿ ಡಿಸೈನರ್ಗಳು ಯಶಸ್ವಿ ಆಗಿರುವುದು ಸಮಿತಿಯು ಗಮನಿಸಿತು. 1984ರಲ್ಲಿ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ವೇತನ ಶ್ರೇಣಿ ₹750 ರಿಂದ 1500 ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯಾಗಿತ್ತು. ಅದರಂತೆ ನೇಮಕಾತಿಯಾಗಿ ಅದನ್ನು ಒಪ್ಪಿಕೊಂಡು ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವುದರಿಂದ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಯ ವಿಷಯವನ್ನು ತಪ್ಪಾಗಿ ನಿರೂಪಿಸಿ ಮುಂದಿನ ಹಂತದ ವೇತನ ಶ್ರೇಣಿ 1050 ರಿಂದ 1950ಗೆ ತಮ್ಮ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ನಿಗದಿಪಡಿಸಿಕೊಳ್ಳಲು ಮಂಜೂರಾತಿ ಪಡೆದಿರುವುದನ್ನು ಸಮಿತಿಯು ಪರಿಶೀಲಿಸಿ ದೃಢಪಡಿಸಿಕೊಂಡಿತು. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ 3 ಮಂದಿ ಟೆಕ್ಸ್ಟೈಲ್ ಡಿಸೈನರ್ಗಳಿಗೆ ನೀಡಲಾಗಿರುವ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಯ ಮಂಜೂರಾತಿಯನ್ನು ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಿಂಪಡೆಯಲು ಹಾಗೂ ಅವರಿಗೆ ಅರ್ಹ ವೇತನ ಶ್ರೇಣಿ ಮತ್ತು ಮೂಲ ವೇತನವನ್ನು ನಿಗದಿಪಡಿಸಲು ಶಿಫಾರಸು ಮಾಡುವುದೆಂದು ಸಮಿತಿ ನಿರ್ಣಯಿಸಿತು. ನೇಮಕಾತಿ ದಿನಾಂಕದಿಂದ ಅಂದರೆ 14/2/85ರಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಸದರಿ 3 ಮಂದಿ ಡಿಸೈನರ್ಗಳಿಗೆ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆ ಮಾಡಲಾಗಿತ್ತು. ದಿನಾಂಕ 1/1/2012ರಿಂದ ಆರ್ಥಿಕ ಸೌಲಭ್ಯಗಳು ನೀಡಲಾಗಿದೆ. ತಪ್ಪಾಗಿ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಯಾಗಿರುವುದರಿಂದ ಅವರಿಗೆ ಈ ಪರಿಷ್ಕರಣೆಯಿಂದ ನೀಡಲಾಗಿರುವ ಆರ್ಥಿಕ ಸೌಲಭ್ಯಗಳನ್ನು ವಾರ್ಷಿಕ ಶೇಕಡ 14 ಬಡ್ಡಿ ಸಮೇತ ಅವರಿಂದ ವಸೂಲು ಮಾಡಿ ನಿಗಮಕ್ಕೆ ತುಂಬಿಕೊಳ್ಳಲು ಶಿಫಾರಸು ಮಾಡಲು ಸಮಿತಿಯು ನಿರ್ಣಯಿಸಿತು. ಈ ಸಂಪೂರ್ಣ ಪ್ರಕರಣವನ್ನು ಅವಲೋಕಿಸಲಾಗಿ ಸದರಿ ಡಿಸೈನರ್ಗಳ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಗೆ ಕಡತ ಮಂಡಿಸಿ ವಿಷಯವನ್ನು ತಪ್ಪಾಗಿ ನಿರೂಪಿಸಿ ನೇಮಕಾತಿಯನ್ನು ₹750 ರಿಂದ 1525 ಪೂರ್ವ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಮಾಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ ತಪ್ಪು ಮಾಹಿತಿಯನ್ನು ಆಡಳಿತ ವಿಭಾಗದ ಪ್ರಭಾರಿ ಆಡಳಿತಾಧಿಕಾರಿಯಾದ ಶ್ರೀ ಬಿ ಗಜೇಂದ್ರರವರು ಮಂಡಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದುದರಿಂದ ಈ ಪ್ರಕರಣದ ಸಂಪೂರ್ಣ ಜವಾಬ್ದಾರಿಯನ್ನು ಅವರ ಮೇಲೆ ಹೊರಿಸಿ ಅವರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದೆಂದು ಶಿಫಾರಸು ಮಾಡಲು ಸಮಿತಿಯು ನಿರ್ಣಯಿಸಿತು. ಹಾಗೂ ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಇತರೆ ಅಧಿಕಾರಿಗಳನ್ನು ಗುರುತಿಸಿ ಅವರ ಮೇಲೆ ಸೂಕ್ತ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದೆಂದು ಶಿಫಾರಸು ಮಾಡಲು ಸಮಿತಿಯು ನಿರ್ಣಯಿಸಿತು. ಈ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಳ್ಳುವವರೆಗೆ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಕಡತಗಳನ್ನು ಹೆಚ್ಚು ಸುರಕ್ಷತೆಯಿಂದ ನಿರ್ವಹಿಸಿಕೊಳ್ಳಲು ಆಡಳಿತ ವಿಭಾಗದ ಸಿಬ್ಬಂದಿಗೆ ಸೂಚಿಸಲು ಸಮಿತಿ ನಿರ್ಣಯಿಸಿತು. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ 3 ಮಂದಿ ಟೆಕ್ಸ್ಟೈಲ್ ಡಿಸೈನರ್ಗಳಿಗೆ ನೀಡಲಾಗಿರುವ ವೇತನ ಶ್ರೇಣಿ ಪರಿಷ್ಕರಣೆಯ ಮಂಜೂರಾತಿಯನ್ನು ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಿಂಪಡೆಯಲು ಹಾಗೂ ಅವರಿಗೆ ಅರ್ಹ ವೇತನ ಶ್ರೇಣಿ ಮತ್ತು ಮೂಲ ವೇತನವನ್ನು ನಿಗದಿಪಡಿಸಲು ಶಿಫಾರಸು ಮಾಡುವುದೆಂದು ಸಮಿತಿ ನಿರ್ಣಯಿಸಿತು. ನೇಮಕಾತಿ ದಿನಾಂಕದಿಂದ ಅಂದರೆ 14/2/1985ರಿಂದ that is repeated document. Thereafter, ಈ ವರದಿಯೊಂದಿಗೆ ಲಗತ್ತಿಸಲಾದ ದಾಖಲಾತಿಗಳು ದಿನಾಂಕ the committee members who have signed the.
Please read paragraph number 2 again.
Please, Lord. ನಿಗಮದಲ್ಲಿ 1983ರಲ್ಲಿ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಗಳನ್ನು ದಿನಾಂಕ 1/4/1982ರಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಹಾಲಿ ಸೇವೆಯಲ್ಲಿರುವ ಡಿಸೈನರ್ಗಳು 1984ರಲ್ಲಿ ಹೊರಡಿಸಲಾದ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಅನ್ವಯ ನೇಮಕಾತಿ ಹೊಂದಿದ್ದು, ಸದರಿ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ 33ನೇ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ ₹500 ರಿಂದ 1120 ಶ್ರೇಣಿಗೆ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿ 750 ರಿಂದ 1500 ವೇತನ ಶ್ರೇಣಿಯ ನೇಮಕಾತಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿದೆ.
Which is the correct scale of pay?
Please, bro.
Applicable to this other designers.
Yes, bro. Annexure A may kindly be seen for a moment. Annexure A is the case Karnataka Handloom Development Corporation Staff Regulations 1979. Relevant is at page 17. This is 1979 regulations, page 17, textile designer. Right, point number 3, post carrying scale of pay 750 to 1525. It was in the year 1979 itself.
Yes.
Textile designer scale was 750 to 1525.
Then how did this committee say this?
That is the wrong observation made by them, Lord. Kindly come to Annexure B for a moment, Lord. And this is the revised pay scale accepted by the Karnataka Handloom Development Corporation.
Okay, but how did this committee come to this conclusion at paragraph number 2?
They say that, Lord,
ಹಾಲಿ ಸೇವೆಯಲ್ಲಿರುವ ಡಿಸೈನರ್ಗಳು
yes,
84ರಲ್ಲಿ ಹೊರಡಿಸಲಾದ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ವಯ ನೇಮಕಾತಿ ಹೊಂದಿದ್ದು, ಸದರಿ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ 33ನೇ ಸಭೆ ನಿರ್ಣಯದಂತೆ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ 500-1120 ಶ್ರೇಣಿಗೆ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯ 750, 1500 ವೇತನ ಶ್ರೇಣಿ ನೇಮಕಾತಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿದೆ.
That is the wrong observation. That is why I am saying, Lord, the regulation itself says the scale of pay is 750 to 1525 in the year 1979 itself. Now, how they are coming to conclusion that that scale of to the textile designer was 500 to 1,120. That is not forthcoming, my lord. Now, and I request my lord to kindly come to annexure B for a moment, page 19. my lord.
B na?
B, page 19.
Ah,
Here, my lords may come to point number 6.
ah.
500 to 1,120 pay scale. And the revised pay scale is 750 to 1,500.
500 ಯಾವ ಸ್ಕೇಲ್ ಇತ್ತವಾಗ ಇರ್ಲಿಲ್ವಾ?
ಇರ್ಲಿಲ್ಲ. The next ಅದು ಕೆಳಗಿನ ಸ್ಕೇಲ್ ಇರೋದು 600 to 1,240. ಅದು ಬಂದ್ಬಿಟ್ಟು ಸೇಲ್ಸ್ ಮ್ಯಾನೇಜರ್, ಸೇಲ್ಸ್ ಆಫೀಸರ್ ಬೇರೆ ಅದ್ರಲ್ಲಿ ಕ್ಯಾಟಗರೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes,
My lords, short accommodation, my lords, scenery is out of
I will
date,
not
my
grant
lords.
accommodation. I can grant you
Kindly,
accommodation provided you pay cost.
Yes, kindly, my lords.
No, I'm sorry, I did not.
Scenery is out of council, out of station, my lord.
Nodi,
Kindly.
I had mentally decided that henceforth I will not impose cost. But
Shortly.
ನಾನು ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಬಂದ್ರೆ you people compel me to impose cost.
Tuesday, my lords. Please, my
No, no,
lords.
this matter is heard. This is the second time.
Second time.
My lords, kindly, my lords.
No, no, sorry. Town council for the petitioner seeks, respondent number 1 and 2 seeks.
Kindly, my lords, my
Full
Tuesday.
stop. This petition was heard
Day before.
on 28/8, huh?
Yes, lords.
On 28/8/2024. And learned counsel for, after hearing, full stop. The learned counsel for the respondent number 1 and 2 seek short time and is posted today. Full stop. The request for adjournment by the learned counsel for response 1 and 2 is therefore not justified. However, as a last chance list on
Tuesday, my lords.
Tuesday, subject to payment of cost of
Yes, yes.
2,000
Much.
payable to the library fund, advocates library. Grateful.
Number 20 point, online staffing.
Hearing for respondent, my lords.
Yes. Mr. Mohammed, no,
A state of hearing, my lord. Within 3 hearing date, my lord. Entire inquiry has been completed, no document has been supplied. And financial misappropriation, their
What are
own
the
petition for.
charges against
My
you?
lords, if I may make a submission, my
So
lord.
let him argue, madam. What are the charges against you?
Charges, my lord. Page 17.
Page?
17 annexure D.
Page 17,
17.
70.
70. 17. 17.
Seventeen is a petition.
17, my lord, annexure D. 60, sorry, my lord. 60, sorry. Other double number.
Page 60.
60. My lord, total, my lord, 3 charge sheet and show cause notice in charge issued, my lord. This second one. Three charges, charge sheet has been issued, my lord. Total 47
55.
charges has been framed against petition. All charges pygmy account maintaining for the account holder.
Let us see what does the inquiry report, inquiry officer.
Inquiry report, my lord, this honorable court directed to the bank, my lord, to produce the entire inquiry document proceeding, inquiry document. Till today, they are not produced.
My lords.
You don't have a copy of the report.
My lord, finally, they have, my lord, this one, I think it is.
My lords,
available
it's
in the file.
available in the file, my lords. It is filed on 12th March 2021, my lords.
12th March.
2021.
No, something is filed on 3rd of September 2018.
10/3/2021.
No, there's nothing filed on 12th March. What is the?
10 March.
Right.
You placed on record the inquiry report.
Yes, my lords.
It was filed on 12th March 2021.
Yes, my lords.
There's nothing like. 10th March. Yes. What all charges is held to be proved, madam?
My lords, 47 charges have been proved, my lords. Out of 55.
I thought, how many charges are held to be proved and which are they? ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ
Milord, page 4 other second. Ink page 4
of this document?
This document,
10th March.
10th March.
Page?
Milord, charges first 1 to 15 charges ಅಂತ ಹಾಕಿದ್ದಾರೆ. Charge 1 ಮೇಲೆ ಮೊಹಮ್ಮದ್ ಆರ್ ಬಿನ್ ಗುಲಾಮ್ ಅಹಮದ್ ರವರು HAC ಠೇವಣಿಯಲ್ಲಿ ತೊಡಗಿಸಿದ್ದರು 30,000ಗಳ ಖಾತೆಯನ್ನು ಕೈದುಗೊಳಿಸಿದ ನಂತರ ಪುನಃ ಠೇವಣ ಲೆಡ್ಜರ್ ಬೇರೆ ಪಾನಲ್ಲಿ ಸುಳ್ಳು ದಾಖಲಿಸಿ ಬಡ್ಡಿ ಮತ್ತು ಅಸಲು ಎಂದು ಒಟ್ಟು 46,005 ರೂಪಾಯಿಗಳನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಹಣ ಪಡೆದು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಬ್ಯಾಂಕಿಗೆ ವಂಚಿಸಿ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿರುವುದು ನೌಕರರ ಸೇವಾ ನಿಯಮಾವಳಿ ಸಂಖ್ಯೆ 55 Roman 7 A2.
So he had invested 30,000 rupees.
Milord, this kind of charges, Milord, totally same charges, 47 charges were raised against the petitioner, Milord. Milord, 122 document has been marked in the examination, in the inquiry, Milord. This entire inquiry, 3 dates they have completed, Milord. And
These documents were not given to you.
not supplied, Milord. I repeatedly requested and I have also not to allowed me.
Along with the charge sheet ಕೊಟ್ಟಿಲ್ವಾ ಇದೆಲ್ಲಾನು?
ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಅರ್ಜಿನೂ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮ್ಯಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ಮೇಲೆ ದಿಸ್ ಈಸ್ ಸಬ್ಮಿಟೆಡ್ ಟು ದಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮೇಲೆ ಪೇಜ್ 82 ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಮ್ಯಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದೀನಿ.
Page 82
ಪೇಜ್ ಮೇಲೆ ಅನೆಕ್ಷರ್ ಹೆಚ್ಚು ಕೈಯಲ್ಲಿ ಬರ್ದು ಕೊಟ್ಟಿದ್ದೇನೆ, ಅದು ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದೀನಿ ಸರ್. I may permit it. Para 1 minute. That the disciplinary inquiry has ordered against me by the reference 1. Above and you are appointed as a disciplinary inquiry officer in the matter by reference 2 above. That the disciplinary inquiry as per order 1 above fixed on 16/1/2003 and 5/2/2003 wide reference 1, which the disciplinary officer should have issued notice calling my presence to record my written statement before you, but it is surprising to note that the notices are issued by a person which is not competent to issue such notices. If it is issued, it is illegal. It is also surprising to note that said officer issuing the inquiry notices with reference 3, above having issued the said notices has directed to inquiry officer in the matter. Besides, the said officer also directed to presenting officer to take suitable action on behalf of the disciplinary authority, which is also not correct. As stated in para 3, as stated in para 2 above, though I have attended the place as fixed for the said inquiry at the time scheduled on 16/1/2003 at HDCC Bank, Hassan head office, but it was surprised to note that neither the inquiry officer and presenting officer were present at the place on the scheduled date. Even though I have waited for the whole day, in this connection, I have sent a letter to the MD HDCC Bank Limited, Hassan head office on 23/1/2003 through the courier which is marked as Annexure 1, herewith appended. For another notice dated 24/1/2003, but reference 3 above received by me forthwith. Inquiry date is fixed on 5/2/2003 at 11 AM in the HDCC Bank meeting hall, Hassan, which is also not issued by the inquiry officer, but others which is not legal. Earlier to the said date fixed for a disciplinary inquiry, I have sent a letter on 23/1/2003 through courier to the managing director HDCC Bank Limited, Hassan,
who has earlier sent the list of charges against me, imputations, list of document in annexure 1 to 4, but has not supplied the documents as per the said annexure 3. In order to submitting statement of objection before the inquiry officer, hence I have already aspired in the said letter that the MD HDCC Bank Hassan to issue the documents marked in annexure 3 pertaining to charges number 1 to 15 and letter dated 30/12/2003, number 8 to 98 pertaining to charges 1 to 22. In my said letter, I have asked the managing director HDCC Bank Limited Hassan to supply the concerned audit report pertaining to the charges framed against me, so as to enable me to file my objections before the inquiry officer. The copy to the letter sent to MD HDCC Bank on 23/1/2012, appointed herewith and marked as annexure 2.
Yes,
but
madam,
said
have you sent
documents-
these documents to him?
My lords, we have informed my lords, I will establish that in the letter, my lords. Which
No.
We have
See,
sent.
you have relied upon so many documents at
Yes,
the
my lord.
inquiry. Were these documents supplied to him when the charge, articles of charge was furnished?
My lords, there is a communication addressed by the petitioner stating that,
But a last date of hearing, my lord,
my lords,
in respect to this point, my lord, they have referred, my lord, service rules records, section 58, page 111, my lord. There is no, as per their service rules, document is not necessary to supply to the.
Then how
inquiry
will you
officer.
my lords,
prepare the
my
defense?
lords, kindly
this is
allow me
also-
to complete my submission, my lords. My lords, the letter addressed by the petitioner to the bank on where he admits that on 2/8/2002, an order of inquiry was made under number A and C, 3466 of 2002 and 3, appointing one FD, Sri FD D'Souza, advocate for inquiry officer, and Sri Puttaraj Gowda as presenting officer, along with the inquiry order, list of charges, list of documents, and list of witnesses in all annexures 1 to 4 were supplied to me. He admits this, my lord.
Where do I find that?
This is R19, my lords.
Exhibit R19.
Exhibit R19. This is-
You have produced that along with the statement of objections.
No, my lords, this is
No, where was it marked?
in,
Before the inquiry officer.
yes, my lords, before the inquiry.
Please pass it on.
Yes.
The list of documents is not documents per se.
But my lords, this was the,
Correct, you're supposed to produce or furnish the documents, madam.
my lords,
How does
further,
he prepare the defense then?
my lords, further, the inquiry proceedings, my lords, an order sheet, in entire perusal of the order sheet, my lords, no such letter is being given to the bank, my lords, requesting for the documents, my lords.
Madam, you are supposed to furnish the documents along with the articles of charge. What is the basis of charge?
My lords, he chose to not attend, my lords. This is an afterthought, my lords. I'll establish that.
Fair enough, fair enough. Then the opportunity has to be given to him to face the inquiry afresh.
My lords, that cannot be done because the disciplinary authority has duly complied
They
with.
not participated in the inquiry.
My lords, we have informed him to be present on 5/2/2008, my lords, but he has chose not to appear, stating that authority who has issued the letter is not competent enough to inform. But that cannot be taken as ground, my lords, because Appellate Tribunal has exhaustively discussed all the points,
Yes.
contentions raised by the petitioner, my lords.
Yes.
If my lords may kindly. Page number 13, my lords.
13 of
13 of, sorry, 35, my lords, in page 35
what?
of petition, my lords. It's the Appellate Tribunal's order, my lords. The first ground on, if I may start, my lords. The first ground on which R2 assigns his dismissal order is that the inquiry proceedings were scheduled in such a manner so that the petitioner would not be able to attend the same, and the notice of inquiry has been caused to be issued by a person who is not competent to issue a notice.
Yeah, but
When we
why
examine-
did you challenge it before the appellate tribunal?
My lords,
You were before the.
yes, my
tribunal.
lords, because JRCS, the joint registrar, has completely
Set aside.
set aside the
So that is
dismissal
challenged
order, and asked to reinstate the petitioner, my lords. When we examine exhibit P1, it is seen that the same is dated 6/1/2003 and is sent by registered post, informing R2 that domestic inquiry to be conducted against him will be held on 16/1/2003 at 11:30 a.m. in the meeting hall of head office of the Appellant Bank, and the said notice is issued on the directions of the inquiry officer. The inquiry officer reads as under, ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಸುವುದೇನೆಂದರೆ ನಿಮ್ಮ ವಿರುದ್ಧವಿರುವ ಆರೋಪಗಳ ಬಗ್ಗೆ ನಡೆಯುತ್ತಿರುವ ಗೃಹ ವಿಚಾರಣೆಯ ವಿಚಾರಣಾಧಿಕಾರಿ ಸೂಚನೆ ಮೇಲೆಗೆ 16/1/2003 ರಂದು ಬೆಳಿಗ್ಗೆ 11:30ಗೆ ಹಾಸನ ಜಿಲ್ಲಾ ಸಹಕಾರಿ ಕೇಂದ್ರ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಪ್ರಧಾನ ಕಚೇರಿ ಹಾಸನ ಇವರು ಮೀಟಿಂಗ್ ಹಾಲ್ ನಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ಆದುದರಿಂದ ಸದರಿ ವಿಚಾರಣೆ ಹಾಜರಾಗಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ತಪ್ಪದೆ ನಿಮ್ಮ ಗೈರು ಹಾಜರಿನಲ್ಲಿ ವಿಚಾರಣೆಯನ್ನು ಮುಂದುವರಿಸಲಾಗುವುದು. Exhibit P11 has been signed by Divisional Office Manager of the Appellant Bank. However, the reasons not brought on record, the inquiry officer has held on comments. Sorry, my lords. However, for reasons not brought on record, the inquiry has not been held on or commenced on 16/1/2003. Thereafter, respondent number 2 has written a letter to the managing director stating that divisional manager has, in his notice 6/1/2003, cited with reference, has intimated me, my apologies, intimated me the date of inquiry on 16/1/2003 at 11:30 in meeting hall so and so. Accordingly, I was appeared to the inquiry, but both inquiry officer and presenting officer were absent. He says that, my lords. And further, exhibit P14 reveals that inquiry has been commenced on 5/2/2003 and continued on 10/2/2003, 17/2/2003, and finally on 22/2/2003, on which day the inquiry has been concluded.
What happened on 16/1/2003? Was an inquiry held on that day?
My lords, the inquiry was supposed to be commenced due to the have to be commenced, but then due to some issues they couldn't, and the same was informed. My lords,
Was it informed to?
Yes, my lords.
Where is that?
On
exhibit?
5/2, my lords, the letter which was sent by the bank informed the first date and the second date of the inquiry, where
Second date
5/2
16/1/2003 inquiry was not held.
not commenced.
Was a fresh notice issued to him?
No, my lords, in the first notice which was sent, 5/2/2003, that day was also mentioned, my lords.
It was fixed in advance.
Yes, my lords.
16/1 and
And
5/2.
5/2.
Where is that notice? You letter refer ಮಾಡದಲ್ಲಿ ಇದು page number.
Page 56 joint register order ಮೇಲೆ.
ಅಲ್ರಿ
ಮೇಲೆ.
ನೀವು
ಇದು
letter
annexure H ಮೇಲೆ 82 page ಮೇಲೆ. Typed page 87 ಇಂದ.
I have sent a letter to the MD Hassan on 23/1/2003 through the courier, which is another notice. It's also for inquiry date is fixed on. So 24th you issue another notice.
My lords.
You issue another notice on 24th January,
Yes, my lords.
fixing the date
Yes.
of inquiry on 5/2.
Yes, my lords.
Uh,
He was very well informed, my lords. He chose not to appear, stating that the competent authority has not given the.
Yes.
this thing, notice, my lords.
Hmm.
My lords, further, this the alleged letter stating requesting the documents is not a part of the record, my lords. I'll establish that by the entire proceedings, the order sheet, my lords. Nowhere it reflects that they have received any letter from the petitioner, my lords.
Yes.
The entire order sheet.
Now, this is dated 3/2/2003.
Yes, my lords.
Is sent to the disciplinary authority.
Yes, my lord. It
How
is
can
not. It is not a part of the file, my lords. It is a implanted document, my lord. That also has been noted by the appellate authority, my lords.
Yes, please read.
Yes, my lords. A moment. My lords, page number 40, my lords. The next ground is that the request of R2 petitioner to provide copies of relevant documents that are needed to prepare and defend himself effectively during the inquiry were not supplied. Relies upon exhibit P12 and P13 in order to prove this allegations. Exhibit P12 is a letter dated 23/1/2003 addressed to the managing director of the Appellate Bank, where there is no whisper of requisition for any documents. In this, the R2 has only informed the managing director. He has appeared at the venue of the inquiry on 16/1/2003 at 11:30, but both the inquiry officer and presenting officer were absent, and proceeds further to and requests for intimation of the next date of the inquiry. Exhibit P13, which is addressed to the inquiry officer, the R2 has only said that he has sought for documents from the managing director, which are yet to be supplied to him, and unless he has supplied, with the required documents by the managing director who has initiated the disciplinary proceedings, he is unable to file objections before the inquiry officer. He further proceeds and requests the inquiry officer to arrange for issue of necessary documents. Exhibit P3 does not specifically state and list out documents sought by R2. It is dated 3/2/2003. By then, the inquiry notice 24/1/2003 informing R2 that the inquiry would be conducted on 5/2/2003 has already reached him. Instead of attending the inquiry and putting forth before the inquiry officer, he has request for supply of documents, and he chose to write a letter to the inquiry officer stating that he has sought for certain documents, which is yet to be supplied. Inquiry officer arranged for supply of the same. Further, it is also not certain that the said letter 3/2/2003 marked exhibit P13 has reached the inquiry officer, since there is no acknowledgement of in proof of the fact that exhibit P13 has reached, and the same has been served to the inquiry officer. My lords, this is a implanted document.
What is implanted? It is already marked by you, madam.
Yes, my lords, but it is not there in the in our official.
Marked by you as exhibit P13.
My lords, we have not approached JRCS, my lords. They have approached. It is their document, my lord.
That is right. Exhibit P13.
But the acknowledgement of having received has to be furnished, no, my lords. That is not.
It is marked by you.
My lords.
Exhibit P13 has reached the inquiry officer. Since there is no acknowledgement in proof of the fact that exhibit P13 has reached or has been served on the inquiry officer.
Yes, my lords.
How is it?
We have
You
not.
have marked it.
My lords, before JRCS, we have not approached, my lords. It is the petitioner who has approached, my lords, challenging.
This P13 was marked before the JRCS.
Yes, my lords, not before the appellate tribunal.
How?
Sorry, my lords.
How was it marked before the JRCS? Well, then you supply all documents, let the inquiry begin afresh.
My lords, it can't, my lords, because
Why?
it is, it is timely barred and the charges have been proved, my lords. It can't go back, my lords. I have a judgment to
Even if your
support.
rules, even if your rules say that documents need not be supplied,
Yes, my lords.
the principles of natural justice has to
My
be
lords,
read
it is
in.
not violated because he has chose not to appear, my
It is
lords.
not. You are bound to
My
furnish
lords,
all
their
the documents.
conduct itself shows, my lords. Everything is afterthought, my lords. My lords, may kindly accept this finding where in 155 charges, he's been held guilty of 147, my
Madam,
lords.
let him
This
be hanged.
itself,
Let him be hanged, but you please follow the principles of natural justice.
my lords,
That is
no,
all.
no prejudice is being caused, my lords.
Alright,
No.
you passed an order of penalty and you say no prejudice is
He
gone.
he's been given sufficient opportunity, my lords.
You please.
Because the
hand over all
appellate authority has exhaustively dealt with each and every contentions raised by the petitioner, my lords.
Hand over all the documents to him, we'll fix a date for the inquiry officer to conduct and conclude. Whether this inquiry officer is still there.
No, my lords, he died long time, 2011 only he
One
died.
more inquiry officer, let him conduct a de novo trial. Without handing over the documents, madam, it's not a
My
fair
lords,
inquiry.
that one aspect may,
Please put yourself in his position. Please put yourself.
but
in
my
his
lords, he has
position.
understood all of the,
Madam, you don't even give the documents to him. You don't even give the documents to him. How will he cross-examine? How will he know? How will he formulate his defense? How will he formulate his defense?
leaving that apart, his conduct as such has not been well, my lords. That is the only reason.
Documents kotilla, that you admit.
My lords, he
You
could
admit.
have on 512.
Correct, you
Five-
admit that you have not handed over the documents.
My lords,
to
he
him.
accepts that he has received the list of documents and he could have,
Documents is not documents, madam. List of documents is not documents. You're bound to hand over the documents to him.
but my lord, at this juncture, conducting a fresh
Since you have
inquiry is,
kept it pending for so long.
yes, my lords, that
Hmm.
no prejudice is being caused, my lords.
Yes, yes, mister. Why did you not appear before the inquiry officer?
My lord, I appeared, my lord, I requested.
But how can you say that notice is issued by somebody else when
My
it is issued at the direction of the inquiry officer?
My lord, one finding, the joint register of the kindly see, my lord, page 56, my lord. Page 56, joint register. Order. I may permit it. ವಾದಿಯು ತನ್ನ ಹೇಳಿಕೆಯನ್ನು
Page
ಸಲ್ಲಿಸಿ
56 of what?
ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟರ್ ಆರ್ಡರ್
Huh.
ಅದರಲ್ಲಿ ನಾಲ್ಕನೇ ಪ್ಯಾರಸ್. ವಾದಿಯು ತನ್ನ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿ ಗುರುತಿಸಿದ ನಿಶಾನೆಗಳಲ್ಲಿ ದಿನಾಂಕ 3/2/2003 ಈ ಪ್ರಕರಣದಲ್ಲಿ ರಚನಾತ್ಮಕವಾಗಿ ಅರ್ಥಪೂರ್ಣವಾಗಿ ಭಾಗವಹಿಸಲು ದಾಖಲೆಗಳನ್ನು ಪೂರೈಸಬೇಕೆಂದು ಕೊಟ್ಟ ಅರ್ಜಿ ನಿಶಾನೆ P13 ಅನ್ನು ನಿಶಾನೆಗಳೆಂದು ಗುರುತಿಸುವಾಗೆ ಪ್ರತಿವಾದಿಯು ಯಾವುದೇ ತರಹದ ತಕರಾರನ್ನು ಎತ್ತದೇ ಇರುವುದರಿಂದ ಈ ನಿಶಾನೆಯು ಅಬಾಧಿತವಾಗಿರುತ್ತದೆ ಮತ್ತು ವಿಚಾರಣೆಯನ್ನು ಕೈಗೊಳ್ಳುವಾಗೆ ಕೋರಿದ ದಾಸ್ತಾವೇಜುಗಳನ್ನು ಪೂರೈಸುವುದು ಇಲ್ಲವೇ ಪೂರೈಸುವಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ಕರ್ತವ್ಯವಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ನಿಶಾನೆ R122 ನಿಶಾನೆ P14 ವಿತಿನ್ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಕೋರಿದ ದಾಸ್ತಾವೇಜುಗಳನ್ನು ಪೂರೈಸಲಾಗಿದೆ ಎಂದು ಉಲ್ಲೇಖವಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಶಿಸ್ತು ಪ್ರಕರಣದಲ್ಲಿ ದಾಸ್ತಾವೇಜುಗಳನ್ನು ಅಪಾದಿತ ನೌಕರನಿಗೆ ಪೂರೈಸದೆ ಪೂರ್ಣಗೊಳಿಸಿದ ವಿಚಾರಣಾ ವರದಿಯು ದೋಷಪೂರಿತವಾಗಿರುತ್ತೆ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ರೆಫರೆನ್ಸ್ ಮೇಲೆ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಮೈ ಲರ್ನ್ಡ್ ಬ್ರದರ್
ಎಲ್ಲಿದೆ?
ಪೇಜ್ ರೂಲ್ಸ್ ಅಲ್ಲೇ ಇದೆ ಸರ್. ಮೇಲೆ ಪೇಜ್ 112 ಮೇಲೆ 112 explanation serial number 3 ಮೇಲೆ the employee shall for the purpose of preparing his her defense be permitted to inspect and take extracts from such officials records as she may specify, provided that such permission may be ordered in writing, be refused by the inquiry officer if in his opinion
such records are not relevant for the purpose or it is against the public interest to allow him access thereto. My lord, this has not come annexure P14. They have not recorded whether they have supplied or.
No, these are documents that which you want to inspect.
Enquiry, entire inquiry charges and inquiry
Yes.
questions pertaining to the documents into the inquiry.
Okay, na?
My lords, I have a judgment in support of.
My lord,
Put whatever judgment you want.
my
to
lord,
apply.
their allegation is I have misused the fund, my lord. For that, my lord, they have initiated very same joint register against me for recovery proceedings, my lord. That is rejected.
That is
In
on.
that, my lord, they have not filed any appeal or taken steps, my lord. It shows, my lord.
Yes,
even-
please, what is this
My lords,
judgment?
departmental inquiry, principle of natural justice, non-supply of documents, belated protest, that, about that, my lords.
Yes.
Para 3. We have considered each and every contentions raised by the learned counsel for the appellant. We do not find any substance in any one of them. It is
Please read the facts, madam. What are the facts?
an order of
For the-
compulsory retirement in a disciplinary proceedings under provision of
Page 576. Please read the sentence beginning at page 576. Blasphemy. Before the inquiry officer, the delinquent prayed for production of certain documents. And in fact, an order was passed to the inquiry officer directing the department authorities to give documents of those documents to the delinquent. But notwithstanding the same, the allegation of delinquent is that some of those documents had not been produced. Ultimately, on the basis of the materials produced, the inquiring officer came to the conclusion charges against the delinquent have been proved by the department. It's not a different set of facts.
my lords, but
It's a
That-
different set of facts.
my contention here is that it's an afterthought, my lords. It's a belated.
Fully.
Principles of natural justice are not violated, my
But
lords.
full.
My lords, there is no, if my lords may peruse the entire order sheet, there is no letter which is given, my
Madam,
lords.
do you admit,
My lords,
do you admit that you handed over the documents or do you not hand it
but
over?
my lords, there was no bar on him also to
Purpose.
have been present, my lords.
The petitioner has challenged the order dated 10/7/2015 passed by the Karnataka Appellate Tribunal in appeal number 788/2011, by which it set aside an order passed by the respondent number 2 and restored the order of the disciplinary authority. Full stop, next para. The petitioner while in service as a senior assistant at the respondent number 1 was served with an articles of charge. Was suspended on 3/6/2002 pending a departmental inquiry. Full stop. A show cause notice was issued to the petitioner, following which he submitted his reply. The disciplinary authority not being satisfied with the reply sent, issued an articles of charge, rejected the reply and issued an articles of charge. Containing how many charges?
Total
155.
Containing 150 charges. Which primarily related to certain misappropriation by the petitioner while he was working as a senior assistant at the respondent number 1. Full stop. The disciplinary authority appointed an inquiry officer who held the first proceedings on. What are the first proceedings? That was
5 to 2000,
on? See,
to 2003, my lords. First,
on 16/1/2003. Full stop. However, the inquiry officer did not preside over the proceedings, and the case stood, the inquiry stood adjourned to 5th of December 2003. Full stop. Petitioner was served with a notice of inquiry, allegedly submitted a representation to the disciplinary authority stating that the notice of inquiry was issued by an incompetent person and not the inquiry officer, and therefore refused to appear before the inquiry officer. Full stop. The inquiry was thereafter held on 5/2/2003, then 5/2/2003 and
10/2/2003.
10/2003 and 17.
Finally, 20/2/2003.
17/2/2003 and 20.
22/2003.
On which dates, the presenting officer examined a witness and marked how many documents?
122.
122 documents. Stop. The petitioner allegedly submitted a representation dated
3/2/2000.
so
3/2/2000.
3/2, not 3, madam. 23/1/2003. 23/1/2003. Requesting for the documents that were sought to be marked at the inquiry. Full stop. The inquiry officer proceeded with the inquiry and submitted his report, holding that all the charges against the petitioner were proved. Full stop. The disciplinary authority thereafter accepted the report of the inquiry officer and passed a major order of dismissal from service. Full stop. The petitioner, being agreed with the said order, challenged the same before the respondent number 2 in a proceeding under section 70 of the Cooperative Society, Karnataka Cooperative Society Registration Act. Full stop. The respondent number 2 held that the inquiry was not fair and proper and recorded the evidence of the petitioner. Full stop. At such inquiry, the petitioner marked exhibit P13, which was a letter dated 23/1/2003. Full stop. This letter was not opposed by the respondent number 1. Full stop. The respondent number 2, after perusing the record, held that the respondent number 1 had not furnished the documents that were sought to be relied upon at the inquiry, either at the time of filing, either along with the articles of charge or at the inquiry, and therefore held that the inquiry was not proper but was in violation of the principles of actual justice, and consequently set aside the order passed by the disciplinary authority and directed the reinstatement of the petitioner. Full stop. Feeling agreed with the said order, the respondent number 1 filed an appeal before the Karnataka Appellate Tribunal. Full stop. The tribunal, after considering the material placed on record, held that the petitioner had deliberately absented himself from the inquiry on the ground that the notice of inquiry was issued by an incompetent person and not by the inquiry officer. The tribunal therefore held that the petitioner had deliberately absented himself from appearing before the inquiry officer and participating in the inquiry. Full stop. It also held that The letter dated 23/1/2003, which was the basis of the order passed by the respondent number 2, was doubtful as there was no endorsement issued by, there was no acknowledgement by the inquiry officer about the receipt of that letter. And therefore no evidentiary value can be attached to that letter. Full stop. It also held that the finding of the respondent number 2 that the inquiry was held in haste was not proper, as the rules provided a procedure which was complied by the inquiry officer, and it was for the petitioner to participate in the inquiry, and that he could not have contested the procedure adopted by the inquiry officer. Full stop. Right. The appellate tribunal therefore set aside the order passed by the respondent number 2 and restored the order passed by the disciplinary authority, disciplinary/appellate authority of the respondent number 1. Full stop. Being agreed with the said order, the petitioner is before this court in this petition. Next paragraph. The learned counsel for the petitioner submitted that the petitioner was served with only an articles of charge, and there was no documents were furnished to him so as to formulate his defense. Full stop. He also submits that there was no statement of imputation of misconduct against a petitioner. Full stop. Further, he submits that the documents that were relied upon by the respondent number 1 were not furnished to him even after a request was made on 23/1/2003. Full stop. He therefore contends that the inquiry was conducted in haste and without following the principles of natural justice. Further, he contends that the first date of inquiry was fixed on 16/1/2003, but on the said day there was no proceedings held by the inquiry officer. But the inquiry was then taken up on 5th of February 2003 without formally informing the petitioner. Full stop. He therefore contends that the proceedings of the inquiry officer is in stark violation of the principles of natural justice and therefore deserves to be interfered with on this short ground. Per contra, the learned counsel for the respondent number 1 submitted that the notice of inquiry was issued to the petitioner, informing him that the inquiry would be held on 16th of January 2003. However, the petitioner responded and claimed that that notice was not issued by a competent officer and therefore he abstained from participating in the inquiry. She further contends that the notice of inquiry further contends that the inquiry was held on 5th of February 2003 and the petitioner was informed well in advance about the date of inquiry and that the petitioner did not participate in the inquiry on 5th of February 2003. He submits that the petitioner had categorically admitted that a list of documents that the respondent number 1 intended to rely upon was furnished to him, and therefore the petitioner cannot contend that he was not provided with the documents. Full stop. She also referred to the order of the appellate tribunal and contended that the tribunal had held that the petitioner was the one who was responsible for protracting the proceedings by not participating before the inquiry officer. Full stop. She therefore contends that the petitioner is not prejudiced in not being served with the copies of the documents that were relied upon at the inquiry. In support of her contention, she relied upon the judgment of the apex court in Syed Rahimuddin versus Director General CSIR and others, 2001, Part 9 SEC, page 575. Full stop. I will consider the submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 1. Next paragraph. It is now tried that any departmental inquiry or a domestic inquiry has to be conducted by complying with the principles of natural justice. Full stop. It is also tried that even if the service rules or the regulations relating to such domestic inquiry do not provide for such complaints of principles of natural justice, the same needs to be read into it. Full stop. It is not in dispute that when the articles of charge were served on the petitioner, the respondent number 1 had furnished along with it the statement of imputation of misconduct and had also not furnished the documents which the respondent number 1 intended to rely upon in support of the articles of charge. Full stop. Therefore, the inquiry had stumbled at the first step, inasmuch as it did not give an opportunity to the petitioner to formulate his defense. Full stop. Even at the inquiry, full stop. The inquiry commenced its first sitting on 16/1/2003. However, there was no proceedings on the said date. Full stop. There is nothing to show that the petitioner was informed about the next date of hearing, that is on 5/2/2003, though it is contended by the learned counsel for the respondent number 1 that notice of the inquiry dated 5/2/2003 was informed to the petitioner well in advance. Be that as it may, the inquiry was held on 5/2/2003, then, madam, on what dates? On so and so dates, on 22/2003, 17/2/2003, so and so. On all these dates, the petitioner did not participate. Full stop. The petitioner has placed on record a document dated 23/1/2003, which purportedly was a letter addressed by him to the inquiry officer, which was marked before the respondent number 2. This document was not contested by the respondent number 1. Full stop. Therefore, a reading of Exhibit P13 shows and establishes beyond doubt that the petitioner did make a request before the inquiry officer for the documents that were marked before him. And there's nothing to show that such documents were furnished to the petitioner. Full stop. The contention of the learned counsel for the respondent number 1 that the regulations do not provide for furnishing of documents along with the articles of charge or at the time or before the inquiry officer, is noted only to be rejected. Full stop. It is therefore clear that the inquiry was not conducted in accordance with law and was in absolute violation of the principles of natural justice. Consequently, the impugned order passed by the tribunal deserves to be set aside, and the order passed by the deserves to be set aside. Consequently, the inquiry shall be conducted afresh by appointing appointing a inquiry officer, as it is reported by the learned counsel for the respondent number 1 that the earlier inquiry officer has expired. Full stop. In that view of the matter, the following order is passed. The impugned order passed by the tribunal is set aside The respondent number one is directed to conduct a fresh inquiry after furnishing all the documents that were relied upon at the inquiry before the inquiry officer. Full stop. The petitioner shall, the respondent number one shall take immediate steps for appointment of an inquiry officer who shall conduct the proceedings afresh and pass and afresh in accordance with law.
That's
Full stop. It is made clear that the inquiry shall be concluded within a period of 6 months from the date of receipt of a copy of this order. Yes.
I want to bring one point in to the your lodge notes is Dinanka 20 in the entire order sheet, it is said, it reflects that Dinanka 24/1/2003 ವಿಚಾರಣೆ ನೋಟಿಸ್ ನಂತೆ ಈ ವಿಚಾರಣೆಯನ್ನು ಬ್ಯಾಂಕ್ ಕೇಂದ್ರವು ಕಚೇರಿ ದಿನಾಂಕ so and so there is like there's a mention of this date where the communication was sent.
It is sent, madam, but the documents are not furnished ultimately. See, everything should be transparent. You have to furnish documents to him. He should be given all opportunity. Yes, next. Sorry.
Hearing B group matter, serial number.
Is it possible within 6 months?
8 months.
Within a period of 9 months, yes.
Serial number 26, Sudha D.
For the yesterday's matter. For the
Yes.
the impugned order of entrustment is at, my lord, 31/5/2013. But insofar as competency is concerned, my lord, when writ petition was filed, my lord,
No, whether this judgment of mind deals with that question. Nande on the order ideyalla. Yesterday it was given to you.
but say, my lord, insofar as I am not aware of, my lord, my lord's order, but I am aware of the judgment rendered by the coordinate bench in writ petition number 2899 of 2021.
Yes.
Not, it is covered insofar as, not, the competencies.
This covered, then that is a judgment rendered by Justice Nagaprasanna.
Yes.
Kodi, there is a
I
batch
am-
of petitions.
And mark ಮಾಡಿದ್ದೀನಿ.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ನಿಮ್ key points ಏನೋ ಇದೆಯಾ ಅದರಲ್ಲಿ?
ಇಲ್ಲ ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಅಷ್ಟೇ.
It is covered against you.
It is covered against me. Insofar as, my lord, competency is concerned, my lord, it is covered against me.
Yes.
My lord, the coordinate bench has held that there is a delegation, director is empowered to issue an order of appointment. My lord, I will make one attempt, not with regard to competency, my lord, the matter is pending before the division bench, there is no interim order. And, my lord,
Competency, anyway, you're not questioning. What else are you questioning now?
Lord,
On facts.
on facts.
On facts.
On facts ಅಂತಂದ್ರೆ, not, there is no application of mind as contemplated under section 12(4) of the Karnataka Lokayukta Act as held by the division bench of this honorable court, not the impugned order is at page 14. And, not one further development is, not yesterday, not, the criminal court has acquitted me.
ಅದಕ್ಕೆ ಬರೋ ಸಂಬಂಧನೇ ಇಲ್ಲ.
On merits ಆಗಿದ್ದಿದ್ರೆ, not, judgment is not released. I have got only the case status, which ಎಲ್ಲಿದೆಯೋ acquitted ಅಂತ.
Acquit ಆದ ಏನು, we do not know on what basis. Yes.
Not, in that event, may I request, not, tomorrow or day after tomorrow, I'll produce the criminal court.
ಬೇಕಾಗಿಲ್ಲ ಅದು, ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿ. Please point out.
See, his contention is the matter has been entrusted by the second respondent is wrong.
ಆಯ್ತು, entrustment is giving up.
It is correct and that even
He is not arguing that point.
On other ground, my lord.
Okay, what is the other zone?
Yes, without application of mind ಅಂತ ಹೇಳಿದೀನಿ. But page 14 is the impugned order. Not, this extract, page 15, my lord, till last but one paragraph refers the my lord, communication between Lokayukta police and the respondent. Last but one paragraph says, I have examined these materials, whether in the teeth of my lord division bench order, that would suffice.
Hello, 14A what is just satisfaction, Mr.
Yes, application of mind is required.
Just satisfaction, not application of mind, just satisfaction.
But the division bench has held that not application.
There is one judgment of Justice Sanjay Goda. Where is that?
That is, my lord, 17A, my lord.
17A.
That is approval, permission. My lord, the microscopic examination is not required. And my lord, section 17A, it is only
It was, I think, under 14A.
17A.
No. There are two things that was examined in the judgment rendered by Justice Goda, where question was whether the Lokayukta itself can make a request for transferring it for inquiry, number one. Number two, whether the satisfaction should be as strict as the one that is contemplated under section 17A.
As far as my knowledge,
that is the judgment rendered. I remember distinctly.
Sriru,
I don't remember the past title Gottilla, but I remember the text of the judgment.
Microscopic examination. The division bench of this own court has held that, my lord, application of mind is a parameter, my lord, under rule 14A of the CCA rules. Sanjeev Kumar.
Yes, please read. Please read the relevant course. Para 13.
Yes.
Case number?
Para 13 or para 19, note.
It is after this disciplinary authority, competent authority is required to take a call under section 12(4) of the Act of Entrustment, entrusting the inquiry under rule 14A of this rules. Subsection 3 of section 12 mandates that report of the Lokayukta along with his findings, recommendation, relevant documents, materials and other evidence be forwarded to the competent authority. The gist of the report under section 12(4) of the Act has found its place in the order of entrustment of the inquiry to the hands of second respondent Lokayukta and is extracted hereunder for the purpose of ready reference.
Yes.
Then, my lord,
22. Para 22.
Subsection 4 of section 12 of the Act casts a duty upon the competent authority to examine the report, forward it to it, and then take a decision. After such examination, a bare perusal of the order entrusting the inquiry under rule 14A of the rules depicts flagrant violation of section 12(4) of the Act, as competent authority has not even examined as required under section 12(4) of the Act as to whether inquiry requires to be entrusted to Lokayukta, or is there any grievance worthwhile to hold an inquiry against the petitioner. All that the order dated so and so would say is the extract of the findings in the report to the Lokayukta under section 12(3) of the Act, and the fact that Lokayukta has sought inquiry to be entrusted to itself, and in those circumstances the inquiry was entrusted. Perusal of the order sheet would clearly indicate that the reminders were sent to the competent authority by the second respondent to entrust the inquiry to itself.
The unequivocal fact that would emerge from our consideration above is the disciplinary authority, competent authority has surrendered its discretion of decision making to the dictates of the second respondent Lokayukta, thereby abdicating its duty cast under section 12(4) of the Act. Abdication of one's discretion in decision making and capitulating to the dictates of the external agency amounts to itself non-application of mind in view of the law laid down by the Honorable Apex Court in so and so. The authority cannot permit its discretion to be influenced by the dictation of others, as this would amount to abdication and surrender of its discretion. It would then not be the authority's discretion that is exercised, but someone else.
It's a different set of facts. ಅದರಲ್ಲಿ ಲೋಕಾಯುಕ್ತನೇ ಹೇಳ್ತಾರೆ ಗವರ್ಮೆಂಟ್ಗೆ ಕೊಡಿ ನಮಗ್ ಕೊಡಿ ನಮಗ್
ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
Yes, that is not reference number. But page 15 itself says, may I read, my lord? ಸದರಿ ಲಂಚಾರೋಪ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತನಿಖೆ ಸಮಯದಲ್ಲಿ ಸಂಗ್ರಹಿಸಿದ ದಾಖಲೆಗಳು ಮತ್ತು ಪುರಾವೆಗಳು ಆರೋಪಿ ಅಧಿಕಾರಿಯಾದ ಶ್ರೀ BM ಚಂದ್ರಶೇಖರಯ್ಯ, ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ರವರು ಮೇಲೆ ತಿಳಿಸಿದಂತೆ ಫಿರ್ಯಾದುದಾರರಿಂದ ಲಂಚವನ್ನು ಪಡೆದು ದುರ್ನಡತೆಯನ್ನು ಎಸಗಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿಯೂ ಆದುದರಿಂದ ಸದರಿ ಆರೋಪಿ ಅಧಿಕಾರಿಯವರ ವಿರುದ್ಧ ಇಲಾಖಾ ವಿಚಾರಣೆಯನ್ನು ಹೂಡಲು ಮತ್ತು ಅದನ್ನು ತಮಗೆ ವಹಿಸಲು ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರವರು 30/3/2013 ವರದಿಯಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಶಿಫಾರಸು ಮಾಡಿರುತ್ತಾರೆ.
ಆಯ್ತು.
ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರ ವರದಿ ಮತ್ತು ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳ ಪ್ರತಿಗಳನ್ನ ಅಪರ ನಿಬಂಧಕರು ವಿಚಾರಣೆ 10 ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಬೆಂಗಳೂರು ಅವರು ದಿನಾಂಕ 5/4/2013 ಪತ್ರದೊಂದಿಗೆ ರವಾನಿಸಿರುತ್ತಾರೆ.
ಮುಂದೆ ಹೋಗಿ.
ಪ್ರಥಮ ವರ್ತಮಾನ ವರದಿ, ಅಂತಿಮ ತನಿಖಾ ವರದಿ, ಪ್ರಾಯೋಗಿಕ ಪಂಚನಾಮೆ, ಮರು ಪಂಚನಾಮೆ, ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮೆ, ಆರೋಪಿಯ ಹೇಳಿಕೆ ಹಾಗೂ ಮುಂತಾದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಸದರಿ ದಾಖಲೆಗಳು ಮತ್ತು ಪುರಾವೆಗಳು BM ಚಂದ್ರಶೇಖರಯ್ಯ, ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ರವರ ವಿರುದ್ಧದ ಲಂಚಾರೋಪವು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿರುವುದಾಗಿ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಸದರಿ ಆರೋಪಿ ಅಧಿಕಾರಿಯ ವಿರುದ್ಧ ಇಲಾಖಾ ವಿಚಾರಣೆಯನ್ನು ಆದೇಶಿಸಲು ಮತ್ತು ಅದನ್ನು ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರಿಗೆ ವಹಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಅದರನ್ನು ಈ ಕೆಳಕಂಡ ಆದೇಶ.
What more is required? ಅಷ್ಟೇ.
But according to me, my lord, in the light of, my lord, the decision rendered in Sanjeev Kumar.
No, but then in Sanjeev Kumar's case, the Lokayukta follows it up with the state government, requesting them to send the papers along with the permission to conduct an inquiry. But here they have applied their mind. What more is required?
If this is, my lord, sufficient to hold that, my lord, there is an application of mind by the disciplinary authority.
The petitioner has challenged.
But
The petitioner is challenged.
but only one submission. Lord, your lordship may say, if, Lord, I have been acquitted in the criminal case yesterday.
That you take advantage in whatever manner.
In the inquiry, my lord, I may be.
You take advantage if law permits, you take advantage of it. The law permits, you take advantage. Markuli, the petitioner has challenged an order dated 31/5/2013, passed by the respondent number 1. Sorry. Yeah, respondent 1.
On number 2, my lord.
2. Respondent number
Director.
2. Order date bearing number so and so, number so and so dated 31/5/2013, passed by the respondent number 2, entrusting inquiry to the respondent number 3. Under Rule 14A(1) of the KEB Employees CCA Rules 1987. Next para. The petitioner, while in service at the respondent, with the respondent number 2, while in service with the respondent number 2, was accused of demanding illegal gratification. Full stop. The respondent number 3 had handed over a voice recorder and a button camera to the complainant to ascertain the nature of demand. The complainant recorded the demand of the petitioner and thereafter lodged a complaint against him on 22/7/2011. Following this, the respondent number, the Lokaयुcta police, following this, the Lokaयुcta police registered a first information report in crime number 20/2011 for the offences punishable under section 7, 13(1)D, read with section 13(2) of the PC Act on 22/7/2011. Full stop. Trap aita. Petition, the Lokaयुcta police laid a trap which was successful. Full stop. A trap measure was drawn, following which the charge sheet was filed against the petitioner. Full stop. The respondent number 2, respondent number 3 conducted an inquiry and submitted a report to the state government under section 12(3) of the Lokaयुcta Act 1984, recommending initiation of departmental inquiry against the petitioner in respect of the same incident. Full stop. In respect of the aforesaid incident. Full stop. Based on the documents placed before it, and the recommendation, the state government directed the respondent number 1 to conduct to initiate an inquiry and hand it over to the respondent number 3 on 31/5/2013. Full stop. The petitioner is therefore before this court challenging the interestment of the inquiry by the respondent number 2 to the respondent number 3 on 2 grounds, namely, number 1, that the respondent number 2 was not competent to interest the inquiry, and that there was no, and number 2, that there was no application of mind by the respondent number 2 before interesting the inquiry to the respondent number 3, as required under Rule 12(4) of the Act of 1984. Full stop. The learned counsel for the petitioner fairly conceded that the question regarding the competency of the respondent number 2 to interest the inquiry to the respondent number 3 is fully covered by a judgment of a coordinate bench of this court in Writ Petition 2899/2021 and other petitions. He, however, contends that the respondent number 2 did not independently apply its mind to the documents placed before it before deciding to conduct an inquiry and handing it over to the respondent number 3. Full stop. He invited the attention of the court to the order passed by the respondent number 2 entrusting the inquiry to the respondent number 3 and contended that it was and contended that it was handed over to the respondent, it was entrusted to the respondent number 3 on the request made by the respondent number 3. He therefore contends that there was no application of mind by the respondent number 2, and that the respondent number 2 had abdicated its reasoning to the respondent number 3, and therefore the order of entrustment is illegal and deserves to be set at naught. Next paragraph. The learned counsel for the respondent number 2, on the other hand, submitted that the director is competent to decide upon the need to conduct an inquiry and to entrust it to the respondent number 3. He submitted that apart from the coordinate bench of this, apart from the judgment of a coordinate bench of this court in WP number 2899/2021, this court itself, another judgment of a coordinate another judgment of this court in WP number 203068/2019 also dealt with the said aspect and held that the respondent number 2 is competent. Full stop. He therefore contends that the question raised by the respondent petitioner is no longer res integra. Question raised by the petitioner regarding competence of the respondent number 2 is no longer res integra. Full stop. Insofar as the contention that there was no application by the respondent number 2, application of mind by the respondent number 2 before entrusting the inquiry to the respondent number 3, he invited the attention of the court to paragraph number 2. Invited the attention of the court to the order of entrustment and contended that the respondent number 2 had carefully considered the material on record and had rightly come to the conclusion that there was a need to conduct an inquiry against the petitioner, and that the respondent number 3 and then conduct the inquiry petitioner, and that it was prudent to hand over the inquiry to the respondent number 3 as it was in custody of all the materials. Full stop. The learned counsel for the respondent number 3 also reiterated the above contentions. Full stop. I consider the submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 2, 3, and 4. Next paragraph. In view of the fact that the coordinate bench of this court in WP number 2899/2021 and 203068/2019, having held that the respondent number 2 is competent to entrust the inquiry to the respondent number 3, this question need not be again adverted to, need not be again considered. Full stop. Insofar as the contention that there was no application of mind by the respondent number 2 to the report submitted by the respondent number 3 under section 12(3), before concluding that an inquiry is warranted against the petitioner, the following portion of the entrustment order would establish that the respondent number 2 had indeed applied its mind. Copy mode, page 15, red line, red pencil mark. Sorry. In that view of the matter, it cannot be held that the respondent number 2 had not applied its mind before concluding that an inquiry was warranted against the petitioner. Domestic departmental inquiry was warranted against the petitioner. Full stop. Therefore, There is no merit in this petition, and the same is dismissed.
Please.
Stay ಇದೆಯಾ ಇದರಲ್ಲಿ? ಇಲ್ಲ, ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ಏನಾಯ್ತು? What has happened to the inquiry? Still going on.
Lokaयुಕ್ತ is pending.
Huh?
Lokaयुಕ್ತ pending ಅಲ್ಲ, pending. ಇದೆ.
Inquiry is pending. I have.
ಇನ್ನೂ pending,
And he is already retired also.
still pending.
2015 already retired. Because of this.
Inquiries of the year, my lord, 2014-15, my lord, they are expediting now.
No, but still unfortunate, yeah, 2014 matter,
10 years,
huh?
10 years.
10 years have gone by.
There is no.
ಇನ್ನೂ ಎನ್ಕ್ವೈರಿ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
Taking advantage of this petition pending, it is being delayed.
ಇಲ್ಲ, ಅದು ಆಗ್ತಾ ಇದೆ. Inquiry not without reference.
Since the inquiry is already entrusted to the respondent number 4, the respondent number 3 and 4 are directed to expedite the inquiry, which shall not be later than 3 months.
3 months.
From the date of receipt of a copy of this order.
Much obliged.
Please, but in fact, my lord, in fact, my lord, writ petition was allowed in an earlier occasion. Lord, before a day prior to my lord, judgment rendered by my lord the coordinate bench, Justice Nagaprasanna's order. Thereafter, my lord, it was recalled on third, my lord, 23/10/2021. Writ petition was allowed. Lord, my lord's order is on 23/10/2021. 30th allow ಆಗೋಗಿತ್ತು ಒಂದು ವಾರದಲ್ಲಿ. ಅದಾದ್ಮೇಲೆ then it was
Next day only.
very next day, my lord, it is brought to the.
Anyway. Yes, next.
28.
28 N Manohar.
My lord, I am appearing for instead of N Manohar has given NOC for me.
Shashidhar Agali.
Yes, my lord, myself personal. I have personal inconvenience. May I request for.
These matters very rarely, very with great difficulty it is appearing. ಏನೋ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಏನೋ.
I do agree. I could not lay hand on my, on the file. So it was misplaced. So I just need small accommodation up to 15th. 15th gave on the date, if
So this
possible.
matter was listed on 21st.
I do agree.
Now you
I
come
will-
and say that.
I have a very aged mother, 94 years. I'm looking after her. Hardly I got some time to look into this.
ಏನ್
I- Just a week's time or after 10th.
Run counsel for the respondent number
2
2 seeks time as a last chance list on.
after 10th.
Please don't expect lenience in this
No, no.
old matter, sir.
I'm
2013, 14, 15 alive.
okay, much of it.
Number 29, Rimla Joyce.
Appear, my lord.
Here for respondent. Yesterday's matter, my lord.
Yes, what?
My lord, our the defense of the university is, my lord,
I
admittedly, my
don't
lord.
remember the facts. You please refresh my memory. ಏನು ಅಂತ ಹೇಳಿ.
May I
Like
submit?
the pay scale, my lord, yesterday, my lord, my learned friend has argued the matter to VC, my lord.
Revision
According to him, revision of, he seeks for, my lord, the extension of a pay scale on par with the state government. My lord, the university, my lord, while he was appointed in 2012. As per the statute, my lord, whatever the pay scale, my lord, which was fixed for this computer program, my lord, it has been extended to him. And he has accepted it.
Forget accepting it.
Yes, ma'am.
If the order of appointment
Yes.
said that whatever pay scale that was fixed for government employees would be given to the petitioner,
Yes.
then obviously he is entitled to.
ಅಲ್ಲ ಅದು ಕಾಲ ಇಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ 7 ನಲ್ಲಿ ಅಭ್ಯರ್ಥಿಯು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಅಧಿನಿಯಮ 2000 ನಿಯಮ ಹಾಗೂ ಕಾಲಕ್ಕೆ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಸರ್ಕಾರ ಹೊರಡಿಸುವ ಸೇವಾ ನಿಯಮಗಳಿಗೆ ಅಥವಾ ಆದೇಶಕ್ಕೆ ಬದ್ಧರಾಗಿರುತ್ತದೆ. It has been extended.
ಯಾವಾಗ?
It has been extended whenever, my lord, the salary has been increased. But the thing is, my lord, his grievance is when he was appointed initially itself, that was a lesser scale. That was his grievance, my lord. Because as per the statute, your lords may kindly turn to my objections, my lord, I have filed.
ನಿಮ್ದು ಕೊಡಿ C&R rules ಏನಿದೆ ಕೊಡಿ.
ಅಲ್ಲ ಅದನ್ನ ಹಾಕಿದ್ದೀನಿ. Annexure R1 may kindly be seen.
Next,
R1. Page number 5, my lord, is the, along with my objections.
Annexure R1.
This is a statute, my lord, R1 filed by, along with the statement of objections. Page number
Next one,
8.
please wait.
The 9 pages is.
Annexure R1.
ಹೌದು ಅದರಲ್ಲಿ
Ah.
this is a statute, my lord, which has been the creation of non-teaching post in Tumkur University, my lord. Then your lordship may kindly turn to page number 8, my lord. 8 ಅಲ್ಲಿ ಕೆಳಗಡೆ last computer programmer pay scale 6,000 to 11,200, only one post, sanction post, or against which, my lord, he was appointed. This pay scale was then extended to him. And afterwards, my lord, whatever the pay scales which has been increased by the state government, you have been adopting, and it's been extended to him. His grievance is, as on the day, and
Computer operator or programmer?
programmer. Operator alla. Programmer.
Computer operator or programmer?
Programmer.
Programmer.
ಹೌದು programmer ಅನ್ನೇ. First appointment order ಇದೆ programmer ಅಂತ. So ಹಾಗಾಗಿ, my lord, his grievance is, my lord, having accepted this appointment order, my lord, in 2012, for the scale, my lord, which has been fixed by the university as per the statutes, my lord, he cannot now, my lord, turn back and say, my appointment order itself, there is a less salary and I should be given extended.
What does?
And he has also relied on the pay scales of other universities, Sanskrit University and the Rajiv Gandhi University, VT on Lord.
Let us see what the Universities Act says. What does it say?
The Universities Act alli idu
Does not prescribe the pay scales, my lord. It also is from a method of appointment, recruitment method ide. Pay scale matra, there was a committee constituted by the at the instance of Honorable Appellate Court, Muddappa committee inta. Adadmele state government accepted that all the university in the state of Karnataka should carry the state pay scales anta nenne order ಓದಿ ಹೇಳ್ದೆ ನಮಗೆ. Anyway, your lordship.
adu that order was prior to this statute.
Kindly, my lord, yesterday
2005 order adu. He cannot
2005 ಆಗ್ಲಿ.
Yes, Mr. Ranganaj, you can start off again.
That's not better, my lord, because yesterday even almost, your lordship, you can see petitioner was appointed as a computer program as per annexure A, page number 10, my lord.
Yes.
The pay scale that was shown in the order of appointment was 11,400.
11,400.
11,400.
Yes.
Whereas the post of computer program in all the universities in the state of Karnataka, my lord, that was, as on that date, my lord, it was 14,050-25,050. All the computer programs in every university of the Karnataka state carrying a scale of 14,050, 25,050, my lord. That was the pay scale of 2007, my lord. 2007 revision nalli computer program in all the university. That's why I read over yesterday, along with the memo for production of documents at page number filed on 28/11.
Nim recruitment yavaga 2012.
But ಅದಕ್ಕಿಂತ ಮುಂಚೆನೇ ಈ revision ಆಗೋಗಿದೆ. They had not sent the necessary proposal to the government. Kindly, for that, my lord, for comparative study, kindly see the memo. Yesterday I showed your lordship a memo along with the pay scales, my lord, annexure U, along with the memo dated 28/11/2023, my lord. I have filed memos as to various university in the Karnataka. What is the pay scale of computer programmer? Annexure U, my lord, is produced along with the memo. Annexure U.
document copy ಕೊಟ್ಟಿಲ್ಲ ನಮಗೆ.
It was filed on 28/11. It has been heard 3 times, my lord. Kindly see annexure U, my lord. Tumkur University do one kade pay scale 99 pay scale 6,000 11,200. ಅದನ್ನೇ ರಿವೈಸ್ ಮಾಡಿ 11,400 ಮಾಡಿ ಮತ್ತೆ 2012 ಅಲ್ಲಿ 22,800 ಅಂತ ಮಾಡಿದ್ದಾರೆ. Whereas all state government pay scale 99 ಅಲ್ಲಿ 7,000.
This 22,800 ಆಗಿದ್ದು 21/2012. What is your date of appointment?
Kind of appointment is 5/5/2012. Before that only.
Before that only.
Yes. This is retrospectively brought into force, but kindly see the next pay scale, the pay scale unit. Karnataka government alli,
the pay scale was 28,100 in 2012 as on the. Similarly, Karnataka University, Dharwad, 28,000. Visheshwara Technical University, 28,000. ಎಲ್ಲ ಕರ್ನಾಟಕದಲ್ಲಿರೋ ಯೂನಿವರ್ಸಿಟಿ ಇಲ್ಲೆಲ್ಲ ಪೇ ಸ್ಕೇಲ್ ಕಂಪ್ಯೂಟರ್ ಪ್ರೋಗ್ರಾಮ್ ಇದೇ ಇರೋದು. ಹಿಂದೆ ಏನಾಯ್ತು, ಇದೇ ತರ ನಮ್ಮ ಯೂನಿವರ್ಸಿಟಿ ಅವರು ದೇ ಶುಡ್ ಹ್ಯಾವ್ ಫಾರ್ವರ್ಡೆಡ್ ದಿ ಸೇಮ್ ಟು ದ ಗವರ್ಮೆಂಟ್ ವೈಲ್ ರಿವೈಸಿಂಗ್ ದಿ ಪೇ ಅಂಡ್ ಬ್ರಾಟ್ ಇಟ್ ಆನ್ ಫಾರ್ ವಿತ್ ದಿ pay scale of all the university. ಅದನ್ನ ಬೇರೆ ಕಡೆ ಮಾಡಿದ್ದಾರೆ ಮಂಗಳೂರುದು. Kindly come to one order which I read yesterday that your lordship will find that the rejoinder filed by me, my lord. Rejoinder filed on 14/9/2021. I have produced one order, my lord, wherein similarly Kalburgi and Mangalore University, the pay scales were not revised from time to time. Therefore, for the first time in 2005, retrospectively revision of pay scales were made and all the benefits were extended to them. That so far as this university is concerned, it has not forwarded, it has remained the unrevised pay scale of 1999. They have continued like that only, where as I pointed out from the just now read document, because of the failure to revise the earlier pay scale, the later pay scales also going reduced in the reduced way. Whereas in the all other universities, they have revised from time.
You invited the attention of the court to some rejoinder. What is found in the rejoinder?
In the written arguments, my lord, written arguments filed on 19/10/22. Elaborately, all documents are found, my lord. 19/10/2022. Yesterday, I read it from that your lordship may kindly take, my lord.
Yes.
ಇದರೊಳಗೆ ಅನಕ್ಷರ ಎಸ್ ನಾನು ನೆನ್ನೆ ಓದಿದ್ದು ಪೇಜ್ ನಂಬರ್ 55 ಮೇಲೆ. Because this is not the only university. ಬೇರೆ ಯೂನಿವರ್ಸಿಟಿಲಿ ಈ ತರನೇ they had not revised from time to time. ಆವಾಗ ಗವರ್ಮೆಂಟ್ passed an order as per annexure ಎಸ್ ಪೇಜ್ ನಂಬರ್ 55. ಮಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ಮತ್ತು ಗುಲ್ಬರ್ಗಾ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ವಿಜ್ಞಾನ ಉಪಕರಣ ಕೇಂದ್ರ ಮತ್ತು ಕಂಪ್ಯೂಟರ್ ಕೇಂದ್ರಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಬೋಧಕ ಮತ್ತು ತಾಂತ್ರಿಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಕ್ರಮವಾಗಿ ಯುಜಿಸಿ ವೇತನ ಮತ್ತು ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಸ್ತರಿಸುವ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ. ಮೇಲಕ ಓದರಾದ 15/11/96 ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ 1/1/96 ಪೂರ್ವಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಬರುವಂತೆ ಪರಿಷ್ಕೃತ ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಪ್ರಾಧ್ಯಾಪಕರು, ಪ್ರವಾಚಕರು, ಉಪನ್ಯಾಸಕರು ಮತ್ತು ದೈಹಿಕ ಶಿಕ್ಷಣ, ಅದು ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ ಹಾಗೂ ಘಟಕ ಕಾಲೇಜಿನಲ್ಲಿ ಪ್ರಾಂಶುಪಾಲರ ಉಪನ್ಯಾಸಕ್ಕೆ ದೈಹಿಕ ಶಿಕ್ಷಣ ವಿಸ್ತರಿಸಲಾಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ 2, ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಗುಲ್ಬರ್ಗಾ ಮತ್ತು ಮಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ವಿಜ್ಞಾನ ಉಪಕರಣ ಕೇಂದ್ರ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಬೋಧಕ ಮತ್ತು ತಾಂತ್ರಿಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳು ಮತ್ತು ಕಂಪ್ಯೂಟರ್ ಕೇಂದ್ರಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಗಳಿಗೆ 1/1/96 ಯುಜಿಸಿ ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಸ್ತರಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಇವರಿಗೆ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯನ್ನಾದರೂ ವಿಸ್ತರಿಸಬೇಕಾಗಿತ್ತು. ಆದರೆ 93 ಹಾಗೂ 98 ರಾಜ್ಯ ಸರ್ಕಾರದ ವೇತನ ಪರಿಷ್ಕರಣೆಗಳು ಸಹ ಇವರಿಗೆ ಅನ್ವಯವಾಗಿರುವುದಿಲ್ಲ. ಈ ರೀತಿ ಯುಜಿಸಿ ಮತ್ತು ರಾಜ್ಯ ವೇತನ ಪರಿಷ್ಕರಣೆ ಎರಡರಲ್ಲೂ ಇವರಿಗೆ ವೇತನವನ್ನು ನಿಗದಿಪಡಿಸಿಲ್ಲ. ಆದ್ದರಿಂದ ಕಲಬುರ್ಗಾ ವಿಶ್ವವಿದ್ಯಾಲಯ ಮತ್ತು ಮಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ವಿವರವಾದ ಪ್ರಸ್ತಾವನೆಗಳು ಸಲ್ಲಿಸಿ ಅವ್ರ ಯೂನಿವರ್ಸಿಟಿಯವ್ರು ಕಳಿಸಿದ್ರು. ಇವ್ರ ಯೂನಿವರ್ಸಿಟಿ ನಾವು ಕಳಿಸೋದೇ ಇಲ್ಲ ಅಂತಾರೆ. ಆದ್ದರಿಂದ ಗುಲ್ಬರ್ಗಾ ವಿಶ್ವವಿದ್ಯಾಲಯ ಮತ್ತು ಮಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯವು ವಿವರವಾದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿ ವಿಶ್ವವಿದ್ಯಾಲಯದ ವಿಜ್ಞಾನ ಉಪಕರಣ ಕೇಂದ್ರ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಬೋಧಕ, ತಾಂತ್ರಿಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರಿಗೆ ಯುಜಿಸಿ ಪರಿನಿಯಮಗಳ ಪ್ರಕಾರ ಅರ್ಹರಿಗೆ ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ಅರ್ಹದಲ್ಲದವರಿಗೆ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಸ್ತರಿಸುವಂತೆ ಸರ್ಕಾರವನ್ನು ವಿನಂತಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ನೌಕರರು ಮತ್ತು ಅಧಿಕಾರಿಗಳು ಅವರು ಜವಾಬ್ದಾರಿಸಿರುವ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿ ಕರ್ತವ್ಯ ಸ್ವರೂಪ ಮತ್ತು ಜವಾಬ್ದಾರಿ ಇತ್ಯಾದಿಗಳನ್ನು ಗಮನದಲ್ಲಿರಿಸಿಕೊಂಡು ಯುಜಿಸಿ ಮಾರ್ಗಸೂಚಿ ಅನ್ನುವ ಬೋಧಕ ವರ್ಗದ ಹುದ್ದೆಗಳಿಗೆ ಸಮಾನಾಂತರ ಹುದ್ದೆಗಳಿಗೆ ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ಮತ್ತು ಬೋಧಕೇತರ ಹುದ್ದೆಗಳಿಗೆ ಸಮಾನಾಂತರ ಹುದ್ದೆಗಳಿಗೆ ರಾಜ್ಯ ಸರ್ಕಾರದ ಇತರ ಇಲಾಖೆಗಳಲ್ಲಿ ಇರುವಂತೆ ಹುದ್ದೆಗಳಿಗೆ ನೀಡಲಾಗುತ್ತಿರುವಂತೆ ರಾಜ್ಯ ಸರ್ಕಾರದ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ನಿಗದಿಪಡಿಸಿರುವುದು ಸಮಂಜಸವಾಗಿರುತ್ತೆ. ಆದ್ದರಿಂದ ಈ ಆದೇಶ ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಗುಲ್ಬರ್ಗಾ ಮತ್ತು ಮಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ವಿಜ್ಞಾನ ಉಪಕರಣ ಕೇಂದ್ರದಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುವ ಕೆಳಕಂಡ ಬೋಧಕ ವರ್ಗದವರಿಗೆ ಕಂಪ್ಯೂಟರ್ ಕೇಂದ್ರದಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ 96 ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿ ಹುದ್ದೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿರುವಂತೆ ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳನ್ನು ವಿಸ್ತರಿಸಲಾಗಿದೆ. ಯುಜಿಸಿಯ ನಿಯಮದಂತೆ ಬೋಧಕ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಥಿಯ ಸಮಾನ regarding computer people, my lord, your lordship may kindly see the next ಕಂಪ್ಯೂಟರ್ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಯಾರು ಕೆಲಸ ಮಾಡ್ತಾರೋ ಅವರಿಗೆಲ್ಲ ಕಂಪ್ಯೂಟರ್ ಗಣಕ ಕೇಂದ್ರ ಅದರೊಳಗೆ ಕೆಳಗಡೆ ಇದೆ. ಅಲ್ಲಿ ಮೇಲೆ ಹೆಡ್ ಆಫ್ ಕಂಪ್ಯೂಟರ್ ಸೆಂಟರ್ ಅವರಿಗೆಲ್ಲ ರಿವೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಸಿಮಿಲರ್ಲಿ ಮ್ಯಾಂಗ್ಳೂರ್ ಯೂನಿವರ್ಸಿಟಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಪೇಜ್ ನಂಬರ್ 58 ಗಣಕ ಕೇಂದ್ರ ಕಂಪ್ಯೂಟರ್ ಅವ್ರಿಗೆಲ್ಲ ರಿವೈಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ವಾಟ್ ಸಿಮಿಲರ್ ರಿವಿಷನ್ ರಿಕ್ವೈರ್ಸ್ ಟು ಬಿ ಮೇಡ್ ಇನ್ ಕೇಸ್ ಆಫ್
ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಇದೆ, ಕಂಪ್ಯೂಟರ್ ಪ್ರೋಗ್ರಾಮರ್ ಇಲ್ಲ.
ಆಯ್ತು, ಯಾವ್ದೇ ಪೋಸ್ಟ್ ಆದ್ರೂ ಕನ್ಸರ್ನ್ ಪೋಸ್ಟ್ ಕೊಡ್ಬೇಕು.
ಸ್ಟೇಟ್ ಸ್ಕೇಲ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಿರೋದು.
ಕೊಡ್ಬೇಕು ಅಂತ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇದೆ. ಆಮೇಲೆ ಬಿಫೋರ್ ದಟ್ ಮೇಲೆ ಬಿಫೋರ್ ಐ ಕನ್ಕ್ಲೂಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ kindly I have produced with the along with the same the report of the Muddappa committee, annexure N, page number 7 of this written argument. My lord, I have produced 77 nolage. As early as in 77, it was decided by a committee that the employees working in the university have to be extended the pay scales of the state on par with the state government. My lord. Therefore, my lord, taking into this consideration, my lord, all universities in the Karnataka have extended the pay scale of the state government to the concerned employees. Only in this university, they have not recommended to the government, and consequently, government has. Your lordship kindly see page number 44. 44 ಅಲ್ಲಿ ಯಾವ ಯೂನಿವರ್ಸಿಟಿ ಬರುತ್ತೆ ಇದ್ರೊಳಗೆ ಅಂತ, ಅದ್ರೊಳಗೆ ಎಲ್ಲ ಯೂನಿವರ್ಸಿಟಿ, ತುಮಕೂರು ಯೂನಿವರ್ಸಿಟಿನೂ ಬರುತ್ತೆ. ಪೇಜ್ ನಂಬರ್ 44, ಡೀಟೇಲ್ಸ್ ಆಫ್ ದಿ ನಾನ್ ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್ಸ್ ಇನ್ ದಿ ಯೂನಿವರ್ಸಿಟಿ. ಅದ್ರೊಳಗೆ ಮ್ಯಾಂಗಲೂರು ಸೀರಿಯಲ್ ನಂಬರ್ 6, 7 ಗುಲ್ಬರ್ಗ ಅವ್ರಿಬ್ರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದಾರೆ. ನಮ್ದು 15ನೇ ನಂಬರ್ ತುಮಕೂರು ಯೂನಿವರ್ಸಿಟಿ. ಇವರು ಅದೇ ತರ ರೆಕಮೆಂಡೇಶನ್ ಕಳ್ಸಿದ್ರೆ ಮಾಡಿರೋರು. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಸೆಂಡಿಂಗ್ ಇಟ್, ದೇ ಟ್ರೈ ಟು ಡಿಫೆಂಡ್ ಇಟ್ ಅಂಡ್ ಸೇಯಿಂಗ್ ದಟ್ ನೋ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ವಾಟ್ ಎವರ್ ಇಸ್ ಗಿವನ್ ದೇ ಶುಡ್ ಅಕ್ಸೆಪ್ಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ದಟ್ ಇಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 45.
230 ಹೊಟ್ಟೆ ಹಸಿತಿಲ್ವೋ ನಿಮ್ಗೆ?
ಸಾರಿ ಸರ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೋದಲ್ಲ, ನಾವು ಪ್ರಪೋಸಲ್ ಕಳಿಸ್ತೀವಿ ಗೌರ್ಮೆಂಟ್, ನೀವು ಕನ್ಸಿಡರ್ ಬಂದ್ಬಿಡಿ ಆರ್ಡರ್ ಕೊಟ್ಟರೆ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಆ ಪ್ರಪೋಸಲ್ ಕಳಿಸ್ತೀವಿ, ನೀವು ಅದನ್ನ ಕೊಡ್ಬೇಕು. ನಾವು ಕೊಡಕ್ ಬರೋಲ್ಲ. ಹೌದು, ಎಕ್ಸ್ಟೆಂಡ್ ನೀವು ದುಡ್ಡು ಕೊಡ್ಬೇಕಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಡಿಸಿಷನ್. ಹೌದು, ಅದನ್ನೇ ಹೇಳಿದ್ದು, ಹೇಳ್ತೀವಿ ಡಿಸಿಷನ್ ತಗೊಳ್ಳಿ. ಆಮೇಲೆ ನಾನು ಪ್ರಪೋಸಲ್ ಬೇಕಾದ್ರೆ ಕಳಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಸಂಡೇ ಪ್ರಪೋಸಲ್ ಟು ಯು, ನೀವು ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ. ನಾ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇಲ್ಲ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದೆ ಅಷ್ಟೇ. ಈ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್, ಕಂಪ್ಯೂಟರ್ ಪ್ರೋಗ್ರಾಮರ್
ಮತ್ತೆ ವಾಪಸ್ ಬರ್ತದೆ, ವಾಪಸ್ ಬರುತ್ತೆ.
ಹೌದು,
ಆಪರೇಟರ್ ಬೇರೆ, ಪ್ರೋಗ್ರಾಮರ್ is higher than computer operator. Operator you can operate, but program you have to do. There is higher price.
ಎಲ್ರಿ ಏನ್ ನಾವ್ ಇದೇ ನಮ್ಗೇನ್ ಮಾಡ್ಲಿಲ್ಲ, ನೀವೇನ್ ಕಳ್ಸಿಲ್ಲ ಯಾರು?
ಸರ್ ಊಟ ಮಾಡಿ ಬರ್ತೀನಿ.
Serial number 29, Venkat Joyce.
Yes.
My defense of the university is only when his appointment was made, as per a statute, my lord, which has been assented by the chancellor, there is some pay scale, which he has accepted.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟು ಆಮೇಲೆ now, my lord, what they say, my lord, the other universities are extended and those things, my lord. Other universities ಅಂದ್ರೆ, my lord, Sanskrit University, Rajiv Gandhi University, VTU and all, they have their own separate acts. That is not applicable. Only for the state universities, my lord, if it is adopted, my lord, it's applicable. Here what happens is, section, my lord, the provision says, we cannot, my lord, on our own, my lord, vary the pay scales, because this section 29 of the Act, my lord, which has got a power of the syndicate, which says, my lord, I'll just read the, nothing contained in subsection 2 shall be deemed to confer on the syndicate the power to revise the pay scale of any of the employees or to grant any allowances or emoluments to them. So we have absolutely no power. What we can do, maximum what we can do is, based on the representation, my lord, we can propose the thing, we can send it to the state government. And it is for ultimately for the state government to consider, and if they say yes, my lord, then, my lord, we may release, my lord, we can extend.
But this proposal must have been sent by you long back, as is done by other universities.
ಅಲ್ಲ, ಅದರ್ ಯೂನಿವರ್ಸಿಟೀಸ್ ಮಾಡಿರೋದು ಬಿಫೋರ್ ಇಸ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ 2005 ಅದು ಅವ್ರು ರೆಫರ್ ಮಾಡಿರೋದು. ಇದು 2012 ಅಪಾಯಿಂಟ್ ಆಗಿರೋದು. ಹಂಗಾಗಿ ಆಮೇಲೆ ಪ್ರಾಬಬ್ಲಿ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಅಂತ ಕಾಣುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು, ಮೈ ಲಾರ್ಡ್, we will send it to the state government along with the proposals. Let the state government consider and take a decision and pass an order, because ultimately, my lord, the state government has to release the grant, because it's a sanctioned post against which is appointed, and we are governed by the statute, my lord, of the universities, which has been assented. Annexure R1, my lord, I have produced the statute, and time to time, whatever is there, my lord, it has been extended from the pay scale which has been fixed.
Not a dictation that. It's tomorrow for dictation. Yes. Good.
Last door matter, list number 1, serial number 9. Which
Huh? Told. Matru Law Firm, who is this? There is somebody by name Mr. Basuraj Arvo is on record.
And three where we have print the entire and it's original and we have The petitioner was posted to the place at date number 20 on 23/8/2023. Is an employee of KRIDL. But I take charge on 24/8/2023. Improved order is dated 19/8/24.
Neojisi RJC is deputed.
The word used is Neojane. I'm an employee of KRI.
You are an employee of KRIDL.
Yes. Next is P, page number 21, where I take the
No, what is the post to which you are transferred?
executive engineer. I'm an executive engineer. I'm due for retirement.
Karyapalaka Abhyantara Raj. What is your?
Executive.
You are also an executive engineer.
I was posted to the present place on 23/8/2023. I take charge on 24/8/2023 at the present place. Page number 21. Now by improved order at Annexure A, page number 19. In less than 1 year. Respondent
the Rudresh is posted to my place, I am rendered without posting. But I have raised the contention, not one, that it is premature, two, that I am due for retirement, I am rendered without posting. Three, the order is dated 19/8. The transfer period that has come to an end on 31/7. I have produced that order also at page 23.
Transfer period of?
The general transfer period was extended page 23. Was extended up till 31/7/2024. The period during which not general transfer could take place.
No, but this is not a case of transfer. It says Neojane.
Neojane word ಉಪಯೋಗಿಸ್ತಾರೆ, but even otherwise not, I am rendered without posting and due for retirement within 1 year. Next July 2025, I am due for retirement. And my lord, it's a premature transfer.
What about this Rudresh?
Rudresh, not the person who was represented to the caveat, is not before your lord. But I am rendered without posting. Your lord know that any number of times come out of the guidelines.
Basuraj RY, not really. Basuraj RY. There is no representation for the respondent number 2. The learned counsel for the petitioner submits that a copy of the writ petition along with all enclosures were mailed to the email ID of the learned counsel who represented the Kevata respondent number 2. He also submits that the same were also sent via WhatsApp on the telephone number of the said advocate. Full stop. Learned counsel for the petitioner submits that the petitioner was posted, was posted as executive engineer in terms of the order dated 23/8/2020. Before he completed the minimum tenure, the impugned order is passed on 19/8/2024, by which the respondent number 2 is posted in place of the petitioner and no place of posting is shown to the petitioner. Stop. In view of the judgment of the division bench of this court in, which is that SEMA versus State of Karnataka, it is incumbent upon the respondent number 1 to show the posting to the petitioner, more particularly since the petitioner is on the verge of retirement. Consequently, the impugned order posting the respondent number 2 to the place of the petitioner is stayed till the next date of hearing. List on. Yeah. KRIDL here. Huh? What is there? Still what? KRIDL. KRIDL. Sharan BT, Devendrappa, Nataraju. Pura Joshi ilvalla illi. Sharan BT. Mr. Sharan BT is directed to accept notice for respondent number 1. Adadmeli Idvaridi. Yes. List down on date.
21st September. Serial number 23.
Huh? I can grant you time, but pay cost.
My lord, he is dismissed.
Yaro?
Mr. Ramchandrappa is dismissed.
Who is Ramchandrappa?
You are asking me the morning. So that the other accused, that is number 2, who was the
Other employee is dismissed.
yeah, he is dismissed.
Inquiry was conducted against.
Inquiry was conducted and using proceedings. So I have just got the proceedings also.
Sir, are you ready to argue the matter or not? But to learn counsel for the petitioner, do whatever you want, but pay cost. No, sorry, mister, I can't. These are all old matters reflecting on the board since the last. ಇಲ್ಲ argument ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ. If you don't want to argue, I'll impose cost and adjourn. Nothing will come free of cost. Mister, I can't be lenient. ನಾನು lenient ಆಗಿದ್ರೆ ನೀವು misuse ಮಾಡ್ತೀರಿ. No. This matter was listed earlier. It is earlier, huh? Correct, it was listed earlier, not 5/7/2023 it was listed. Again, you are sought for time. Then 12/6/2023 you are sought for time.
Totally,
27/3, registers director to delete the name of Sri Puttegoda and retain the name of Rajesh Shettigar. Learned counsel is appearing, sought for time. You have been seeking for time, mister. How many? You do whatever you want. When do you want it? ತಗೊಳ್ಳಿ ಯಾವ ತರ ತಗೊಳ್ಳಿ pay cost so that you don't ask for time again. Cost ಬೇಡ ಅಂದ್ರೆ then I'll dismiss it. Learn counsel for the petitioner. ನೀವು ಬೆಳಿಗ್ಗೆ ಬಂದಿಲ್ಲ. Learn counsel for the petitioner seeks time. The order sheet discloses that the petitioner has been consistently seeking time. Since this petition is pending since the last 11 years, the request for adjournment is not justified. Nonetheless, as a last chance opportunity is granted, case is adjourned till subject to payment of cost of rupees 5,000. 2,000 payable to the advocates library fund. Yes. This hale matters all ತಗೋಬೇಡ್ರಿ, please. See, I don't want to be labeled as a judge who imposes cost, but you also should not be labeled as a lawyer who doesn't argue. ಹಳೆ matters all at least 2016 ವರ್ಗಾದ್ರೂ argument ಮಾಡಿ, 17, 18, 19, 20, whatever it is. NOC. Yes. ಯಾವತ್ತು ಬೇಕು, ಯಾವತ್ತು ರೆಡಿಯಾಗಿ ಬರ್ತೀರಿ? Ninth. ಯಾವತ್ತಾರ ತಗೊಳ್ಳಿ ರೆಡಿಯಾಗಿ ಬನ್ನಿ ಅಷ್ಟೇ.
List number 2, serial number 5, passed over matter HN Basuraju.
ಅದಕ್ಕೆ list number 2, serial number 5 ತಗೋತಿದ್ರಿ?
For the respondent.
ಇದೆಲ್ಲ ಆಗ್ಲಿ. Yes. Correct, next.
My lord.
Serial number 30. Yes.
Mr. V.S. Naik.
Please, your lordship, I appear for the petitioner. Mr. Naik is not keeping well, your lordship. He is seeking for 1 week's adjournment.
The learned counsel for the petitioner seeks time list on date. Mr. A. Nagarajappa.
Much obliged.
ಯಾವತ್ತೊಂದು ಡೇಟ್ ಕೊಡಿ.
Serial number 31, Nagarajappa A.
Same order. Mr. Anand Rama.
Number 32, Anand Rama K.
B.N. Jagdish. B.N. Jagdish for R1. What does this relate to?
Post of accountant in the respondent number 1 corporation, housing corporation.
What is the issue? What is the issue in what?
The issue was, he was selected in the merit list. He was next to the candidate who got finally selected. That candidate did not report. Then, my lord, I submitted provisional selection list, objection 73. In that, my lord, they said if the selected candidate does not report, then we will operate the wait list, and whoever is next, my lord, the wait list, then we will appoint them. In respect of this court, the person who was selected did not report. That my lord, they are confirmed under the argument. Then I submitted.
You are claiming under any reserved category?
Yes, my lord, 2A.
2A. And the person who did not report?
Was also selected under 2A.
2A.
The very same post of accountant under 2A.
Respondent.
Yes, ma'am.
My lord, let him complete submissions. I'll submit.
You ready?
Yes, ma'am.
Yes, please.
Notification under which the applications were called for. This is group C, Lord, page number 25.
Yes.
Group C, Lord. Under group C, Lordship may kindly turn to Lord, serial number 10, Deputy Garu, the accountant post. Total, Lord, 11 posts of accountants.
Yes.
Totally, Lord, the entire notification covers 114 posts, Lord, in the warehousing corporation. Lordship may kindly turn to page 27. The bottom portion, Lord, last but one paragraph.
Yes.
ಕ್ರಮಸಂಖ್ಯೆ 1ರಿಂದ 10ರವರೆಗಿನ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆ ಮಾಡಲಾಗುವುದು by competitive examination. And on next page, page 28, fourth paragraph.
Yes.
Lord, Karnataka ರಾಜ್ಯ ಉಗ್ರಾಣ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆ ಮೂಲಕ ನೇರ ನೇಮಕಾತಿ ಮತ್ತು ಆಯ್ಕೆ ಸಾಮಾನ್ಯ ನಿಯಮಾವಳಿ 2005 ಮತ್ತು ತಿದ್ದುಪಡಿ 2007 ಅಭ್ಯರ್ಥಿಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಹತೆ ಶೇಕಡ 50 ಅಂಕ ಮತ್ತು ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಗಳಿಸಿದ ಒಟ್ಟು ಶೇಕಡ 50 ಅಂಕಗಳ ಅನುಪಾತದಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಲಾಗಿದೆ. Therefore, as per this rule,
Next, yes.
then I submitted my application under category 2A. That is forthcoming in annexure B below. My application is page 44. About in the middle of the page, annexure category 2A.
Yes.
Also, my kindly turn to annexure F, page 53, the merit list. Merit list, page 54.
54, huh?
Oh, page 53, my lord, is letter 54, my lord. Also, my kindly come to the 5th row. Koteshwara Yankappa Madiwala. He has applied under 2A. 5th row.
Yes.
Claim, my lord, is about his rural AMS. Then, my lord, category claim is 2A. He is the first person in the merit under 2A. Next, we got the last line, serial number 15, Hanuman Badakapanavar. He also claimed 2A. Next to Hanuman Badakapanavar, we got the next page, second row. Govinda Raju, we got is the petitioner. He has also claimed as a 2A. Now, this was a merit list, then the provisional select list was after we got interview and all that, we got selection list.
So this is the provisional list, is it?
This is the merit list.
Merit list.
Merit list.
Provisional merit list, my lord.
Merit list. Then not they published a provisional selection list. Candidates who are selected and called for objection, that is annexure D. The H, not page 78.
Yes.
After the interview. 9/2/2018. Lord, in this, your lordship may kindly turn to page number 89.
Yes.
89, bottom portion, Lord, post number 9, accountant. That is HK. Then, Lord, your lordship, non-Hyderabad, Karnataka. Kindly come to serial number 5. Hanuman Badakapanavar. He is selected under 2A. Then we are Koteshwara Yankappa Madiwala, serial number 9. He is selected under GM. So 2A, Lord Hanuman Badakapanavar got selected. Then for this provisional selection list, objections were filed. Annexure J, Lord, is the reply, Lord, how the objections were dealt with by the corporation. Lord, kindly turn to page number 97. There was an objection with regard to the post of accountant. The objection was that the candidates have not applied for several entities. If you are suppose they do not report, what would be done was the one of the objections that was filed. Page 97, last bottom portion, left hand side, the number 3. Many of the candidates who are shortlisted in the provisional list, they are already selected for other posts. also like ESCOM, AO post, APSC, controller and audit officer post, assistant professor, etc. So many of them maybe will not have been joined here. So please give the reason why you have not announced the waiting list of the candidates. If you announce the same, it will be helpful for other aspirants also. Now, the answer page number 97, right hand side, ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಆಯ್ಕೆಯಾದ ಅಭ್ಯರ್ಥಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳದಿದ್ದಲ್ಲಿ ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಕಾಯ್ದೆಯಿಂದ ಪಟ್ಟಿಯಂತೆ ಕ್ರಮ ವಹಿಸಲಾಗುವುದೆಂದು ಅಭ್ಯರ್ಥಿಗೆ ತಿಳಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ.
So this is in response to this question, is it?
ಹೌದು, this question. Because provisional select list and the publish ಮಾಡಿ, they are called for objections. So this was not one of the objections received for the post of accountant. Then they dealt with the question saying that we will operate the wait list and provide appointment. Next, I also kindly turn to annexure CA. This is the final selection list. Page 116.
Yes.
126 is the relevant portion, post 9 accountant.
Yes.
Post 9, the middle of the page, page 126. Account entry serial number 4, again, Potential Yantappa Madhura, he is selected under GM. Kindly turn over to page 127, page serial number 8. Hanumant Vadakappanova is selected under category 2A. Serial number 8. Immediately after Hanumant Vadakappanova, he is a petitioner and there is no dispute with regard to that fact.
Now, where is your name in the merit list?
Merit list, your lordship may kindly turn to page 55, page 54 and 55. 54 ಅಲ್ಲಿ ಹನುಮಂತ್ ಬಡಕಪ್ಪನವರು is at the bottom portion.
The correct name is, what is your name?
Govindra. Next page is second row. 2A. So in 2A, after Hanuman Padakappanavar, it is Govindra, that is the petitioner. He got 58.04.
Yes, yes.
And Hanuman Padakappanavar got 58.5238. It's a marginally short.
Right.
Then I sought for information at the annexure whether Hanuman Padakappanavar has reported for duty. Page 129. Right hand side, Mahiti, information has been furnished. ಲೆಕ್ಕಿಗಳ ಹುದ್ದೆಗೆ ಆಯ್ಕೆಯಾಗಿದ್ದ ಹನುಮಂತ ಬಡಕಪ್ಪನವರ ಶಿವಲಿಂಗಪ್ಪ so and so application number is mentioned the same application number ಎಂಬುವ ಅಭ್ಯರ್ಥಿ ಕರ್ತವ್ಯಕ್ಕೆ ಕಾರ್ಯವರದಿ ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ. Then I submitted a representation. Annexure 139, page 139, annexure A. This was in fact representation was submitted much earlier to the obtaining of the information. To operate the wait list, and then appoint as per the wait list. This representation was not considered here. Representation is page 139 is the last paragraph. ಈ ಕಾರಣಕ್ಕಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉತ್ತರ ನಿಗಮವು ಹಿಂದೂ ಒಂದರ ಅನುಪಾತದಂತೆ ಆಯ್ಕೆಯಾಗಿ ನೇಮಕವಾಗದೇ ಇರುವ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಈಗಾಗಲೇ ಸುಮಾರು ಸಮಯವನ್ನು ಕೊಟ್ಟು ಕಾಯ್ದೆಗಳಿಗೆ ಅವರೊಂದಿಗೆ ಪತ್ರ ವ್ಯವಹಾರವನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಆದರೆ ಸಾಕಷ್ಟು ಅಭ್ಯರ್ಥಿಗಳು ಈ ಪತ್ರಕ್ಕೆ ಮರಳಿ ಉತ್ತರವನ್ನು ಸೂಚಿಸಿರುವುದಿಲ್ಲ. ಕಾರಣ ಅವರು ಈಗಾಗಲೇ ಬೇರೆ ಇಲಾಖೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಅವರು ಈ ಪತ್ರವನ್ನು ಗಮನಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ಸ್ಪಷ್ಟವಾಗಿ ತಿಳಿದುಕೊಳ್ಳುತ್ತಾರೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉದ್ಯೋಗ ನೇರ ನೇಮಕಾತಿ ಸಮಿತಿಯು ಈಗಾಗಲೇ 1:2 ಅನುಪಾತದಲ್ಲಿ ಹಲವು ಅಭ್ಯರ್ಥಿಗಳ ಮೂಲ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆ ಡಾಕ್ಯುಮೆಂಟ್ ವೆರಿಫಿಕೇಶನ್ ಅನ್ನು ಮಾಡಿರುತ್ತದೆ ಹಾಗೂ ಹಲವು ಆಕ್ಷೇಪಣೆಗಳಿಗೆ ಉತ್ತರಿಸಿದಂತೆ ಕಾಯ್ದೆಯಿಂದ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲು ಒಪ್ಪಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ದಯವಿಟ್ಟು ಹೆಚ್ಚುವರಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಕಾಯ್ದಿರಿಸಿದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಂತೆ ಆದಷ್ಟು ಬೇಗನೆ ಪ್ರಕಟಿಸಲು ಕೋರಿಕೊಳ್ಳುತ್ತೇವೆ. ಏಕೆಂದರೆ ಈ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಈಗಾಗಲೇ 4 ವರ್ಷಗಳಾಗುತ್ತಿದ್ದರೂ ಸಹ ಕಾಲಗತಿಯಲ್ಲಿ ಸಾಗುತ್ತದೆ. ಇದರಿಂದ ಹಲವು ನಿರುದ್ಯೋಗಿಗಳ ವಯೋಮಿತಿ ಮೀರುವ ಆತಂಕದಲ್ಲಿದ್ದಾರೆ ಹಾಗೂ ನಿಗಮದಲ್ಲಿನ ವಿವಿಧ ಹುದ್ದೆಗಳ ಕೊರತೆಯಿಂದಾಗಿ ನಿಗಮಕ್ಕೂ ಸಹ ತೊಂದರೆಯಾಗುತ್ತದೆ. ಆದ್ದರಿಂದ ಶೀಘ್ರವೇ ಕಾಯ್ದಿರಿಸಿದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಂತೆ ಅರ್ಹ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಉದ್ಯೋಗ ದೊರಕಿಸಿಕೊಡುವಂತೆ ತಮ್ಮಲ್ಲಿ ಈ ಮನವಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇವೆ. The petitioner is the Roman number 5 in that representation and last time sign ಮಾಡಿದ್ದಾರೆ ಗೋವಿಂದರಾಜು. This representation was not considered. A writ petition was filed before this honorable court. Should be not grade 141. Writ petition got disposed of by order dated 31st of July 2021. Page 155 annexure Q. So here, my lord, they did not file any objections to this writ petition. My representation was directed to be considered, and an order was directed to be passed. I gave one more representation at annexure R, page 161. Again requesting to operate the wait list and not appoint as per the wait list. Annexure yes, not in the endorsement issued, which is not included the present writ petition.
Yes.
In the present endorsement, page 165 would be the relevant portion. 165 law has considered that the board has taken a decision that insofar as the unreported vacancies are concerned, only not about 44 vacant candidates reported. And the rest 67 vacancies that they have taken a decision to cancel those 67 vacancies and then will not make fresh appointments. This stand was not taken in the earlier request. And earlier request was filed prior to the said order dated 27/7/2020.
Yes.
It is referred to in page 165. Now, here the only ground is that they have taken is that the last paragraph, the obtaining of marks is not in dispute. Last paragraph, ಮೇಲ್ಕಂಡ ಕಾರಣಗಳಿಂದ ದಿನಾಂಕ 29/4/2016 ಅಧಿಸೂಚನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೆಚ್ಚುವರಿ ಪಟ್ಟಿ ಕಾಯ್ದಿರಿಸಿದ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲು ನಿಗಮದ ನೇಮಕಾತಿ ನಿಯಮಾವಳಿಯಲ್ಲಿ ಅವಕಾಶ ಕಲ್ಪಿಸದೇ ಇರುವುದರಿಂದ ಮತ್ತು ಈಗಾಗಲೇ ಸದರಿ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಭರ್ತಿ ಮಾಡಲು ಉದ್ದೇಶಿಸಿದ ಮತ್ತು ಭರ್ತಿಯಾಗದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿ ಹೊಸದಾಗಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಉದ್ದೇಶಿಸಿರುವುದರಿಂದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಚ್ಚುವರಿ ಪಟ್ಟಿ ಅಥವಾ ಕಾಯ್ದಿರಿಸಿದ ಪಟ್ಟಿ ತಯಾರಿಸಲು ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಶ್ರೀ ಗೋವಿಂದರಾಜರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಲಾಗಿದೆ. They said there is no provision in the rules to even prepare a wait list. In the objections, it clearly said they will operate the wait list and then appoint as per the wait list.
Yes.
So, Lord, if I can I will satisfy laws regarding the rules, that there is a provision for preparing and operating the wait list. Even otherwise,
So where are the rules? Where are the rules?
The rules. Kindly turn to page 8.
Page?
Page 8 of the list of the list. This is not the Karnataka State Warehousing Corporation Recruitment and Conditions of Employees Regulations 2005.
Yes.
The rule 17. This rule does not specifically provide the procedure for appointment where competitive examination is contemplated. Rule 17 is applicable to it says all other rules of the government is applicable to the Karnataka State Warehousing Corporation. The provisions of Karnataka Civil Service Rules, Karnataka Civil Service General Recruitment Rules, Karnataka Civil Service Probation Rules, insofar as they are not inconsistent with the provisions of these regulations and apply to the employees of the power. All other rules govern the conditions of service and the matter of seniority, promotion, performance report, time-bound advancement, service and Kannada language examination, advance for education of children of the employee, declaration of assets and liabilities, statement by the employees, or any other appropriate rules and guidelines of the state government and the guidelines laid down by the state government from time to time shall mutatis apply to the employees of the corporation.
It is after recruitment. This will be after recruitment.
Even for the recruitment, they said that the recruitment will be done as per the direct recruitment competitive examination rules. The competitive examination rules, there is no rules of the warehousing corporation with regard to the only competitive examination rules is framed by the government.
Yes.
That your lordship will find at page 31. Karnataka Civil Services Direct Recruitment by Competitive Examination and Selection General Rules 2006.
Yes,
This is also referred to in the notification itself.
yes.
They have referred to this rule, that as per this rules, they will make the recruitment. Now, this 2006 has been subsequently amended. The amended rules will be of 2014, it is at page 37.
Yes.
Page 37. These rules may be called the Karnataka Civil Services Direct Recruitment by Competitive Examination and Selection General Amendment Books 2008. Now, may I take a lot to rule 8, which is amended at page 39. Rule 5 of the amendment rules, which amends rule 8, of the competitive examination. Rule 8, final selection list of candidates. In respect of all group A and B technical and not, that may not be applicable, not there it is group C, not clause 2. In respect of all group C technical and non-technical posts, the commission shall prepare a final selection list of candidates eligible for appointment on the basis of merit, determined on the basis of total percentage of marks secured in the competitive examination, and taking into consideration the reservation policy of the state equal to the number of vacancies notified. Final selection is prepared under sub-rules 1 or 2, which will be published in the Karnataka Gazette, and in such other and in such manner as the state government may direct, and a copy thereof will be sent to the appointing authority themselves. The fact of selection will be intimated to the candidates in the commission. The selection shall be enforced for a period of 1 year in the recruit commission. The pending comes to clause 4. The commission shall also simultaneously prepare an additional list of candidates not included in the main list, not more than 50% in respect of technical posts and 10% in respect of non-technical posts, which may be operated only once to the extent of unreported vacancies, and the same shall be enforced for a period of 1.5 years from the date of its publication.
Yes.
Here subclause 4 clearly provides, since it is a non-technical post, not 10%. The respect of non-technical posts may be operated. They have to prepare a wait list and then operate to the extent of 10% of the vacancies.
Yes.
But there are also government guidelines, how the wait list has to be operated, and prepared and operated. Not 11 April 2003. They refer to the earlier guidelines in this regard.
The one which you referred just now,
Yes.
what is the date of that guidelines?
That's 2015. That is the
2015.
rule itself.
So why you refer to the government notification, government order? The rule itself is clear.
Rule is clear, and here, the guideline says if a person is to a particular category or reserved post has not reported for duty, then a person from the wait list or the reserved category was claimed the very same category can be.
Yes, madam.
Point. One more submission here. Annexure T in 2012, they have not applied the very same rules, prepared the wait list and given appointment.
In which case?
In respect of a technical post of technical assistant, annexure P page 166, very same housing corporation, which contains that as per the rules, they are not obliged to prepare a wait list. Have appointed from the wait list.
What has happened to these posts now?
The 67 posts, they say that there is a board has taken a resolution to cancel those.
Abolish.
Cancel and issue fresh
Cancel
notification.
candidate. Endorsement is very clear, page 165. ಅದರಂತೆ ದಿನಾಂಕ 27/7/2020ರಂದು 67 ಹುದ್ದೆಗಳ ಅಭ್ಯರ್ಥಿ ಧನವನ್ನು ರದ್ದುಪಡಿಸಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ.
Yes.
Now, before that, I have already come before this honorable court.
Is there any interim order now?
Interim order, now there is an interim order, we will keep one for the weekend.
Yes, please.
My lord, one request. I'll try to convince your lordship. If not, then my senior may be permitted to
Oh.
make a submission.
Sir, you argue or you say, yes. You argue.
I'll commence, my lord, but in case, because he's on record. My lord, yes.
The citation which have to be, first citation of Honorable Supreme Court. The Supreme Court said, you know, the weightage has to be high.
Yes.
My lord, their prayer is limited only to this question of the wait list, my lord. And my submission in the objections also I have said that our endorsement is clear that we don't have a provision for it. And the rules that he is relying on, the rule 17 says, insofar as they are not inconsistent with the provision of these rules shall mutatis mutandis apply, my lord. Since we don't even have that provision to apply wait list.
No, but if you have followed that rule in another recruitment for post of non-technical posts, sorry, technical posts, why you can't apply it for these people?
Because now, my lord, these 67 posts have been cancelled, the candidature, and they want to issue a fresh notification is my instruction.
That is okay.
However, and they are relying on this Hanamant Bada, that person who has not, who he says has been selected. However, my instruction is, and I've put it on the objection as well, he has not reported for that vacancy, my lord. So the 2A post had the effect of being cancelled along with those 67 posts.
Okay, but why did you prepare a wait list then?
That is some other matter, my lord. That is not in contention here, my lord.
No, no, wait list is prepared in this case.
In this case, no wait list has been prepared, my lord, not at all. Only that objection has been raised by somebody else, some other candidate, and he's relying on our reply in that. This petitioner has not raised any objection so far.
Is prepared or not?
No, my lord.
Not prepared?
No, my lord. So there is no provision now for us.
Now they say there is no provision, so my.
No, 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 is a wait list prepared or not?
No, no,
They have actually published it or not.
you can put it on record, but there is no wait list in this. With this respect to this notification, we have not prepared any wait list because we went ahead and cancelled those 67 posts. So there is no occasion for that. That is my instruction, my lord. So this is the second time he is litigating on this. And my lord, I have also relied on.
Hey, if they don't want to recruit in respect of all those vacancies which are not reported, all
Yes.
those persons who are not reported, the government can take a call, the respondents can take a call and issue a fresh recruitment notification. What
Yes, my
vested
lord.
right you have?
The vested right, you know, that I am the very next eligible candidate.
Could be.
Who has been selected as per the merit list. And secondly, Lord, the rules upon which they refer.
Then, assuming that there's a wait list, they don't want to operate it. What is your vested right? Assuming there's a wait list, they don't want to operate.
Lord, but they have, Lord, acted on these elections and.
This point of-
No, Lord, there is an, Lord, decision taken to fill up that vacancy.
Yeah.
That one vacancy of category 2A that they have decided to fill up. Once, Lord, they have decided to fill up, that, Lord, will give me, Lord, very eligible candidate the right.
So what is the law on the point?
Lord, that
This point of.
first citation.
Really
Decides to fill up that vacancy.
that is right. Then you get a vested right.
Yes.
The moment you.
But they offered it now the
But
government,
it's-
he did not report,
Okay.
and the margin, the margin was hardly, in. We.
No,
Very,
if it
He
can
did not
apply to you,
report
it
is
can
one
apply
thing,
to
my lord.
others also. If it can apply to you, it can apply to others also. Out of the 67 posts.
In fact, they have, out of the cancelled vote, they have given to another person, not pursuant to orders of this honorable court, not one,
Okay.
Lokesh Patil, they have given, out of those 67 votes.
Without even a merit list or a wait list.
No, my Lokesh Patil was in the list, my lord. I will seek instructions once again on this, Lokesh Patil. But my memory with respect to this is that he was already part of that final list, my lord. Here, Govind Raju is not even part of that. He was only part of the provisional select list. He has not given any objection to any of the other lists after that. He is riding on the objection raised by some other petitioner, and now he is trying to litigate on this, my lord, the second time.
This is a long. Really there. Yes, please.
Kindly come straight, para 2, page 2. Facts are almost identical. The Public Works Department of the State of Jammu and Kashmir conducted a process of selection for recruitment against the post of junior engineer civil grade 2. Satpal, the respondent hearing, participated in the aforesaid process of selection. He was successful in as much as he figured in the final merit select list of scheduled caste candidates prepared at the termination of the selection program. Having learned that some scheduled caste candidate above him in the merit select list had not joined in spite of having been offered appointment, Satpal addressed a representation to the appellants seeking appointment against an available vacancy. In his representation, he mentioned the name of Khan as one of the selected candidates who had been offered appointment but had not joined. In his representation, he also pointed out that in the merit select list pertaining to scheduled caste candidate, his name figured immediately after the name of said Khan. Still not this candidate was not considered. Kindly come to Lord the right hand side. The controversy in hand, yet another expression of denial of legitimate claim of innocence citizen. Rather than appreciating the claim raised by the respondent before the High Court to so and so, to which the appellants failed to even file their response. The same was ordered to be closed when order dated so and so. Thereupon, appellants are to pursue a course which would sideline the main controversy. The course adopted would neither serve their own purpose nor the purpose of the respondents and part. It is not a matter of dispute. The respondents and part participated in the process of selection for recruitment against the post of junior engineers in grade 2. It is also not in dispute that this name figured in the merit select list of scheduled caste candidates. Khan, who had been offered appointment against the post of junior engineers in grade 2 on 22/4/2008 did not join despite the said offer of appointment. The instant fact is fully substantiated from the order dated so and so issued to the chief engineer R&D department journal. Even though candidates who were higher in merit were offered appointment to the post of junior engineer grade 2, for whose recruitment was held, some of the posts remained vacant on account of the fact that persons higher in merit to the respondents and part had declined to join despite having been offered appointment. At least one such vacancy offered to Khan never came to be filled. In such a situation, the claim of the respondents and part whose name figured in the merit select list ought to have been offered appointment against said post. The claim of respondents and part could not have been repudiated, especially on account of his assertion that his name in the merit select list among scheduled caste candidates immediately below the name of Khan was not disputed even in the pleadings before this court. It is not the case of the appellants before this court that any other candidate higher than such part in the merit select list is available out of the scheduled caste candidates and can be offered the post.
Correct, but this judgment is not applicable to you because you're not in the list.
Exactly, my lord. Provisional list, my lord.
You're not there in the provisional select list.
Yes,
Full
sir,
stop.
I was not the select list because Lord Bharatapanavar was above me. In the merit list, I am next to
So
Bharatapanavar.
therefore, the question is, because Bharatapanavar did not report, what is your right?
But my right is to get appointment in his post because he was offered the appointment.
No, my lord, one clarification.
After the recruitment process, Lord, I entered the provisional selection list. The warehousing corporation totally, Lord, abandoned to, or Lord, done away with the decision to fill up the entire post of accountant.
Ye-
Yes.
Or other category 2A for that matter.
Correct, now the respondent has taken a policy decision to invite a fresh recruitment notification or a fresh recruitment in respect of all the posts which are not filled up.
True, Lord. But by that, by the time that decision.
It is not as if they have selected one post, they have given the benefit to a person was in the merit list and that this one was benefit was not given to you. That is not your case. So what is your right?
Not in the merit list, my name finds it.
Not in the provision select list.
Not because Lord Bharatapanavar was selected.
Correct.
So therefore, there was only one post on the
So
category.
therefore, if that man has not reported, what is your right is what I am asking you.
That is.
What is your right?
Comes to operation.
Wait,
Lord, under the rules.
no, they don't want to operate the wait list. They have said we'll invite a fresh notification.
Government guidelines which have produced, that
Yes.
says that wait list shall be operated. Even when the rule says that 10% with regard to the vacancies, the wait list has to be prepared and operated.
Yes.
And they refer to those rules. So therefore, they cannot say that they are not under an obligation to prepare a wait list.
Yes,
at all.
but what is your argument for that?
my lord, one clarification with respect to Hanamant Badapakwanar. This person was not issued an appointment order. Page 3 of my statement of objections. So it is not that he was appointed and then didn't report. In the process itself, we had asked for some documents and he did not provide that. So that's all. That post ceased to operate like that, and therefore went into the 67 posts.
His
Therefore,
contention is, please wait. His contention is that first of all, you must have prepared a list of, what do you call this? Additional list or a additional list of candidates who are not found in the merit list or the final select list. You must have prepared a additional list, is the argument. What is the reply to that?
so in the impugned annex.
ವಿದ್ಯಾರ್ಹತೆಯ ಶೇಕಡ 50 ಅಂಕ ಅಂದ್ರೆ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಇದು ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಮತ್ತು ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಗಳಿಸಿದ ಒಟ್ಟು 50 ಅಂಕಗಳ ಅನುಪಾತದಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಲಾಗುವುದು. So 50% of your examination results and 50% of your competitive examination results will be taken into consideration. ಅಷ್ಟೇ ಹೇಳೋದು. You can't say that. As per the rules ಮಾಡ್ಬೇಕು ಅದು, ಅದರಲ್ಲೇ ಇರೋದು, ಅದೇ ತರ ಮಾಡ್ಬೇಕು ಅಂತ.
For competitive examination, there is no rules of the warehousing part.
Yes.
When they conduct,
Where are these rules?
these rules just now have written,
Hmm.
along with the list of citations and rules.
Hmm.
Page 37. So amended, not page 31, not is 2016. There is one confusion here is not what they say is the Karnataka Rajya Vidyana Sundar name of that is Spardhatmaka Pariksha. Should be actually Karnataka Civil Services in Karnataka. Notification. Appointment. Page 31 not is the rule. It is amended at page 37 in the year 2015.
Please come to page 33, final selection of page 33 of the document.
Yes, that's the Rule 8. That is amended. 2015 amended page 37. Our 2005.
37.
So, page 37. So, 7.4 not in the page 39. Amendment of rule 8. For rule 8 and the entry date is thereafter of the said rule, the following shall be substituted. Otherly, clause 2, in respect of all group C technical and non-technical course. This is a group C non-technical course. So after clause 3, clause 4 only there is a provision for the preparation of petitioners. Now, the very object may not of preparing an additional list is to see that if otherwise eligible, the person who has been appointed does not.
Yes, he has a case. He has a case.
My lord,
Don't have rules regarding competitive. You have to fall back upon the rules framed by the government.
but that is inconsistent with our own rules. We
Yes,
don't have
where's
an
the
option to put a
inconsistency?
wait list as such.
Where-
We are not bound to put a wait list.
Where is the inconsistency is what I am asking you. Does your rule provide for something else?
No, it doesn't have a rule for wait list.
Doesn't even have a rule for selection list also. It only says it should be by direct recruitment, that is all. You don't have a rules at all. So how do you deal with this? You have to fall back upon the rules framed by the government.
My lord, but since it is cancelled, there is no occasion for us now. That is the reason, my lord.
This tomorrow for dictation.
Yes.
ನಾಳೆಗ ಡಿಕ್ಟೇಷನ್ 3 ಇದೆಯಾ ಅದು ಮಂಡೇ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ.
Oblige, my lord.
Thirty-three, Naveen Jain.
Here for respondent minutes. The last date of hearing, I took notice for the respondent minutes.
Learned counsel
Made
for
to
the
receive the
respondent.
wakalat and
1 and 2 seeks time, list on date. Sir Nagarajappa. Interim order is extended till the next date. Well, Nagarajappa adjournment, huh? 30? List this petition along with WP number 23044 of 2001. Call on date put. ಯಾವತ್ತೂ ಒಂದು ಡೇಟ್ ಯಾವ್ದು ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಓಲ್ಡರ್ ಮ್ಯಾಟರ್ಸ್ ಈಗ ತಗೊಳ್ರಿ.
Kalburgi bench matter for order serial number 1. SS Siri.
SS Siri, Mr. Mohammed Abdul Qayyum. Mr. Abdul Qayyum.
Abdul Kaim sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Mr. Abdul Qayyum. There is no representation for the respondent. List on date.
Sir, I am available.
ಏನು ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡ್ರಾ?
We could not get it, sir. We have written a letter, registered for letter, no reply has come from Joint Commissioner.
So what do you want to do?
Company says 1 week, 1 month's time they want.
The learned counsel for the respondent seeks time. List on. Date ಕೊಟ್ಟು. Correct. Second list, final hearing.
List number 2 for final hearing matter. Serial number 3, SH Prashad. Serial number 3.
Vidyulata. Pardon? So please use the mic.
Sir, namaskar.
Synopsis could reporting. ಅದು ಕೈಯೂ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ. It is adjourned.
Much obliged. Thank you.
But the petitioner was working as a district judge in super time scale. 3 disciplinary proceedings were initiated against him. Then, my lords, at the end of the inquiry proceedings, an inquiry report was submitted.
Synopsis.
Hold.
Providing the submission.
Now, it's page 331 is the second show cause notice that was issued.
331.
331, annexure AD.
But does this survive?
It definitely survives. After considering,
what?
because the petitioner is dead. What is challenged is dismissal order. Reinstatement will not be possible, but the LRs will be entitled to all the monetary benefits and wife will be entitled to family pension also. No, my lords, 11/3/2009, this is the second show cause notice. The High Court and the Disciplinary Authority has accepted the report submitted by the inquiring authority. Kindly mark this. Second show cause notice is to be issued to ascertain the objections of the employee against the inquiry report as also conduct of the inquiry. And after considering his objections, a decision has to be taken by the disciplinary authority whether to accept or not to accept the inquiry report.
Yes.
Here, the High Court accepts the inquiry findings, then issues me a notice. This is the first flaw. Charge number 1 so and so stand proved against you. The Honorable High Court has proposed to impose the penalty of dismissal from service against you and directed to issue a show cause notice. Therefore, you are hereby directed to show cause within 15 days from the date of receipt of this notice as to why the penalty of dismissal from service under Rule 8 of the KCS CCA rules should not be imposed against you. Copy of the inquiry report is enclosed herewith. Then, my lords, I reply. My reply is at page 332.
Yes.
There is a forwarded letter. Then the substantive reply commences at page 333. The above stated, because I am reading this because I point out every flaw that has happened in the inquiry. The above stated second show cause notice was served on the DGO on 12/3/2009. By the said notice, the DGO has been informed. The High Court and the Disciplinary Authority has accepted the report submitted by the inquiring authority in DI 1 of 2005, 8 of 2005 and 12 of 2005
holding that charges 1 to 4 in DI 1 of 2005, charges 1 to 5 in DI 8 of 2005, charge 1 in DI 12 of 2005 stands proved against you. The Honorable High Court has proposed to impose the penalty of dismissal from service against you and directed to issue a second show cause notice. He has been on the basis of the above decision of the disciplinary authority holding the DJO guilty, directed to show cause why the proposed penalty of dismissal from service shall not be imposed on him. Time limit of 15 days has been cause directed to be shown by the DJO is on the following question. You are hereby directed to show cause within 15 days from the date of receipt of this notice as to why the penalty of dismissal from service should not be imposed against you. At the outset, DJO respectfully submits that there is absolutely no evidence on the basis of which the inquiring authority could have finding the could have held against the DJO as proved. The findings the IA are vitiated by reliance on materials which is not in evidence. Failure to apply his mind to the totality of the evidence issued as a viewed as a whole, and misdirection of law and facts. In short, it is the case of the DJO that the findings of guilt written against him is untenable apart from the inquiry itself having been vitiated on the grounds mentioned in the objections raised by the DJO from time to time during the course of the inquiry. Proceedings and for the reasons set out in the written brief of the defense case submitted on the conclusion of the inquiry. Fairness requires that DJO ought to have been served a copy of the report and findings of the IA before the disciplinary authority embarked on the exercise to consider the report and findings of the IA. That DJO ought to have been afforded an opportunity to make his submissions on the part of the findings of the inquiring authority, and only thereafter the disciplinary authority could have proceeded to consider the report and findings of IA along with the entire record of the inquiry and the submissions of the DJO against the report and findings of the IA. On consideration of all these materials, the disciplinary authority ought to have recorded its conclusions, whether the charges are proved or not, whether the IAS report comments to be accepted in full or in part or deserved to be rejected. And after such judicial exercise, the disciplinary authority ought to have arrived at and recorded its conclusions on the guilt of the DJO. Para one of the second show cause notice issued to the DJO categorically states that the disciplinary authority has accepted the report submitted by the IA in DI 1 of 2005, 2 of 8 of 12 of 2005, etc. Thus, even without serving a copy of the report and findings of the IA on the DJO, and even before hearing the DJO on what report on the DJO on that report and findings, the disciplinary authority has held the DJO guilty to the extent held by the IA. Thus, the DJO has been guilty without a predecisional hearing on the report and the findings of the IA. This becomes all the more clear when it is noticed that opportunity given to the DJO by the second show cause notice is restricted to proposal to impose the penalty from service, and he is forbidden from saying on the report and findings of the IA. Thus, the mandate of fairness is breached, and the DJO has been held guilty contrary to the principles of natural justice. Law mandates predecisional hearing. In the present case, having regard to the facts and circumstances of the case, prejudice caused to the DJO is apparent and evident. There are at least several judgments of the Supreme Court which have held that post-decisional hearing is no substitute for predecisional hearing. With all humility at his command, the DJO submits that if only he had been given a predecisional hearing, he would have been able to persuade the disciplinary authority that the report and findings of the IA do not deserve to be accepted, and the DJO is entitled to be exonerated. On the basis of the findings of guilt recorded by the DA against the DJO without hearing him on the report and findings of the IA, the DJO respectfully submits that no penalty, much less the proposed penalty, could be imposed on him. There were 3 charge sheets, then one of the rest of the things is on conduct of the inquiry. Now I will take my lords to the conduct of the inquiry, how it has synopsis. Now, if my lord would kindly take the submissions note, I have given a written submissions dated 30th August. This document that is now passed on. Yes.
You are not challenging the inquiry report.
Yes, my lord.
The inquiry report findings you are not attacking.
They are attacked.
Ah,
Now, the first submission I am making is this. After judgment in the Managing Director UCIL versus Karnataka, pre-decisional hearing will have to be there on the findings of the inquiry officer.
yes.
Here what the High Court does is, it accepts the inquiry report, then gives me a notice on proposed penalty. This substitution of post-decisional hearing in place of pre-decisional hearing to which I am entitled has vitiated the order of penalty.
Yes.
May I make a request before? I was under an impression there was an application that was made, my lords, till last time. The submission was they wanted to look into some of the reports of the administrative committee. So I thought it has to be on that first and then on the merits of the matter. So, my lords, if it's on the merits, my lords, I would request it anytime next week, my lords, because I don't have the.
No, but have you obtained any extracts of the administrative committee?
They have not, they have refused to give, in fact.
We have not
earliest of the
refused to give.
kind of
My
allot-
lords, last time
take
also,
page
when this matter was
179.
listed, we have said we will give extracts of the committee reports, my lords. We cannot give photocopies because a part of it will have somebody else report, my lords. We cannot give.
Why don't you furnish the copy?
I
of
can
the
give
extract?
whichever they are.
Let's
I mean,
check.
even this, I made a submission last time also. Whatever they want, I'll give extract, my lords. I will give a true extract, I'll give, and then they can proceed with this matter, my lords. It was like this in the last hearing. This is what was the submission made. If they want, whichever they want, my lords, we are ready to give.
But,
And I would request this honorable court to pass an order to this effect, my lords. Whatever they want, we will give
My
extracts,
lords,
my
in
lords.
the inquiry itself, when these issues arose, I have requested as to what are the proceedings I want.
Yeah, but why don't you look at the report of the administrative committee? How they came to the conclusion that the inquiry report has to be accepted?
That I need not see because.
No, that is
That-
right. What you say
Because
is
the
right.
question is, no reason is furnished in the order.
No, that is only an intimation by the Registrar General. So therefore, please have a look at the report of the committee. What basis they have come to the conclusion that the report has to be accepted?
There is-
Whatever they make available, I will look into.
There is an
All
application
that I have
on
asked is-
16/7/2012 made
What
by.
please. Justice Dattu became a member of the ACN 1, that is Administrative Committee number 1,
Yes.
on 16/8/2005.
Hmm.
And he continued to be a member of ACN 1 till his elevation as Chief Justice of the Chhattisgarh High Court. Similarly, my lord, the second inquiry officer, Justice Banurmat, he became a member of the Administrative Committee number 1 on 1/6/2006. He also succeeded HLDJ as inquiry officer. Then he was a member of the second administrative, the Administrative Committee number 1 until his departure to Kerala High Court as Chief Justice. All that I have asked is, in my submission and also in my IA, is furnish me proceedings of the ACN 1 committee, which have happened from 16/8/2005 onwards, because I do not know in which committee what was discussed.
Yes.
Insofar as it pertains to disciplinary proceedings against the petitioner, from that date until the order of penalty was passed. That, my lords, they filed a serious objections and all that.
I know that they're willing to give, hand it over.
Let them give. I will.
Dispose of that application.
They have asked from 16/8/2005 to 8/10/2010. Your lordships may direct us to produce, give the extract, my lords. And if your lordships also
Extract
direct,
should
we will.
indicate the
Yes, yes.
persons attending the
Yes,
committee.
I have instructed them. And if your lordships wants to, do not believe us, we'll keep the original records in a sealed thing also. I'll give the persons attending.
I am grateful to my lords, after 3 years, at least this much is coming from the High Court.
My lords, even last time I submitted
Yes.
this, my lords.
Stated, but then the court did not pass on.
Yeah.
Earlier to that, your contention was totally different. Your contention was, they are confidential. ಅವ್ರಿಗೆ ಬೇಕಾದ R1, R2, R3 ಹಾಕ್ತಾರೆ.
ಇಲ್ಲ
ನನಗೆ ಬೇಕಾದ ಹಾಕೋದಿಲ್ಲ. Same proceedings.
confidential.
If one meeting is not confidential, other meetings are also not confidential.
Confidential.
They stand on the same footing. One meeting cannot be confidential because something against me has been decided contrary to law.
Where is the application?
16/7/2022 it has been, sorry, 2012 is been.
Slip ಅಲ್ಲೇ ಇರ್ತದೆ.
7/2012.
Yes, please.
Orders on IA 1/22. This application is filed by the petitioners. It's not, sorry, legal heirs of the petitioner. They sought for some information or?
My lords, para 10 is
Proceedings of the Administrative Committee number 1 from 16/8/2005 to 18/10/2010.
Application
Para 10.
filed by the heirs of the petitioner. The order 11, Rule 12 and 14 of the CPC read with Article 226 of the Constitution of India. Seeking for the following particulars, 1 to 10. Full stop. Aforesaid documents are proceedings of the Administrative Committee number 1, which consider the inquiry report.
not the inquiry report. my lords. From time to time, my defense statements also. Because one of the contentions I have raised is,
Which
one learned judge of this court sits in the AC and one and rejects my
which
defense statement. Next day, he sits against me as inquiry officer.
which foresaw
Unheard of.
the inquiry proceedings against the deceased petitioner. Full stop. Deceased petitioner till the committee decided to to impose a penalty of dismissal against the dismissal from service against the deceased petitioner. Full stop. Next, for the learned senior counsel representing the petitioner, heirs of the petitioner, submitted that these documents and information is necessary to establish the process undertaken by the
ACN 1.
by the administrative committee number 1 was prejudicial and affected the petitioner during the course of the inquiry in various ways than one. Full stop. He contends that without these documents, it may not be possible for him to establish the various contentions urged by him in response to the show cause notice, second show cause notice. Full stop. Next para. The learned counsel for the respondents, on the other hand, contended, though objected to this application, has now fairly contended that the proceedings of the administrative committee number 1 contended that the extracts of the proceedings of the administrative committee number 1 concerning the petitioner shall be handed over to the petitioner, to the learned counsel for the petitioner. Full stop. She contends that all these that the extracts of these proceedings, extracts of the proceeding relating to the petitioner would answer all the claims made by the petitioner in the application. Stop. In view of the aforesaid submission.
My lords,
comma,
let it not be my submission.
On the other hand, the learned counsel for the respondents opposed this application contending that the proceedings of the AC1 are all confidential and cannot be parted with, as it would contain the information of various other persons against whom proceedings are initiated. Full stop. He therefore contends that no direction can be issued on this application in favor of the petitioner. Next, I have considered submission of the learned counsel for the petitioner as well as the learned counsel for the respondent. Next, the petitioner has challenged the order of the disciplinary authority imposing a major penalty of dismissal from service. Full stop. The petitioner has raised various contentions in this petition, contending that many of the members of the inquiry,
The inquiry officers had participated in the,
many of the inquiry officers had
both
participated.
there were only two inquiry officers,
The-
both of them
The
had
inquiry
participated.
officers had participated in the proceedings of the administrative.
AC and
committee
one.
They had not, my lords.
Yeah, that is his
All right, I
allegation.
have produced one proceeding,
Yes.
which you have not denied.
Full stop. Therefore, to afford opportunity to the petitioner to examine and establish his contentions, it is appropriate to direct the respondents to furnish an extract of the proceedings of the AC1 committee
In which
From-
matters in
relating
respect
to the
of
petitioner from
from 16/8/2005
from 16/8/2005
till 8th October 2010.
till 8th October 2010. Full stop. Needless to mention that the extract, it is needless to mention
Other, they can, four of the other items
needless
of
to
the,
mention that the respondent shall mask the proceedings of any other candidate, any other person,
any other item of the.
any other person or any other item which is considered by the administrative committee one. This shall be complied within a period of 1 week.
2 weeks.
Huh?
2 weeks, my lords, because there are too many. Some are in the vigilance, some are in different committee.
From AC1 committee meeting, it's available online.
Some of, no, my lords, not all. At the online bed ante ivrige. They want it from the.
And you can select it and give it to them.
Yes, 2
Not
weeks.
online, it is all digitized,
Yes,
not
yes.
online, sorry. It's all digitized.
Not these, my lords. These are in form of books only. I've seen all of them.
AC1 committee.
They are in form of
proceedings are
books
not
only, even,
digitized.
not yet. These are old ones, my lords. 2012, 2000.
In fact, I raised this
Even then,
question.
I think it was digitized.
It is still in, they want it.
I
2 weeks
raised
ago.
this contention before the
It shall be
inquiry
complied
officer
within-
also.
2 weeks ago,
Yes,
within 2 weeks ago.
within 2 weeks. List on
13th September.
13th September.
20th September.
13th ಅಂತ 13th ಆಗುತ್ತಾ?
ಅವ್ರು ನಂಗೆ
It can be listed only on Fridays, that is why. These
Third,
matters can be. listed.
ಅವ್ರು ನಂಗೆ they have taken time to make available the documents to me till 13th now. 2 weeks ಅಂದ್ರೆ. Next Friday, immediate Friday will be
Whichever
20th.
date you, both of you decide, I'll list it on that day,
20th month.
20th September.
great.
Number 4, yes, P. Rajshekar.
See number 4. P. Rajshekar. P. Rajshekar, ಏನಿದು
No. Departmental inquiry was initiated against the petitioner, my lord. Withholding of promotion is the punishment. Withholding of the promotion, my lord.
withholding of promotion.
Yes, my lord.
Yeah, what are the allegations?
The allegation, my lord, that the petitioner found cash in the Almara where, my lord, he was sitting as a Shirestadar in the court. sum of rupees 680 rupees, my lord, contrary to the circular issued by this honorable court. I know the charges were framed. There were two allegations, my lord, that petitioner has received a sum of rupees 100 from an advocate for filing a caveat, my lord. That charge was, my lord, held to be not proved, my lord. On the second charge, my lord, that the petitioner has kept a sum of 680 rupees without any, my lord, basis, my lord. My lord, the inquiry was held, that charge was held to be proved, my lord, the punishment.
What is the reply?
His reply, my lord, that that amount, my lord, was he had brought from the home to give it, my lord, to one Mr. Chandrika, who has purchased clothes to his daughter, my lord. And my lord, that version of the petitioner was not accepted by the, my lord, inquiry officer, as also, my lord, disciplinary authority and the appellate authority. Since, my lord, he has not declared it in the register, my lord, because he has kept it in an almara, hiding it in a file, my lord, that amount. Had it been, my lord, he has brought it from the home for the purpose of purchasing the clothes, my lord, then it would have been with him only in the pocket, my lord. That is the reasoning given by the, my lord, inquiry officer. As also this is accepted by the honorable
Yes,
High Court also in the appeal.
P. Rajshekar. Yen Malaga. There's no representation for the petitioner. Hence list on.
Serial number 5, Jan Basuraju.
Please.
Hearing for petition.
Shivalli.
I'm for the respondent. My lord, this charges are partly proved, my lord.
You ready, Zira? You ready?
One date may be given.
Sir,
Senior
ಎಷ್ಟು
will-
date ಕೊಡೋದಪ್ಪ?
The senior is senior is out of
ನೀವು
station.
ಬೆಳಿಗ್ಗೆ ಯಾಕೆ ಬಂದಿಲ್ಲ ನೀವು?
ಬೆಳಿಗ್ಗೆ ಬೇರೆ
ಹಾ?
ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ನೀವು ಸೀನಿಯರ್ ಇಲ್ಲ ನೀವು ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗಪ್ಪ? ಬೆಳಿಗ್ಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ತಿದ್ರಿ? ಏನ್ ಸರ್?
ಮುಂದಿನ ವಾರಕ್ಕೆ.
Learn counsel for the respondent number 1 and 2 seeks time. ನೀವು ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಡಿ ಅಂತೀರಾ?
ನನಗೆ ಹಾಕ್ಬೇಡಿ.
ಅಲ್ಲಲ್ಲ ನಿಮ್ಗಲ್ಲ ಯಾರಿಗೂ ಹಾಕ್ಬೇಡಿ ಅಂತೀರಾ?
ನನಗೆ ಹಾಕ್ಬೇಡಿ.
ಬಟ್ ಹೌ ಟು ಕಂಪೆಲ್ ನೀವೇ ಹೇಳಿ ಸರ್. ಹೌ ಟು ಕಂಪೆಲ್ ನೀವೇ ಹೇಳಿ. Anyway, ನನಗೇನು ಐ ಆಮ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಡಿಸ್ಪೋಸಿಂಗ್ ಆಫ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್. But record, it's very shameful that, we are still sitting 2012 matters are still pending. 2009 matter ಒಂದು ಇನ್ನ ಪೆಂಡಿಂಗ್ ಇದೆ. ಹೆಂಗೆ ಇದು ಹೌಮನ್ ಇಟ್ಸ್ ನೀವು ನೋಡಿದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಡಿ ಅಂತ ನೀವು ಹೇಳಿ.
I withdraw my words.
And ನಾವು ಲಿಬರಲ್ ಆಗಿದ್ರೆ ಟು ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್. ಸ್ವಲ್ಪ ಟೈಟ್ ಮಾಡಿದ್ರೆ ಟೈಟ್ ಅಂತ.
ಏನ್ ಲಿಬರಲ್ ಆಗಿದ್ರೆ ಹೊರಗಡೆ ಹೊಗಳ್ತೀವಿ. ಇಲ್ದೆ ಹೋದ್ರೆ
ನನಗೇನಬೇಕು ಹೊಗಳಿದ್ರೆ ತೆಗಳಿದ್ರೆ ಹೌ ಡಸ್ ಇಟ್ ಮ್ಯಾಟರ್ ಸರ್? ಅಲ್ಟಿಮೇಟ್ಲಿ ಹಳೆ ದಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಹ್ಯಾವ್ ಟು ಬಿ ಡಿಸ್ಪೋಸ್ಡ್. ನಿಮ್ ಕೇಸೇ ತಗೊಳ್ಳಿ. ದಟ್ ಲೇಡಿ ಶೀಸ್ ಬೀನ್ ವೇಟಿಂಗ್ ಫಾರ್ ದಿಸ್
2014 10
years ಇಂದ ಶೀಸ್ ಬೀನ್ ವೇಟಿಂಗ್. ಯಾವ್ದು ಮೊನ್ನೆ it was reported in live law. Some lady withdrew the petition because she couldn't make rounds to the courts. She has filed a memo saying that I can't come repeatedly to the court. Therefore, I'm withdrawing this petition.
It would amount to failure of the system. It's absolutely failure of the system. Failure of the system.
ನೀವು ಕಾಸ್ಟ್ ಹಾಕಿ ಏನೋ ಮಾಡಿ ಈ ಎಳೆಯೋಣ ಅಂದ್ರೆ ನೀವು ನೋಡಿದ್ರೆ ನೀವು ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಡಿ ಅಂತೀರಾ. It is not to recover the cost, it is only to compel. ಏನೋ ಒಂದು ಬೈಕೊಂಡು ಬಾರಿಸ್ಕೊಂಡು ಮುಗಿಸ್ತಾರೆ ಅಂತ ಅಷ್ಟೇ. List on.
Wednesday melody.
These matters will come up only on Fridays.
ಮುಂದಿನ ಫ್ರೈಡೆ ರಜಾ ಇದೆ.
ಯಾವ ತರ ತಗೊಳ್ಳಿ, whichever date you want.
ಹೇಳ್ತೀರಾ?
MP ಶ್ರೀಕಾಂತ್.
ಹೇಳ್ಬಿಡ್ಲಿ ಅವ್ರಿಗೆ
ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದೀನಿ ನಾನು.
ಅವ್ರು ಹೇಳೋದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ಲಿ ನಾವು
How can he concede? He can't concede.
Insofar as inquiry, my lord, is partly proved, man.
We'll say that charges are proved. Instead of dismissal from service, we'll say compulsory retirement.
The
So that, family pension, other than,
the habitual offender, my lord. Prior to this, my lord, he is,
Mister, why don't you understand? We'll accept the report. We'll say that the charges are proved. But while imposing punishment, instead of dismissal, we'll say compulsory retirement.
left to the court, man.
Oh.
Left to the court.
When the argument ಮಾಡಿ
Left to the court. Left to the court, man.
ನಿಮ್ ಸೀನಿಯರ್ ಹೇಳಿದಾರ ಲೆಫ್ಟ್ ಟು ದ ಕೋರ್ಟ್ ಅಂತ
Please, yes.
ಹೇಳಿದಾರ
ಹೌದು. ಹೇಳಿದಾರೆ.
ಆರ್ ಯು ಶೋರ್?
Yes, my lord.
ಆಯ್ತಂಗೆ ನಾಳೆ ಶುಕ್ರವಾರ
ಸೋಮವಾರಕ್ಕೆ
ಸೋಮವಾರಕ್ಕಿಲ್ಲ ಇದು ಬರೀ ಫ್ರೈಡೇಸ್ ಮಾತ್ರ ಇದು ಬರ್ತದೆ.
ಇದೊಂದು
ಅದೊಂದು ಡೇಟ್ ಕೊಡಿ. ಲಿಸ್ಟ್ ಆನ್ 13th. MP Srikanth.
Kindly have it on next week.
ನೋಡಿ ಸರ್, ರಾಜಗೋಪಾಲ್ ಸರ್ ನೋಡಿ ಅದೇ ರಾಗ.
Some personal inconvenience, that's why he's seeking.
Grant counsel for the petitioner seeks time. List on.
ಬೇರೆ ಕೋರ್ಟ್
ಯಾವ್ದು ಇಲ್ಲ ನೋಡಿ, ಯಾವ್ದು ನಾಟ್ ಇವನ್ ಒನ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್, ನಾಟ್ ಇವನ್ ಒನ್. Yes, seal number 7.
Lords may permit me to appear online. My apologies, my lords, I'm not able to be physically present.
Sorry,
today.
Parinal Allah.
Parinal Allah is my colleague, my lords.
Yes, Vivek Kolla, who appears for the respondents.
Vivek Kolla.
Are you ready?
I'm ready.
Vivek Kolla, ಹಾಕಿದ್ರಾ? Yes, what are the charges?
The charges are essentially to say that the DGO, who was a typist, was aiding the recruitment to the post of typist, and that therefore there was a charge of him aiding in exchange for money. And that seems to be fundamentally what the charge is all about. Cumulatively, there were 4 articles of charge that were made. And of the 4 articles of charge, in fact, if I could take my lords to page number 56, the charges are written down. There are 4 charges. The first one is to say that the DGO had facilitated a mobile discussion, and during the course of the mobile discussion, a sum of money was inquired and sought to be brought for facilitating the job of a typist. This was the first charge. The second charge was to the effect that the DGO, when he was contacted by the investigating officer, he informed that he will try to get a job with an intention that he would demand a bribe for the purpose.
Now, who is this R.S. Patil?
R.S. Patil is the investigating officer. He is also attached to the Vigilance Department, and he is also a witness for the prosecution as PW2. He is R.S. Patil.
So, investigating officer himself is the decoy.
Himself was the decoy. He and a constable were both decoys. In fact, it was more the constable than the inspector himself. And the fourth charge is that there was a mobile phone that was purchased by the DGO and that he had not taken prior permission for the purchasing of mobile phone. And whilst charges number 1, 2, and 4 are held against the DGO, charge number 3 has been dropped against the DGO. The primary submission that I have in this matter, my lords, is that the primary submission I have in this matter, my lords, is that there is violation of rules 11A2 of the CCA rules. Now, I say this by the reading of the judgment of the Honorable Supreme Court in the case of PNB versus Kunj Behar and Mishra. In this particular judgment, my lords, the Supreme Court says that when an inquiry officer has cleared a DGO of all the charges, which is also this case.
No,
In
what
this
does
case
the
also-
inquiry, what does the inquiry report say?
Inquiry report, in fact, discharged. I mean, he found that all the articles of charge were not applicable, except for one, which was regarding the purchase of mobile phone without permission. Inquiry report basically exonerated him fully and said that none of the articles of charge are proved. Fundamentally, my lords, on the premise to say that the person who is said to be the protagonist or the complainant in this case, who was used by the investigating officers as a Trojan, and who was supposedly the witness to the entire discussions with the DGO, was never made a party to the proceedings, was not brought in as a witness, no statements of that person was recorded. And that there was no material to even suggest that such a person even existed. Anta helbiಟ್ಟು the inquiry officer finally held that none of the articles of charge were proved.
Whether there's compliance of Rule 11.
That's my submission, my lords. There was no compliance of Rule 11 in the.
How do you say that? Let us read the order passed with the disciplinary authority.
Please. In fact, if I may request Your Honors to take page number 52. 52.
Yes.
In page number 52, this is a typed copy of the order sheet of the proceedings. And my lords will see that on 19th of August 2010, says the Inquiry Authority and Judge Family Court Bijapur under letter number so-and-so has submitted inquiry report in DE number 4 of 2009, along with records in proceedings 1 to 208. Send copy of the inquiry report to DGO and fix the hearing on 28/8/2010 at 2 p.m.
Yes.
Follows is a further proceeding on 28th August, so less than 10 days later. Says DGO Shri A. Mirji FDA for hearing. DGO is present and has submitted further. He has received a copy of inquiry report. Shri Manoli, Defense Assistant, is present and has produced memo under Xerox copy of book for having permitted mobile phone, heard arguments of the department, Shri Manoli, on behalf of DGO. Separate.
What is this Xerox copy of book for having permitted mobile phone?
I do not have clarity on that particular.
Is it permitted or purchased?
Perhaps purchased.
For having permitted, purchased.
Perhaps.
Yes.
And thereafter, the hearing ensues on the same day, 28th August 2010, and thereafter an order is passed, indicating that charge numbers 1 and 2 framed against DGO approved, and by exercising powers vested in me under section 8 6 of Civil Services Rules, I impose penalty of compulsory retirement on the head parent. And in respect of charge 1 and 2, and censure in respect of charge number 4 on the DGO. Now, the reason I submit that Rule 11 was not followed, Rule 11A, is on the basis of the judgment of the Honorable Supreme Court in the case of Punjab National Bank and others versus Kunj Behari Mishra. And in here, the Honorable Supreme Court, my lord, says that when an inquiry officer has exonerated person to an inquiry, the DGO, and when the disciplinary authority holds a different view, it is imperative that the disciplinary authority should first communicate his reasons for holding a contrary view. And that decision should be communicated in advance to the DGO. And he should be given a fair opportunity to look through those reasons.
Yes.
And then to counter those reasons as to why they are not valid. And the Supreme Court says that when that process has not been followed by the disciplinary authority, then it is violation of principles of natural justice. And therefore the process is flawed and there's violation of Rule 11.
Yes.
11A. So fundamentally, therefore, on this ground alone, the order of the disciplinary authority, in my respectful submission, deserves to be set aside.
Yes, please. 1, 2, 3, not at all good, so is held to be true. Yes. Charge number 1 and 2 framed against is proved by excessive power and now, in respect of charge number 1 and 2,
please,
it is compulsory retirement. And
yes,
in respect of charge number 4, it is censure.
Right.
Yes, Mr.
My lord, I seek for the matter to be heard on Monday, my lord. My seniors held up.
You should have mentioned it then and there itself, Mr. Counsel for the respondent number 1 and 2 seeks time. List on.
Number 8.
Javed Hussain.
No pleasure.
Javed Hussain. Javed Hussain. No representation for the petitioner. List on. Yes.
Number 10. SM. Shiva B. Raya, party in person.
Same order. 11. PH Virupakshaya.
Number 11. Vipakshaya PH.
Same order.
Number 12. Sarvana S.
Yes, Sarvana. Same order.
Serial number 30. Basuraj Sappannavar.
Basuraj.
I am the petitioner.
Basuraj Sappannavar.
Yes.
Yes,
engaged in some other.
Huh?
ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಎಂಗೇಜ್ ಆಗಿದ್ದಾರೆ. I pray.
ನಿಮ್ಮ ಹೆಸರೇನು? The petitioner was present in person, seeks time on the ground that his advocate is otherwise engaged. List on.
Serial number 14. Yes, Ravindra Valla. Balraj JC.
Ravindra Valla. Ready na? Ready na ಹೇಳಿ.
Pertains, my lord. Matter pertains with respect to my lord 247A of my lord the KCSR rules. Where my lord
one bench, division bench, matter
has been pending before the division, my lord. Now Namde matter, in fact, the matter has been pending before this court. And the order passed by my lord, the KIT has been stayed by my lord, this court. The matter pertains very same, my lord.
So you have to await the disposal of.
ಬರ್ತಾ ಇದೆ ಎವ್ರಿ ವೀಕ್ ಬರ್ತಾ ಇದೆ, ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅದ್ರೊಳಗೂ ಇದೀನಿ ಅದಾದ ಕೂಡಲೇ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
The learned counsel for the petitioner and the learned counsel for the respondent number 2 submits that the issues involved in this petition is pending in another proceeding before the division bench.
In writ petition
In
number,
writ
writ petition number 13,427
13,420.
for 2022.
And list after disposal of so and so. Yes.
Public.
Serial number 15, Arvind.
H. Arvind.
Week's time, my lord, next week.
Mr. ನಾನು ಇನ್ನೊಂದ್ಸತಿ ಬಂದಾಗ ನಾನು ರೆಡಿ ಇದ್ರೆ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ ಈಗಲೇ
ಇಲ್ಲ. Today, my lord, I will serve the copy also, the order.
I don't know when matter is listed.
Yes, yes.
It's a case of dismissal from service.
Yes.
ಬೆಳಿಗ್ಗೆಯಿಂದ I am only adjourning the cases. Nobody is willing to argue.
Application it was.
Next time ಬರ್ದ್ರೆ I'll impose cost
I'm sorry,
5,000.
next time I'll be.
Telling you in advance, if you're not ready on the next day, 5,000 rupees cost. The learned counsel for the petitioner seeks time. It's on.
Week after.
Mr. V. N. Madhav Reddy.
16, V.N. Madhav Reddy, petition case plan.
The petitioner, my lord, is challenged.
Ready now?
My lords,
You are
I pray
ready?
for a week's time, my lords. Senior is on legs in quarter number 3, my lords. A week's time may be granted, my lords.
Date may fix it.
Learned counsel for the response 1 to 3 seeks time. List on.
This matter, already, my lord, he is retired, my lord. Short date may be given.
Serial number 70.
Yes, next.
Grateful, my lords.
Raghavendra Gayatri.
In this case, my lords, I find Wakalat, NOC Wakalat, lords.
Other side, yaru Rachana Bharadwaj, KV Narasimhan, Shiva Reddy. Rachana Bharadwaj.
In this case, my lords, annexure V is the order, my lords.
And my name may be deleted. I earlier filed the petition, but
Yes.
Annexure V is the order.
Other side, yaru sir.
Really consideration irodu, a petitioner not filed application for qualifying service as per 224B within 3 years anta. When he joined the service, within 9 months, he filed application, and on the basis of that application, learned district judge forwarded the file, my lords, in the year 1983. The order says that, my lords, I have not filed application as per section 224B.
Illi the order.
Annexure V, my lords.
Annexure V.
ಹೌದು, ink page 65. 66 ಅಲ್ಲಿದೆ.
66 is some notice. Approval of previous services
ಅಲ್ಲ,
qualified.
ಅದೇ. Therefore, service registrar so and so retired assistant registrar of your court is returned herewith to take suitable action in the matter of counting past service ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಎಲ್ಲಿ ಓದ್ತಿದ್ರ ನಂಗೆ ಗೊತ್ತಾಗ್ತದೆ.
Last line.
Annexure V na.
ಹೌದು.
Therefore, the service registrar of Sri K. Krishna Naik, retired assistant registrar, is returned here to take suitable action in the matter of counting of past service of the set officer.
ರಿಟರ್ನ್ ಮಾಡ್ತಾರೆ 224B ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. Your lordship kindly see annexure A, my lords. 17/11/1983.
Annexure V ಓದಿ ಒಂದ್ಸತಿ.
Please.
Registrar, City Civil Court, District Court, Bangalore City, Rural District.
Yes. Approval of previous service as qualifying service for pensionary benefits to Sri Krishna Naik, retired assistant registrar, City Civil Court, Bangalore, as per rule 224B of KCSR. With reference to the above subject, I am directed to inform as under with regard to counting past service of so and so retired assistant registrar, City Civil Court, Bangalore, as qualifying service for pensionary benefits. As per entry in service register, Sri Krishna Naik has entered into government service on 28/10/1976 as against the master in education department and worked in that post till 5/11/1982. The official was selected by the KPSC and appointed as FDC as per order number so and so dated 29/9/82 of the District and Sessions Judge, Bangalore Rural District, Bangalore. He has reported for duty as FDC on the forenoon of 6/11/1982. In this office letter dated 11/11/83, addressed to the Munsif and JMFC Dodballapura, it is stated that as per Rule 252B of the KCSR, the service rendered by the official in the post of teacher in Education Department prior to his appointment in this department as FDC counts for the purpose of pension, leave and increment. Further, it is requested to take action in accordance with the rules. Original of this letter dated 11/11/1983 is pasted in the service register of the official. The official who was holding the post of assistant master in the Education Department in pay scale so and so and pay at so and so was selected and appointed to the post of FDC in the unit of District and Sessions Judge, Bangalore Rural District in pay scale of so and so. Since the minimum pay of the scale of pay of the new post of FDA was higher than his pay in the old post of the assistant teacher, his initial pay in the post of FDA was the minimum pay of the time scale of the post of FDA. As per Rule 41A of KCSR, accordingly, his pay was fixed at so and so in the new post of FDC, which was about the pay of rupees so and so in the old post of assistant master he holds. As such, protection of pay under Rule 41A of KCSR will not entitle the official for any further refixation and consequential benefits. Hence, no further action was required to had been taken on the direction issued in the letter dated so and so in the matter of fixation of pay and increment of the official. The official was working in the unit till 3/12/2007. He was promoted to the post of Chief Administrative Officer and posted to the Court of District and Sessions Judge, Bijapur, and relieved in this unit on the afternoon of 3/12/2007. Further, Rule 224B was inserted into KCSR with effect from 12/5/2006. As per the said rule, notwithstanding anything contained in Rules 219A, 224A, 235, 235A, 235B, 247, 247A, 248, 248A, 248AA, 252B, 416, 417, every employee desires to have the benefit of counting their previous service of additional years as qualifying service for pension, as the case may be under these rules, shall make a request in writing to the appointing authority within 3 years from the date of joining the government service or within the unit of Bangalore Rural District. The official has not submitted any representation to this office for counting his past service as qualifying service for pensionary benefits as per Rule 224B of KCSR. Therefore, the service register of so-and-so, retired as so-and-so of your court is returned herewith to take suitable action in the matter of counting of past service of the said office at your end. Now, Annexure A is the representation, my lords. Annexure A in page 14. In that, my lords, learned district judge, while forwarding my letter, stated subject representation dated 13/10/83 of so-and-so FDC of your court with reference to the your office letter dated so-and-so. On the above subject, I am directed to state that as per Rule 252B of so-and-so, the service rendered by the official in the post of teacher in Education Department prior to his appointment in this department as FDC counts for the purpose of pension, leave and increment. Therefore, I am directed to return here with the service register of the official with request to take action in accordance with the rules. So as per this, my lord, several transactions has been taken place.
Yes,
But they say that, my lords, I have not submitted the letter.
Yes, Nitish.
My lord, please, my lord, now the communication as it was read, my lord, at Annexure V is on the premise, my lord, that there is no such request that had been made.
No,
Now
but how
that's,
did Annexure A get generated then?
my lord, Annexure A, my lord, as I have stated in my statement of objection, my lord, it's only a correspondence that have been made.
No, but then he has made a request on 13/10/83 for counting his past service.
Yes, my
And
lord.
that is accepted and it is forwarded to the concerned court where he was working. If that is so, then his past service has to be counted for the purpose of pension.
But 224B, my lord, came into effect from 12/5/2006.
Correct, it
That is
says
the insertion. Yes, my
he
lord.
must have made an option within
Yes, my
3
lord.
years of the date of he reporting to duty or joining.
Please, my lord.
Now, there is
Please.
something to show that he has
Yes, my
made
lord.
such a request.
Now, Annexure A, please, please, please.
Then he is entitled for the benefit.
Lord, my objection, my lord, at para 7 may kindly be taken note of, and my lord may kindly.
And disposed of. What is the contention?
Lord, the contention is this, that Annexure A to the petitioner is not an order of the appointing authority. It was the information furnished by the then Chief Administrative Officer of the office regarding applicability of Rule 252B of the Karnataka Civil Service Rules as per Annexure A, wherein it was informed that the service rendered by the official in the post of teacher in education department prior to his appointment in this department as first division assistant counts for the purpose of pension, leave, and increment as per Rule 252B of the Karnataka Civil Service Rules, and it was requested to take action in accordance with the rules. And hence, this is only a correspondence.
Correct, but you 252B totally kodi.
Please, my lord.
252B kodi. For the purpose of leave and pension and increment.
Yes, ma'am.
His past service has to be counted and if he has given a request then itself.
Yes, ma'am.
He could not have given a request under 224B then.
Please, my
it
lord.
is not in force.
Yes, ma'am. In fact, 224B says within 3 years from the date of joining the government service,
correct,
must make such a request.
224B bandid yavaga.
Adu bandidu 2006, 12/5/2006, my lord. It
He
was.
could not have given, he could not have contemplated this in 1983.
Yes, my lord, please.
Looks like a straight case. Smoking gun.
That's why, my lord, the justification, my lord, we have said.
We'll allow this petition. The petitioner has challenged the correctness. The petitioner sought for writ in the nature of certiorari to quash the order dated 1/12/2016 passed with the respondent number 5. Insofar as it states that the petitioner did not submit any representation to count his past service. The petitioner has also sought for a writ in the nature of mandamus to direct the respondents to pass appropriate orders to count his past service as assistant teacher for the period 28/10/1976 to 5/11/1982 for the purpose of counting the qualifying service to determine the pension, refixation of pension, etc. He is also sought for a mandamus, writ in the nature of mandamus, directing the respondents to refix his pension and DCRG and other retirement benefits after counting his past service and to pay the arrears with interest at 18%. Next paragraph. The petitioner had entered government service as an assistant teacher on 28/10/1976. Issued by the, in terms of an order of appointment, issued by the Deputy Director of Public Instructions, Kolar. He worked as an assistant teacher till 5/11/1982. Thereafter, he was selected by the Public Service Commission in the cadre of First Division Assistant and was appointed in the Judicial Department. At District and Sessions Court, Bengaluru Road District on 29/9/1982. Full stop. The petitioner was posted as a First Division Assistant at Ramnagara Civil Court. Thereafter, as per the order of the Deputy Director of Public Instructions, Kolar, dated 1/11/1982, he was relieved from the post of assistant teacher. The petitioner reported to duty as First Division Assistant at Civil Court Ramnagara on 6/11/1982. Full stop. Soon thereafter, he submitted a representation dated 13/10/1983 to his appointing authority, namely the District and Sessions Judge, Bengaluru Road District, to consider his past service for the purpose of leave, pension and allowance and increment, leave, pension and increment. Full stop. Based on such a request, based on such a request, the District and Sessions Judge, Bengaluru Road District, addressed a communication dated 11/11/1983 to the
17/11 ಆಗ್ಬೇಕು. 17/11 ಇಲ್ಲಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 11/11 ಆಗಿದೆ.
17 ಎಲ್ಲ ಇಲ್ಲೂ annexure A is 11/11 ಅಲ್ಲ.
ಅಲ್ಲ 17/11.
17/11.
ಹೌದು.
ನೀವು ತಪ್ಪು ಮಾಡಿದ್ರಿ.
ಅದೇ ಇಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಂತ.
17/11 ಅಂತ ಮಾಡಿ. Communication dated 17/11/1983 to the Munsif and JMFC Dodlapura. ಅಲ್ಲಿಗೆ ಯಾಕೆ ಹೋಯ್ತು?
ಅಲ್ಲಿನೂ ಇದ್ರು ಸರ್ವಿಸ್ ಅಲ್ಲಿ.
To treat the past service for the purpose of pension, leave and increment for the purpose of Rule 252B of the KCSR rule, KCSR. Full stop. The petitioner contends that after completion of 20 years of service, the petitioner's papers were sent to the Accountant General under Rule 329 of KCSR. Full stop. The respondent number 4, in terms of its letter dated 19/6/2003, had confirmed the counting of the past service of the petitioner. Therefore, the petitioner contends that he was fully eligible for counting his past service from 28/10/1976 to 5/11/1982 for the purpose of fixing pension and other benefits. Full stop. The petitioner contends that he retired from service on 30/6/2012. Full stop. The Registrar City Civil Court, Bengaluru, sent a letter dated 28/5/2012 along with the pension papers to the Registrar of this court to sanction pension and other benefits to the petitioner. Full stop. The respondent number 4 also addressed a letter dated 3/10/2012 to the Registrar General of this court sanctioning pension to the petitioner as his qualifying service was stated as 29 years, 7 months, 25 days. The petitioner, on coming to know about the qualifying service stated above, submitted a representation dated 4/12/2012 to to the respondent number 4 through the proper channel which was forwarded by the Registrar City Civil Court, Bangalore on 5/12/2012 to count the past service of the petitioner for the purpose of calculating the pension and other benefits. Full stop. The petitioner contended in his representation that he was that he had put in 36 years, 8 months and 2 days of service, including the past service as assistant teacher. Full stop. The respondent number 4 addressed a letter dated 7/5/2013 to the respondent number 3, contending that the petitioner must have requested for counting his past service within 3 years from the date of joining the government service or within 3 years from the date of the Rule 224B coming into effect, and that the appointing authority should obtain the approval of the government. Full stop. The respondent number 3 then addressed a letter dated 15/5/2013 to the Principal District Judge, Bangalore Rural District, for further needful action in the matter. However, the Chief Administrative Officer of the District Court of Bangalore Rural District addressed a letter dated 2/7/2013 to the respondent number 3, stating that the petitioner did not submit any representation for counting his past service as qualifying service for pensionary benefits. Full stop. In that regard, the petitioner submitted a representation dated 16/8/2013 to the respondent number 1 and a representation dated 19/8/2013 to the Registrar General of this court. Thereafter, the respondent number 3 sent the file of the petitioner to the respondent number 2 on 21/8/2013 and the representation dated 19/8/2013 was sent by the Registrar General to the respondent number 3 on 30th of August 2013. Full stop. The respondent number 4 again reiterated by letter dated 8/11/2013 and addressed to the respondent number 3 and sought further clarification. Thereafter, the respondent number 2 addressed a letter dated 10/2/2014 to the petitioner seeking for the documents relied upon by the petitioner to claim the benefit of counting the past service. The petitioner then submitted a representation dated 6/1/2014 requesting for counting his past service for the purpose of pension and other benefits. Full stop. This was followed by a letter dated 16/1/2016 to the respondent number 2 seeking for certain additional documents. The respondent number 2 in turn addressed a letter to the respondent number 3 and directed him to examine the proposal to count the past service of the petitioner and to take immediate action in that regard. Since there was no steps taken on the representation, the petitioner submitted another representation dated 26/2/2016, enclosing therewith an order dated 17/11/1983 and 29/3/2024 referred supra to the respondent number 1. Full stop. The respondent number 3 then sent a letter dated 4/5/2016 to the principal district and sessions judge. Full stop. In the meanwhile, the chief administrator addressed a letter dated 1/12/2016 to the registrar, to the respondent number 3, stating that the petitioner had not submitted any representation to, and therefore the petitioner's request for counting the past service cannot be considered. Full stop. Being agreed with the said letter, so far as it related to the claim of the Chief Administrative Officer that the petitioner did not submit any representation to count his past service, this petition is filed. Next part. The learned counsel for the petitioner contended that after the petitioner reported to duty, he submitted a representation dated 14/10/1983. 14 ಅಂತ ಇದೆ ಇಲ್ಲಿ. ನೀವೇನೋ ಟೈಪ್ ಮಾಡಿ ಇಲ್ಲಿ ನೋಡಿ.
Annexure A ಯಲ್ಲಿದೆ.
13/10/1983. Following which the Munsif and JMFC Dolblapur addressed a letter dated 14/10/1983 to the district and sessions judge. Full stop. As a follow-up, the district and sessions judge in terms of his letter dated 17/11/1983, forwarded 1983 addressed to the Munsif and JMFC. Informed him that the service put in by the service rendered by the petitioner in the post of teacher at the education department prior to his appointment in the judicial department as FDC is counted for the purpose of pension, leave and increment. He therefore contends that the petitioner had indeed within 3 years from the date of his appointment made a request to count his past service. He therefore contends that the impugned letter is without reference to the submission made by the petitioner and therefore seeks for a direction to quash the order of the Chief Administrative Officer and to direct the respondents to pass appropriate orders to count his past service and to pay and to refix his pension and DCRG and other retirement benefits. Next, learned counsel for the petitioner reiterated the above, learned counsel for the respondent has filed a detailed statement of objections contending inter alia that
Rule 224B is notwithstanding 252B, my lord. That is my content.
Contending that the letter dated 17/11/1982 was submitted to claim the benefit under Rule 252B of the KCSR rules and not the benefit of Rule 224B. Full stop. He submitted, it is contended that both these provisions were exclusive and had to be complied by the petitioner to claim the past service. Full stop. The learned respondent reiterated the above contention and claimed that the compliance of Rule 252B is not sufficient to claim the benefit of Rule 224B of the KCSR rules. Next para. I consider submissions.
As far as that communication at Annexure A is concerned, that's only an information and an interdepartmental correspondence.
He also submits that the letter dated 17/11/1983, which the petitioner claims to be an information to count his past service, is an interdepartmental communication which does not confer any right on the petitioner.
As it is not an order of the appointing authority.
As it is not an order of the appointing authority. Next, but I consider submissions made by the learned counsel for the petitioner as well as the learned counsel for the next para. Rule 250, next para. It is not in dispute that the petitioner had entered the service as first division clerk assistant on 6/11/1982. Full stop. After reporting to duty, comma, after reporting to duty, in 252B, you know. What is, please read 252B.
Resignation of an appointment.
That is different. Oh, I peaceful. The petitioner who was earlier employed with the education department as an assistant teacher till 5/11/1982, comma, submitted a request in compliance with Rule 252B of the KCSR, which reads as follows. I have a copy of it. Therefore, comma, full stop. This request of the petitioner under Rule 252B was considered and his past service was counted as per the letter dated 17/11/1983 issued by the District and Sessions Judge, Bangalore, for the purpose of pension, leave and increment. Full stop. Rule 224B, comma, was introduced by notification dated 8/5/2006 with effect from 12/5/2006 and provided as follows. Copy marked. Full stop. The petitioner retired from service on 30/6/2012. Full stop. When once, comma, the case of the petitioner was considered and the benefit of Rule 252B was granted to the petitioner, comma, it is invariable that his past service had to be counted for the purpose of pension and other benefits, as the employer has treated his earlier service as the employer has treated the past service without treating it as a resignation from public service. Full stop. Therefore, comma, the impugned order passed by the respondent, by the chief respondent number dated 1/12/2016, stating that the petitioner had not submitted any representation to count his past service, is not only improper, but is without reference to the earlier letter dated 17/11/1983 addressed by the Principal District and Sessions Judge, Bangalore Rural District. Full stop. In that view of the matter, comma, the petitioner is entitled to succeed. Consequently, this petition is allowed. The letter dated 16/12/2016, sorry, 1/12/2016, addressed by the respondent number 5 to the respondent number 3, insofar as it relates to holding that the petitioner did not submit a request to consider his past service as prescribed under 224B is set aside and set aside, full stop. Consequently, the respondents 3, 4, and 5 are directed to process the papers of the petitioner for fixation of pension by consider and grant all consequential benefits in accordance with law. This will be complied within a period of 3 months from the date of receipt of a copy of this order. Please.
Great.
Kitchen Basuraj.
Petitioner, seek for a short adjournment. Senior is engaged in.
Yeah, this time I'll grant adjournment, next time.
Yes.
Learn counsel for the petitioner seeks time list on date.
My lords, one more matter, similar matter was adjourned to 13. Hence this matter, if your lordship is convenient. Same day.
Then you will say, I'll argue that, I'll not argue this.
No, ma'am, on the same day. Almost similar matters.
List on so ಅದೇ ಕೊಡಿ ಯಾವತ್ ಬೇಕು. ಪರಶುರಾಮ್.
Grateful.
Lordship, appear for the respondent number 3 in this matter. This is a matter wherein the question is as to whether the appointment of the petitioners amounts to a transfer or it amounts to a promotion. Pleadings are complete in this matter. It has to be finally heard, Your Lordship.
Whom do you represent?
I appear for respondent number 3.
Respondent number?
Respondent number 3.
3. Parashuram. Yale Parashuram.
Only difficulty, Your Lordship, is
list on date.
only difficulty is this matter has been listed for quite some time, but the petitioner
You
counsel.
see the list, there's so many older matters, yes.
Please, please. Very short point for consideration, Your Lordship.
Yes. Yes. Career, ಯಾವ್ದೋ date ಕೊಡಿ, yes.
I'm grateful.
Number 35.
Srinivasa.
First case. Case of substaff not in the respondent bank
Muttarna.
who was illegally terminated from service.
The Muttarna, TP Muttarna. ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ರಿ ಯಾರು
Short date. Any short date because without employment for the last 2 years.
My serial number 46 in serial list number 1.
ಹೇಳ್ತಿದಾರೆ ತಾನೆ. He's saying something, no? You can wait for him. You can wait for him to complete.
Matter was not in fact heard twice not by the previous bench. Matter was about to be disposed, my lord. We have filed a counter affidavit and affidavit.
ಆಯ್ತು ಯಾವತ್ ಬೇಕು ತಗೊಳ್ಳಿ.
Date convenient to this.
ಕೊಡ್ರಿ ಯಾವ್ದು. ಕೊಡಿ ಎಲ್ಲ.
My lordship, serial number 46, list number 1, repeat it tomorrow, sorry.
Tomorrow?
Yes, sir. ನಮ್ಮ senior colleague morning ಇಂದ ಇಲ್ಲೇ ಕಾಯ್ತಾ ಇದ್ದೀನಿ.
38 on Monday, ma'am.
ಕೊಡ್ತಾರೆ date.
38.
Serial number 36.
46.
4 weeks time.
10 days.
36. So.
Sir, serial number call.
13th, 12th, 13th.
Serial number 46.
36, sir. Srinivas K, 36, ಇಲ್ಲ. Chetan DC. 2 weeks, sir. 2 weeks, sir. Next week, 2 weeks ಅಂದ್ಬಿಡೋಣ. Entry ಮಾಡಿದ್ಯಾ ಅವ್ರಲ್ಲಿ? ಗೊತ್ತಿಲ್ಲ. Okay, ಏನಂತೆ? 2 weeks. 37, ಅವರೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. 37. ಇಲ್ಲ ಹೇಳಿ. ನೀವು ಯಾರು ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ನೀವ್ ಹೇಳ್ಬೇಕು. ಯಾವ್ದು ಬೇಡವಾ? 2 weeks ಹಾಕಿ ಸರ್. ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟು ನನಗೆ ಕಷ್ಟ ಆಗ್ತದೆ. 38.
38 urgent ಇದೆ.
ಹಾ.
Next Monday or Tuesday, Thursday.
ಆ ವಾರ ಎಲ್ಲ full busy.
ನಾನು
ಇಲ್ಲ ಇಲ್ಲ ನಿಮ್ಗೆ ಬೇಕಾದ್ರೆ ನಾನು ಬೋರ್ಡ್ ತೋರಿಸ್ತೀನಿ 2, 3, 4.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಆಯ್ತು.
ಸರ್ ಅಲ್ಲಿಂದ 10 days ಆಯ್ತು ಅವ್ರು ತಗೊಳ್ಳೋ ಡೇಟ್. 10 days ಆಯ್ತಲ್ಲ.
Serial number 46.
Sir, serial number